Good morning, everybody. Happy Monday. Hope everybody had a great weekend. And we are continuing with the Casey Anthony trial. We are up to day 25, I believe it is. And we are really finishing this up. Hopefully this week will be the last. So we'll try to finish it up. We'll start with day 25 today. And let's get rolling with it.
Something we got to do. I have a You may be seated. Okay, let the record reflect that the defendant is present along with counsel for the defendant, Assistant State Attorney. Mr. Baez, you ready to proceed?
Yes, sir, we are. Good morning.
Good morning. Just remember what I told both sides. There's something we got to do either before this week is out. Approach the side, but I don't need the court report.
Already starting off with a little feisty.
Okay, who will be the defense's first witness?
Our first witness will be Maureen Bottrell.
Okay, let's return to jury. Good morning, ladies and gentlemen of the jury. Did you heed all of my previous admonitions? Okay, does the state recognize the presence of the jury? And does the defense?
Yes, sir, we do.
Okay, Mr. Baez, you may call your first witness, sir.
Your Honor, the defense calls Maureen Bottrell.
I'm Maureen Bottrell. Last name is B as in boy, O-T-T-R-E-L-L.
May I please support?
You may proceed.
Thank you, Your Honor. Mr. Ashton. Good morning, ladies and gentlemen. Good morning, Ms. Bottrell.
Good morning.
Can you introduce yourself to the jury and tell them what your occupation is?
I am a geologist forensic examiner with the FBI laboratory in the Trace Evidence Unit.
And how long have you worked for the FBI?
I've worked for the FBI for 16 years now.
And has it always been in this position?
It has.
And can you give us your educational background?
I have a bachelor's of science in geology and a master's of science also in geology, both from the University of Georgia. I've taken numerous training courses in various types of instrumentation and also in the analysis of particular types of materials. I've also participated in various continuing education programs since I've been employed with the FBI.
And the actual title that you hold is what exactly?
Geologist forensic examiner.
Okay. And have you taken any additional courses in geology and as a forensic scientist in geology?
I have taken additional courses specifically in the analysis of soil materials and also in using particular analytical techniques for the analysis of soils.
And in addition to that, have you lectured or given any types of training on the topic?
I have lectured numerous times and given several training courses, both in forensic geology for other people and also in the use of particular types of instrumentation.
Have you published any work on the topic?
I have. My most recent article was a review article for glass analysis.
Okay. So, if I understand you correctly, your specialty doesn't only deal with soil and minerals, it also deals with glass as well?
That's correct. As a geologist forensic examiner, my main duties are the analysis of geologic materials like soils, rocks, minerals, gemstones, and those things that we make out of them that are very like artificial rocks. So things like glass and building materials like cements.
And have you testified as an expert witness in the area of geology?
I have.
Where and how many times?
I have testified approximately 40 times, and it has been in various locations, both in federal and state courts, including here in the state of Florida.
Your Honor, at this time, I would move to have Ms. Bottrell entered as an expert witness in the area of geology.
No objection. Ladies and gentlemen of the jury, the witness will be accepted as an expert witness in the area of geology. You may proceed.
Thank you, sir. How did you get involved in this case initially?
I received evidence in this case as part of the regular analytical process at our laboratory. The evidence was sent in. We determined that geologic examination might be useful, and so it was sent on to me.
Okay. And why does the FBI have a geologist on staff?
Well, for geologic examination, what we're typically doing for forensic purposes is a comparison analysis. Could two or more materials have come from the same source? So is the soil that I'm finding on one thing, could it have come from this known source that we're looking at? So the example I usually give is if a burglary took place and somebody walked across a lawn, I might get their shoes to see if they had soil from that lawn that was the same, in which case we can't eliminate that as being a possible location. The other types of analysis that we do are provenance studies, which they will send in materials to us, and we will try and tell you where they came from. So I might get a soil, and they might want to know where on the state or the country this could possibly have come from, and we'll do a geologic analysis to try and pinpoint the location. The other types of analysis that we do are when we get materials and they don't know what they are, we'll try and determine what they are and report back on what we found.
And how is this done?
This is done with standard geologic analysis that is used by geologists all over. We start out by looking at some of the more obvious things with the materials that we get. First of all, we'll look and see if the object that has been sent into us actually has anything on it that we can compare. So if we get a pair of shoes and there's no soil on them, our examination is complete. But if there's soil or something else like that on there, we will collect it up, and then we'll start doing the analysis. So we start with the obvious things. What is the color of the soil? What is the texture of the soil? If we're doing a comparison, if we're looking at two different colors of soil, well, they couldn't have originated from the same source, and our examination will stop at that point. If they're the same, then it'll go on, and we'll start looking at some of the more detailed textural features. Not only just things like whether or not the samples have the same grain size. Am I looking at sand compared to gravel? Again, those would be different in our analysis would stop. But also with microscopic features that we might see, like how rounded are the individual sand grains that we're seeing? Do they contain inclusions of unusual materials? Things like that. We're doing that sort of comparison. The final step in our analysis is going to be the determination of what minerals we're actually looking at. So what is the actual composition of the soil? If all those things are identical, then they could have come from the same source. And we will report it as being that source cannot be eliminated as a potential source of this material. With provenance, we're looking at different things. We do the same type of analysis with color, texture, and mineralogy, but the aim is to try and figure out where this could have been. So we're looking for any unique type of minerals or sets of minerals that would tell us that this was in a particular location. So that's the type of analysis that we're doing. And usually this is accomplished with light microscopes. We'll use a stereo binocular microscope, which gives us relatively low power, up to about 400x. That's 400 times magnification of the materials. We'll look at it under that. And also with transmitted light microscopes. So we're actually looking with a petrographic microscope, which is a microscope set up with particular optical properties that allows us to identify minerals.
So the instruments that you use are to identify these types of soils are two different types of microscopes, one that transmits different lights and a stereo microscope.
Typically, yes. We do have other instrumentation, but we don't use that rarely
And geological would, yeah.
Yes.
Okay. And did you receive evidence in this case from, I'd like to actually refer you to a report dated March 4th of 2009.
Okay.
If you have that in front of you, that might assist you in being able to answer some of the questions that I'm going to ask you.
I have that report.
Did you receive items from the Pontiac Sunfire vehicle with the Florida tag G63XV, which, Your Honor, for the record, both the state and defense have stipulated that this is Ms. Anthony's vehicle?
I did.
Okay, and what exactly did you receive from the vehicle?
I received debris that had been collected from the trunk and areas in and around the trunk of the car.
Okay. And did you also receive a shovel?
I did.
And, Your Honor, for the record, both the state and defense.
Right. Okay.
And did you receive items from the Anthony home at 4937 Hope Spring Drive, which consisted of shoes?
Yes, I did. I received shoes and also a what was identified to me as being a transport bag.
How many pairs of shoes did you receive? If you can
22 pairs of shoes.
22 pairs. Okay. And did you then receive items of evidence from evidence markers from the location off Suburban Drive where Kaylee Marie Anthony's remains were recovered?
I did.
And can you tell the ladies and gentlemen of the jury what your conclusions were after you examined these and conducted your tests?
Have this moment, counsel.
Yes.
As to the soil samples, there's a stipulation that the soil samples were taken from the scene after the top layers were scraped away.
Is that correct?
Yes, sir.
All right. Thank you.
Plant and other items were taken. I'm sorry, we interrupted you. Can you tell the ladies and gentlemen of the jury what tests you ran and what your results were?
Well, for the material that came from the trunk of the vehicle and for the soil, I was being asked to do a provenance study. Where did these materials come from? And in the car, two of the samples, there was insufficient material for us to actually examine it and do a good provenance study. So those were set aside. With the remaining sample from the trunk of the car, it was a mix of materials, which is not uncommon out of the trunk or floor mats of a car. But because the material was mixed, we were seeing things from multiple different sources. You can't really do a good provenance study because you can't unmix those to tell where each individual component came from. I can't know which ones, which components belong to each location. So those samples were not suitable for provenance study. For the
Let me stop you there. So as it relates to the car, there was nothing that you were able to identify that was able to connect the car to the scene of Suburban Drive.
There's actually no comparison done between the material and the car to the scene.
Okay. Go on. I'm sorry, I didn't mean to interrupt.
No problem. And for the shovel, again, we were asked to do a provenance study. Where did the material from the shovel come from? And that study was underway when the body was found. And so the provenance study was stopped because they were looking for a potential location for where the body was from the material off the soil. And since the body was found, that examination was no longer needed. So that examination was stopped before it was completed.
Is that all you had on that topic, on that item of evidence?
Yes.
Okay, let me ask you this while we're on that topic. Were you ever asked or instructed to go back to try and compare anything from the scene to that specific shovel?
No.
And you can go on with the next example.
And for the shoes, the majority of the shoes either had no geologic material on them. In fact, some of them appeared to be unworn, or the material that was on them was so limited that we couldn't do a comparison. 3 pairs of the shoes had some geologic material on them that we could actually do a comparison. And of those 3 pairs of shoes, the material that we recovered from them is different from the crime scene. So it could not have originated from that location.
So if I understand your results correctly, most of the shoes were clean. They didn't have any soil materials or anything. They appeared to not even have much wear and tear. Is that correct? Some
of them appeared to have been unworn. Some of them had been worn, but there wasn't very much material on them. There were only 3 that had a significant amount of soil that we could actually do a comparison with.
And the only 3 that appeared to be dirty, the soil from there differed from the soil off of Suburban Drive.
That's correct.
Are there any other items or any other exams that you did?
There was also the transport bag that was examined, and there was insufficient material in the transport bag for comparison.
And the reason you test the transport bag is because you...
Can counsel specify which item that goes with? I'm not sure what transport bag
Absolutely.
that is.
The transport bag was the bag that the shoes came in, correct?
That was my understanding, yes.
And the reason that you test the bag is because some of the soil might fall off of the shoes and end up on the bag.
That's correct.
And were you able to have anything from the bag that could assist you in connecting Casey Anthony's shoes to Suburban Drive?
No.
Were there any other examinations that you did?
No, that was it.
For this? Okay. I have no further questions, Judge.
Cross-examination?
Does your examination establish that the 3 pair of shoes you did examine had never been at the location of Suburban Drive?
No, you cannot determine that with a soil comparison.
Explain to the jury why.
There's many things that can happen with soils as well as with shoes as you come in contact with the scene. You can walk across the scene and not have any soil transferred onto the shoes, in which case when we do an examination, I won't see any soil and will not be able to connect you to the scene. You can also walk through the scene and have soil transfer, which then later falls off. Soil easily falls off of shoes, especially if it's a very sandy soil. So you would not, it's not preserved on the shoes. So again, there would be no material that I could actually compare and connect it back with that scene. Or you can walk across an area, you can get soil on your shoes. You can walk someplace else, get more soil on your shoes. And now I'm seeing a mix of multiple materials, and collectively they will not look like the original location. Or alternately, you can have never been there. But of all 4 of those possibilities, I can't tell them apart scientifically. So I can't know which one of those mechanisms is in place. And if I can't tell, then I can't say that they were never there, because one of the other 3 possibilities could have been true, that no soil transferred, or the soil fell off, or the soil became contaminated with other material.
So the absence of soil is meaningless in terms of establishing someone's presence or lack of presence at a particular area.
That's correct.
No further questions.
Redirect?
Ma'am, you're employed by the FBI to look for evidence, are you not?
I'm employed by the FBI as a geologist forensic examiner, yes.
And the purpose of you receiving all of these items was to look for evidence, correct?
That's correct.
Okay. And you did not find any meaningful to connect Casey Anthony to Suburban Drive.
That's correct. I didn't.
And you can only testify about science and actual items of evidence that you actually recovered, correct?
Sustain, rephrase the question.
Yes, sir. Can you testify to anything other than science and items of evidence that you recovered?
No.
And those scenarios that you just testified to for Mr. Ashton, those are all speculation, correct?
Well, those are all possibilities that could happen. And if I were to choose which one was in place in this case, that would be speculating.
Okay. Exactly. And that's not what you're doing here today. You're not speculating.
No, I'm not.
You're only looking at the items of evidence that you searched for, correct?
I'm only looking at the items of evidence that I received and testifying to what I found.
Exactly. And not to any other speculation.
No.
No other question.
Okay, will the witness be excused?
Yeah.
Defense? Thank you, ma'am. You may be excused. The defense may call the next witness.
The defense would call Madeline Montgomery.
Yes.
Another sidebar.
You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Yes.
My name is Madeline Montgomery, Madeline Montgomery.
Good morning. May I please record, Your Honor?
You may proceed.
Thank you, sir. Good morning, Ms. Montgomery.
Good morning.
Can you please introduce yourself to the ladies and gentlemen of the jury and tell them what your occupation is?
Yes, my name is Madeline Montgomery, and I'm a forensic toxicologist with the FBI laboratory in Quantico, Virginia.
And how long have you been employed by the FBI?
I've been employed by the FBI laboratory for 15 years.
And could you share with us your educational background?
Sure. I have a Bachelor of Science degree in chemistry from the George Washington University, which is in Washington, D.C. I've also taken graduate level courses from the George Washington University in forensic chemistry and forensic toxicology.
And have you received any additional training in forensic chemistry?
Yes, I've received training by the FBI as well as by different instrument vendors that we work with in forensic chemistry, and I've taken continuing education in both forensic chemistry and in forensic toxicology.
And what is the difference between toxicology and forensic chemistry?
Forensic chemistry is a very broad subject. It could include anything from arson testing to explosive residue testing to analysis of a sample suspected to be a drug. Forensic toxicology is specifically the study or detection and study of drugs and poisons in people. So I analyze things like blood, urine, hair, and autopsy samples such as liver and brain for the presence of drugs and poisons.
And how are you normally approached to do this? Is it through the FBI or through state agencies or medical examiners' offices? How does the work come to you?
Well, in the work that I do, I would say more than half of the work I do actually supports local and state investigations. We have equipment that not all state and local forensic toxicology labs have, so we have the ability to do more sophisticated testing. So we may get involved for specific requests if a local medical examiner or state forensic lab can't do the analysis. But then we also support FBI investigations all across the U.S.
And have you done any or published any work in the areas of forensic chemistry or toxicology?
Yes, I have.
How many articles or publications have you?
Just guessing, I would say between 10 and 20 peer-reviewed published journal articles.
And do you belong to any professional organizations?
Yes, I am an active member of both the Society of Forensic Toxicologists and the International Association of Forensic Toxicologists. I serve as the secretary of the Young Scientist Committee on the International Association of Forensic Toxicologists, and I serve as the executive secretary on the Scientific Working Group for Forensic Toxicology.
And could you explain to the ladies and gentlemen of the jury what the Scientific Working Group for Forensic Toxicology is?
Sure. Scientific working groups are different groups of professionals that are trying to set the standards for their field. So for our toxicology working group, we're trying to gather all the different types of forensic toxicologists, everyone from the people that do driving under the influence testing to the people that do coroner's work, to try to set standards for the minimum levels of education, the minimum types of quality assurance that are needed in the lab, just to make things equal across the field.
And have you testified as an expert witness in the areas of forensic chemistry and forensic toxicology in the past?
Yes, I have.
How many times and where?
11 times.
And where?
I've testified in numerous state courts, federal court, and in military court.
Judge, at this time, we would ask that the court recognize Ms. Montgomery as an expert witness in the area of forensic chemistry and toxicology.
Objection.
Ladies and gentlemen of the jury, Ms. Montgomery will be accepted as an expert witness in the area of forensic chemistry and toxicology.
Ma'am, I'm going to ask you to refer to your report of March 13th, 2009. Do you recall receiving items of evidence to test?
Yes, I do.
Okay. And what exactly was that, or were those items?
I received a hair sample to test.
And this would be the Q59 hair mass coming from the remains of Kaylee Marie Anthony?
That is correct, yes.
Judge, there's a stipulation between the prosecution and defense that this came from the area of suburban drive.
Your Honor, the item is in evidence, so I don't think stipulation is necessary to your testimony. If we could just refer to a fact evidence number.
Okay, Madam Clerk, what is the evidence, state's evidence number? Okay, you may continue.
Thank you, Your Honor. Now, ma'am, as it relates to evidence item 271, what instruments do you use to test hair?
Well, as far as biological samples go, hair is actually fairly complex. So the first thing we do in the laboratory is we have to, what we're interested in is any chemicals that might be within the hair itself. And that's because chemicals can be incorporated into our hair as it grows. So we need to get to the inside of the hair. So we will physically break apart the hair, in this case with liquid nitrogen, which makes it very cold and very brittle. So it'll break on impact, and we make it into a dust. Then that dust is extracted overnight in a chemical solvent so that any drugs or poisons that we're interested in will be leached into that solvent. Then the next day, we do further purification techniques on that solvent and make what we call an extract. And then that extract is taken along with samples of known blank hair and hair that we've added drug or poison to, which are control samples. Those will all be taken to the instrument that is called a liquid chromatograph mass spectrometer.
Okay. And do you have training on the liquid chromatograph mass spectrometer?
Yes, I do.
Okay. And is your knowledge of utilizing that device extensive?
Yes, it is.
Okay. And tell the ladies and gentlemen of the jury what you tested for.
In this case, I was initially asked if we could test for alprazolam and clonazepam.
And what are those?
Alprazolam, you might know, is commonly known as Xanax. That's one of the prescription names. And clonazepam, you might know as Klonopin. They also have other names and can be sold as generics. But they are from a class of drugs called benzodiazepines. They can be used to help someone sleep, to help calm them down. And they can also be used before surgery, again, to help calm someone down.
Okay. And what were the results for those two drugs?
The testing I did for those drugs was negative in the hair sample.
Now, I know I'm going to butcher the names of these other drugs, but please bear with me. You were also asked to look for a drug, Fluniz. You can help me with the rest.
I can help you. The initial testing that was done was for, as I said, the alprazolam and clonazepam. While this evidence was in the laboratory, we were already validating a new method that included not only alprazolam and clonazepam, but 9 other drugs. And this method was superior to the method we were currently using. So the timing worked out so that while we still had the evidence in-house, I was able to test it again, to look again for the alprazolam and the clonazepam, but this time at much lower levels. And then I looked for 9 other drugs as well, which included 8 drugs in the same class as the alprazolam and clonazepam. They're called benzodiazepines. It would include other benzodiazepines such as diazepam, which is Valium, flunitrazepam, which you may have heard of. The media calls it roofies, or the date rape drug. It's one of the drugs associated with sexual assault. And then a series of other benzodiazepines and their metabolites, or the chemicals that our body breaks them down into. And then the last drug that is in the method that I looked for is called ketamine, which is a veterinary tranquilizer that is also abused in the club scene and used for its hallucinogenic properties.
And can you tell the ladies and gentlemen, this is 1, 2, 3, 4, 5, 6, 7, 8, 9 other drugs. Is that correct?
That's correct. 10 benzodiazepines plus ketamine.
Okay. And can you tell the ladies and gentlemen of the jury what the results were when you searched for those drugs?
My results were all negative.
And can you explain, you mentioned that you had a new technique that was even more sensitive than the one you had previously had. Is that correct?
That's correct.
How much more?
On the order of about 10 or so.
Okay. 10 times more?
10 times more sensitive, yes.
Okay. And were there any other drugs that you tested for?
No.
Okay. And as far as this report is concerned, were you able to, I just want to double check to make sure. As far as this report is concerned, did you test any other items?
No, I did not.
Okay. Now, you can't testify as to anything outside of the results of the test you did. Is that correct?
That's correct.
And you can't guess how much use would be required before these drugs would show up in the hair, can you?
Sustain. Rephrase the question.
You don't know how much exposure a person would have before these results show up, do you?
Overruled.
The thing about hair testing after limited exposure is that even in controlled studies where someone is given a known amount of a specific drug and then their hair is tested, we're not always able to detect the drug in the hair. So the answer is, I don't know. There is no certainty with how much drug someone needs to be given or needs to take before it will show up as positive in their hair.
And you can't speculate as to whether it's 1 time or 20 times before it actually shows up, right?
No, I cannot.
All you can say is, we do these highly sensitive tests, and they're either positive or negative.
Sustain.
All you can say, well, let me rephrase that. Is all you can say that you did these tests, and they came back negative.
That is correct.
I have no further questions, Judge.
Cross-examination.
Good morning.
Good morning.
So in summary, the negative result is forensically meaningless. It doesn't mean the person wasn't given the drug. It doesn't mean they were. It just doesn't mean anything.
It means that I did not find any evidence of the drug having been given, correct?
But it still could have been given and not shown up in the hair.
That is correct. Hair is not the best sample for drug exposure.
So in determining whether someone has been given a drug or not, the negative result really doesn't answer that question.
No, it does not.
And even if it did answer the question, it only tells you historic use of drugs. It doesn't give you chronic use of drugs.
Well, it depends on how the testing is done. If you were to test someone like me with long hair, I could look at the length of the hair to look at different time periods of exposure, and that would indicate if I was positive down the entire length of my hair that I was a chronic user of a certain drug. But in this case, the hair was such that we had to look at it in bulk, meaning we had to look at it as one sample. So even had it been positive, I wouldn't be able to say when or how often the person was exposed.
And if someone were exposed to something and died immediately or very closely, it wouldn't appear in the hair anyway.
That is correct.
And you're not able to test for chloroform, are you?
Not in hair samples, no.
Is there anything about your findings that would have indicated that this child drowned?
I have no expertise in that area.
Nothing further.
Redirect.
Ms. Montgomery, what other kind of meaningless work do you do at the FBI?
I don't feel that any of my work is meaningless.
Okay. And the chloroform that you test, the reason you didn't test for chloroform is that study, that type of analysis is not done by your lab, correct?
We don't look for chloroform in hair samples. We will look for chloroform in liquid biological samples, but not in hair.
And you were made aware that Dr. Goldberger was the one that was doing that, correct?
Hearsay.
Sustain.
Do you have knowledge as to whether that was done by another scientist?
Hearsay.
Sustain.
Your Honor, this is an expert witness who is...
Sustain.
Now, the reason, obviously you testify that certainly your work is not meaningless. The reason that you do tests is to search for evidence, correct?
We do tests to answer questions, yes.
Yes. And in this case, you had a sample, you did the test, and the results came back negative.
That is correct.
No further questions.
Okay, may the witness be excused.
Yes, sir.
Thank you, ma'am. You may be excused.
Thank you.
The defense may call the next witness.
Please raise your hand, please. Solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Thank you, sir.
Michael Sigman, S-I-G-M-A-N.
Dr. Sigmund, how are you employed, sir?
I am a faculty member at the University of Central Florida.
What is your highest level of formal education, sir?
I have a PhD in chemistry.
You currently, in addition to being affiliated with the University of Central Florida, are you affiliated with any other organization?
Yes, sir. I have a joint appointment with the National Center for Forensic Science, which is part of the University of Central Florida.
Where did you get your bachelor's degree, sir?
I received my bachelor's degree in 1982 from Southwest Missouri State University.
And your PhD?
In 1986 from Florida State University.
Have you done postdoctoral studies as well?
Yes, sir. I was an NIH postdoctoral fellow at the University of Illinois Urbana-Champaign and at the University of Chicago.
Can you tell us briefly your history of employment?
Following the postdoctoral appointments, I worked for 1 year as a research scientist at Dow Chemical in Midland, Michigan. Then I moved to Oak Ridge National Laboratory, where I was a staff scientist from 1990 until 2002. After leaving Oak Ridge in 2002, I went to work at the University of Central Florida, where I am now.
Did you have acquaintance by chance with Dr. Arpad Voss while you were at Oak Ridge?
Yes, I have known Dr. Vass during the time that I was at Oak Ridge National Laboratory.
Sir, have you, well, first of all, would you tell me what is a peer-reviewed article?
When we perform research in the sciences, when we want to publish that work, we write a manuscript detailing the results of the work. We send it to a journal. The journal will send it out to the article out to our peers who are doing similar research in various institutions, academic, government, people generally who are doing very highly related work. They review the article, send back their reviews to the editor, and the editor makes a decision on whether to publish the article or not. You do not know who the reviewers are.
How many peer-reviewed articles have you had credit for or contributing to, Doctor?
I believe about 64. I list in my CV 74 peer-reviewed publications, book chapters, and proceedings from meetings.
In addition to all of these peer-reviewed articles, have you made presentations, lectures to professional groups regarding your work?
Yes, sir. Over the time since I received my PhD, I've made probably 140, I can't remember the exact number of presentations, myself and in conjunction with my students who do research.
Your Honor, this time I would submit Dr. Sigmund as an expert in his field of chemistry.
No objection.
Ladies and gentlemen of the jury, Dr. Sigmund be accepted as an expert witness in the area of chemistry. You may proceed.
Dr. Sigmund, would you tell the ladies and gentlemen of the jury, please, sir, how you first became involved in the case of the state of Florida versus Casey Anthony?
On July 21st of 2008, I was in my laboratory, received a phone call from Eric Walton, who is an officer with the University of Central Florida Police Department, asking me if I would be willing to speak with Mr. Stryker, I believe it was, from Orange County Sheriff's Office regarding taking sampling of air from the trunk of the car that was supposedly belonged to Miss Anthony. I agreed to speak with Mr. Stryker. He phoned me and told me that they had been in contact with Dr. Vass. They wanted to take samples of air from the trunk of the car, but Dr. Vass was not available to take those samples. Apparently, Dr. Vass gave them my name as someone who would be able to take those samples and who was currently resident in the Orlando area.
What, if anything, did you do, sir, after being recommended to go help the sheriff?
The first thing I did was to phone Dr. Vass and ask him what kind of samples he wanted and what sort of sampling methodology he wanted me to use, because I'm aware of his work, and I know that he typically uses adsorbent traps. I did not have adsorbent traps, but had other ways potentially to pull air samples from the trunk of the car. So I discussed with him the use of a Tedlar bag to pull air samples and put them in the Tedlar bag. He said that that would be acceptable.
What is a Tedlar bag?
A Tedlar bag is a plastic bag. It's made of a fluorinated polymer. I believe Tedlar is a trade name of DuPont, I believe, and it's a bag that's commonly used for collecting air samples.
Having had that preliminary, sir, what, if anything, did you do then?
We proceeded to Orange County Sheriff's Office.
Stop a second. You said we.
Doug Clark and myself. Doug Clark is an associate who works in the laboratory with me. So we proceeded to Orange County. We took with us 2 Tedlar bags, a gas-tight syringe for pulling the air samples out of the trunk of the car. And we went there and pulled the air samples. We pulled 1 air sample that was approximately 1 liter of air and placed it in a large Tedlar bag that was designed to hold 1 liter of air. And we pulled 300 milliliters of air and put it into a second smaller Tedlar bag.
Tell me more details, sir, how you do that. If you pull the air, how you do it? The trunk open or closed? What do you do?
So the procedure for pulling an air sample with a Tedlar bag generally involves using a pump to pull the air into the bag. We did not have a pump, so we used a gas-tight syringe with a metal needle attached to the end of the syringe. When I arrived at the Orange County garage, the trunk on the car was closed. We opened the trunk just maybe an inch, just enough to get the needle from the syringe into the trunk of the car. We extracted the air through the needle and then placed it into the Tedlar bag.
I love hearing about how they're so careful to test the air. They just open up a crack and they quickly put the thing in and then take out some air. Because you got to be so fast with air. It really moves fast. So they got to be really quick.
And how many samples of air did you draw for the directions of Dr. Voss?
We took the 2 samples, one approximately 1 liter into the larger of the 2 Tedlar bags, and a second sample approximately 300 milliliters into the second smaller Tedlar bag.
What, if anything, did you do with those air samples in the Tedlar bags?
We left both samples in custody of the Orange County Sheriff's Department. The larger bag they were to send to Dr. Vass, and the smaller bag they brought to the University of Central Florida, to the National Center for Forensic Science on the following morning, July 22nd, for us to perform preliminary sampling on that bag.
What tests, if any, did you run on these samples, sir?
The first test that we ran, we used a gas-tight syringe to pull 250 microliters of air from the bag, and we injected it directly into a gas chromatograph mass spectrometer to analyze the air.
Doctor, the jury has heard this gas chromatograph mass spectrometer, and enough to probably say it in their sleep. What is it?
A gas chromatograph is an instrument which is like an oven. It has an oven component. It has within this oven component a very long glass capillary. The capillary in the oven that we used was approximately 25 to 30 meters in length. The interior diameter of that capillary is approximately 0.25 millimeters, and it has a very thin coating on the wall, in our case about 0.25 microns. The sample is...
What's a micron? How thick or how thin is that? Tell us what it is.
A micron is a 1/1,000,000th of a meter, so a 25 micron thick film is 25 millionths of a meter in thickness. The sample is inserted into the instrument, generally by some sort of a syringe. It is passed through this column. The different components in the mixture interact differently with the walls of the capillary, and they separate. The components of the mixture will separate out into bands. After they have gone through this column, they come out into the mass spectrometer, which is the detector for this instrument. When they enter the mass spectrometer, they enter what is called a source. There are electrons in the source that are being accelerated, in our case, 70 electron volts. Those electrons pass very close to the molecules or interact with them and actually take an electron essentially from the molecules that have come off the column, creating a positive charge on those molecules. Those molecules are then directed through a mass analyzer, which basically tells us the ratio of the mass of the molecule to the charge of the molecule. The molecules have a weight, and when they are ionized in the source, sometimes they stay in one piece, sometimes they break into multiple pieces, and based on the pieces that they break into and the mass to charge ratio of those pieces, we then can identify what the analyte or what the compounds were that came off the column.
And is the gas chromatograph mass spectrometer universally accepted as the method of doing chemical testing?
It is a widely used and well-characterized method of doing chemical analysis, especially the electron ionization methodology that we use in the source is very stable and has been used many, many times.
In this particular case, sir, you were about to tell us what I needed in education, what you did.
Yes, we analyzed the 250 microliter sample of air that we pulled in the syringe, and the results that we obtained from the gas chromatograph mass spectrometer showed us that there were trace amounts of volatile organic components in the sample, but the signal was not strong. The sample was not concentrated enough for us to achieve what we consider to be a very usable or a good signal.
Now, you tested, if I'm hearing you correctly, one of the bags of air samples, the other one went to Dr. Voss.
We left the other bag with Orange County. I'm not sure if it was sent to Dr. Voss.
Fair enough. And your test resulted in what, sir?
Can you be more specific?
The test that you did, what were the results? What did you find?
For the test of the 250 microliter air sample, we saw organic components very weakly in the sample. They were components that were comparable to the sorts of materials that you would find, for example, in gasoline or some other petroleum product. They were hydrocarbons.
Gasoline. Ordinary gasoline.
Yes.
And did you find anything else other than gasoline in these air samples, sir?
In the first sample that I just discussed, the 250 microliters, the sample was too weak. So we took a second sample from the bag, and we took that sample using a different methodology which would concentrate the sample. That methodology for sampling the bag the second time is what is called a solid phase micro-extraction fiber, or a SPME. And what that amounts to is a very thin glass fiber which has a 65 micron or 65 millionths of a meter thick polymer coating on the glass. That fiber is contained within a metal needle. You place the metal needle into the sample, in this case into the bag. You then extend the glass fiber and let it sit for a period of time, during which organics that are in the vapor phase in the bag will absorb onto that polymer and be concentrated. You then retract the glass fiber into the metal needle, retract the metal needle from the bag, go to the gas chromatograph mass spectrometer, insert the needle and extend the fiber. And in the gas chromatograph, the very part where you insert the samples is called an injection port. It is hot, 250 degrees centigrade in our case, and the organic analytes that are absorbed on the polymer come off and proceed through the gas chromatograph and into the mass spectrometer for analysis.
What were the components that you were able to extract through all this testing?
The second sample from the 300 milliliter air sample was very similar to the first sample, except it was much more concentrated. We had a better signal, and we determined from that if we wanted a really good air sample or a better air sample from the trunk of the car, then the way to do it would be with the solid phase micro-extraction fiber. The results of that test were, again, consistent with the presence of gasoline.
Were you able to do a quantitative analysis of any of the compounds found in that sampling?
No, we did not do any quantitative analysis.
What were the compounds that you actually were able to identify through this process, sir?
In the second sample that we pulled from the Kevlar bag using the solid phase micro-extraction, we identified several components, toluene, some ethylbenzene. We didn't completely analyze everything in the bag because we knew that we could get a better sample, but those are components that you typically find in gasoline.
Did you, in your testing, determine that there was some amounts of tetrachloroethane?
May I access my...
You did report in this case?
Yes.
And you made it, sir, if I correctly, that was dated July the 30th of 2008. Did you send to the Sheriff's Department?
Yes, sir.
Do you need to review that, refresh your recollection?
I just want to access it to, yes.
You may do so, sir.
I do not believe in sample 2, as I recall, that we identified tetrachloroethylene. We did identify it in some additional samples that we took later.
And what were they?
After doing the samples from the Kevlar bag, after analyzing those, on July 22nd, we returned to the Orange County garage with a solid phase micro-extraction fiber and also a activated carbon strip. We took 1 sample from the car using the solid phase microextraction fiber being placed in the trunk for 40 minutes, and the carbon strip was also in the trunk for 40 minutes. We took those back to the National Center for Forensic Science. After taking them out of the trunk, we placed them on ice. We returned to the National Center for Forensic Science and analyzed them immediately following our return. The following day, we returned to the Orange County Sheriff's Office. We collected 4 solid phase microextraction fiber samples. The fibers were left in the trunk for a period of 7.5 hours. We also collected that day 2 activated carbon strip samples, which were also in the trunk for 7.5 hours.
I'm sorry, go ahead. I want you to tell us what the analytical result was of those tests.
Yes, sir. We returned with the 7.5 hour samples and analyzed them the same day as well. In those samples, the chromatographic data was better, was a stronger response than we saw from the samples from the Tedlar bag. There was a pattern, the primary pattern in the chromatograph was that of gasoline. And in looking more closely at the data, we also determined that there was present in the data, in the sample, chloroform, dimethyl disulfide, and tetrachloroethylene.
And were any of those subjected to or capable of being subjected to a quantitative analysis?
A quantitative analysis was not done. A quantitative analysis could have been done. We did not do one.
So the primary substance was gasoline,
Yes,
and then the other 3 that you told us.
that's correct.
Now, what common sources of tetrachloroethylene are there that you're aware of?
It's my understanding that tetrachloroethylene is primary use is in the dry cleaning industry, can also be used as a degreaser.
I'm not sure what is testified that was. I'm not sure what is testified that was found. Tetrachloroethylene, I don't recall mentioning that was being found. Well,
The witness can clarify.
I'm sorry, I don't understand. Can you clarify your statement?
Apparently it's confused. I didn't understand. What were the compounds that you found in the car and in the air? You said primary gasoline and other. What were the other?
Right. Three other compounds.
Okay.
Chloroform,
Those again.
chloroform, dimethyl disulfide, and tetrachloroethylene.
Okay. And the tetrachloroethylene is what you just said, sir, is used in dry cleaning and spot removers and so forth?
Yes.
All right. And the chloroform is used how?
Chloroform is a solvent that you commonly find in chemical laboratories and has uses also in degreasing applications and that sort of thing. It's also formed in, you find it in natural settings. It's formed from the reaction of oxidizing agents such as hypochlorite, sodium hypochlorite, or bleach with organic components in the environment.
Clorox.
Yes, sodium hypochlorite.
Just 1 second, John. Dimethyl disulfide you found.
Yes.
And does it occur naturally in substances that the rest of it might understand?
Yes, dimethyl disulfide is present in onions. It's present in cabbage. It has been reported in soil samples, and it's also been reported in decomposition events as well.
Based on your training, experience, and education, sir, are dimethyl disulfide, tetrachloroethylene, and chloroform sometimes liberated from the decomposition of human remains?
Oh, naturally.
I have not done direct studies on the decomposition of human remains. It is reported in peer-reviewed literature by Dr. Vass and by Dr. Statheropoulos that there are a whole host of compounds that are eliminated or produced during decomposition. Dr. Vass reported in 2008 in the Journal of Forensic Science that tetrachloroethylene, chloroform, and dimethyl disulfide are produced during human decomposition. He listed 30 compounds in his paper, which included those 3 that he called markers for human decomposition. Dr. Statheropoulos, in a paper from 2005 in the Forensic Science International Journal, reported a list of 86 chemicals that were found evolved from 2 decomposing bodies that had been found in the Mediterranean Sea. Of those 86 compounds that he listed as the most prevalent compounds, 11 were in common with the 30 listed by Dr. Vass. Dr. Statheropoulos did not list chloroform. He did not list carbon tetrachloroethylene. However, his samples were produced from aerobic or decomposition in air. Dr. Vass indicated in his paper that the chloroform and the tetrachloroethylene were likely produced by decomposition under anaerobic conditions without air present. And I find no disagreement between those 2 necessarily. So based on the literature that I have read from the peer-reviewed literature, I do believe that those compounds can be considered as related to a human decomposition event.
In addition to cabbage, onions, and cleaners and Clorox.
There are other sources for those compounds, yes.
At the end of the day, after your analysis and your readings and your opinions, sir, do you have an opinion now as to whether or not the evidence establishes that there was human decomposition in the trunk of the car that you took the air from?
My opinion is based on the samples that we collected and that we analyzed. And in those samples, the 3 compounds that we just talked about, the chloroform, carbon, tetrachloroethylene, and dimethyl disulfide were present. but they were at low, they gave very low responses in the instrument, although we did not quantify the concentrations. And because there are other sources of them available in the environment, based solely on our data from our test, I could not conclusively determine that the presence of those compounds indicated that there had been human remains in the trunk of the car.
And sir, finally, if there were, or were you aware of a bag of garbage that was found in the trunk of the car?
I really have tried not to follow all of the details, but I do understand that there was garbage found in the trunk of the car.
Thank you very much, Doctor. I have no further questions. I do have one last question. Verify from your report, sir. How many samples did you take? Air samples?
There were a total of 6 air samples, the 2 Tedlar bags, the 40-minute solid phase microextraction fiber. Sample number 5 was, number 4 was a 40-minute carbon strip, an adsorptive carbon strip. Sample 5 included 4 solid phase microextraction fibers, 2 of which were retained by Orange County Sheriff's Office, 2 of which we analyzed at the University of Central Florida, and there were 2 carbon strips, 7.5-hour exposures in the trunk of the car.
From all of those samples, was the primary finding that of gasoline?
That gasoline was the principal chromatographic profile principal chromatographic profile resulting from the analysis of those samples could be attributed to gasoline.
And do you know which of those samples or how many of them contain these other substances that we were talking about?
The solid phase microextraction fibers from the 40-minute exposure and the 2 7.5-hour exposures contained the 3 compounds chloroform, tetrachloroethylene, and dimethyl disulfide. We did not see those. I do not recall that we specifically identified those in the samples taken from the Tedlar bag or from the last carbon strip that we analyzed, which we extracted the components off of that carbon strip with carbon disulfide, which is a common methodology followed in fire debris analysis. And in analyzing that sample, we also did not see the 3 compounds chloroform, dimethyl disulfide, or tetrachloroethylene.
Was the gathering of the air with the syringe process, as you described, for the 2 Tedlar bags done at the same time?
Yes, sir, it was.
Thank you very much.
Cross-examination? Yeah. We'll take a 15-minute recess at this time. Stay recognized, President of the jury.
Yes, Your Honor.
Defense? You may proceed with your cross-examination.
Morning, Dr. Signer.
Good morning.
The date that you took your air samples, I believe you said was July 21st, 2008. Is that correct?
That is the date that we took the air samples from the trunk to go into the Tedlar bags, yes.
And that was the first sample?
That is correct.
Now, the way you did it, you just sort of cracked open the trunk and stuck some sort of syringe in it and drew out an air sample.
Yes, we opened the trunk maybe 1 inch, maybe a little further, just enough to get a needle. The syringe actually had a long needle, possibly about an 8-inch needle on it, and we put that inside the trunk and pulled the air through that.
So you did not open and inspect the trunk?
No, we did not.
So you were not aware that the trunk liner and the spare tire cover had been removed 4 days before? You didn't know that?
I did not know that.
So your air sample would have been from the trunk 4 days after the trunk liner and the spare tire cover had already been removed, if in fact it was removed on the 17th, as the evidence has shown?
That would be correct.
How much is 250 microliters? Can you give us an example of we can kind of get an idea what a liter is. A microliter is what percentage or fraction of a liter?
A microliter
Yes.
is 1/1,000,000th of a liter.
Okay. So just trying to envision it. You get a 2-liter Coke bottle, half that be a liter, and then a microliter would be a millionth of that.
Right. So I'm sorry, what was the volume value that you were asking
You
for?
said 250 microliters was what you drew of air.
Oh, correct. Yes.
Give an idea of how much that is.
So the syringe diameter, internal diameter, would be roughly the size of a lead pencil, and the length of draw on the syringe would have been maybe 1/4 of an inch. So it's not very much air.
A very tiny amount of air. And then you injected that into a Tedlar bag, or I'm sorry, that's the one you took back directly to the lab, right? The first sample. I think I've confused you. I'm sorry. The first sample you took, what did you do with it?
Okay, on the 21st, we pulled 2 samples from the car. The first one was approximately 1 liter, and the second one was 300 milliliters, about 1/3 the size of the 1 liter one.
Okay. And those were placed in the Tedlar bag?
That is correct.
All right. And those were then taken to the lab and sampled?
They were held by the Orange County Sheriff's Office, and a deputy, or I believe a crime scene technician, Mike Vincent, brought the 300 mil Tedlar bag sample to University of Central Florida on the morning of the 22nd.
And now Dr. Voss had requested that you use a device called a triple sorbent trap.
Yes.
But you didn't have that equipment.
That is correct.
Now, the advantage of a triple sorbent trap is it allows you to test the chemical components of a much larger volume of air, correct?
That is correct. With a triple sorbent trap, you use a pump, and you pull air through a bed of adsorbent, in this case, 3 adsorbents, carbotrap C, and carbosiv S3. And each of those sorbents in the bed takes out different analytes. And so if you pull 10 liters of air through that trap, then you get the components that are in 10 liters of air.
And the advantage of that is you can, in effect, test a large volume of air by just pulling the air through the triple sorbent trap, depending on how long you let it run, how the pump is set.
That is correct.
But you did not have that equipment or that capability of doing that.
I did not.
Now, in your analysis, though, even of the air sample itself, you indicated that you found some weak signals for organic compounds, correct?
That is correct.
Then you went to the next level, which was the SPME fibers, SPME for the court order. Is that correct?
That is correct.
Now, those basically, as you described, are fibers that you essentially just expose to the ambient air and allow the chemicals that happen to be in the air to attach to the fiber, correct?
That is correct.
But again, that method, though better than the bag, is still not as a good a testing method as a triple sorbent trap, correct?
It is a different sampling method and will not concentrate as large an amount of analyte. Therefore, you will probably receive a worse signal-to-noise ratio in the instrument response, a lower instrument response from the solid-phase microextraction fibers.
But again, just like with the other method, you're not actually drawing air past the SPME fibers. You're just sort of letting them sit and letting the ambient air absorb into them.
That is correct.
So that method, though better, still is not as good as triple sorbent trap in finding out what's actually there.
I would consider the triple sorbent trap a better sampling methodology for, especially for components that might be at low concentrations in the air sample.
And would that also be the case for the carbon strips, that the triple sorbent trap is a better method than the carbon strips as well?
That would be correct, yes.
But it would be fair to say that you used the best method that you had available to you in order to try to determine the chemical components of the trunk sample.
That is correct.
Now, your sampling simply tells you what was in the air in the trunk. It doesn't tell you where it came from, correct?
That is correct.
So if there was a particular object in the trunk that you suspected the odor would come from, there are other methods you could use to test those individual items.
If those individual items were isolated, then you could test the air above those items after giving them an appropriate time to equilibrate, and you could test what was coming from those individual items, yes.
Equilibrate means basically you allow the amount of the compounds in the surrounding air to equalize to some extent with the amount that's in the object you're looking at.
Basically, yes, that's correct.
And one of those methods would be to place the item in question in a Tedlar bag and allow it to off-gas into the air for a certain period of time to determine what was in it.
That would be an acceptable approach, yes.
Now, even with the methods that you were able to use, and even with the trunk liner and the fair tire cover gone, you were still able to detect chloroform, correct?
That is correct.
And you were still able to detect the other chemicals that you've referenced, TCE and dimethyl disulfide.
Tetrachloroethylene and dimethyl sulfide, yes. I'm sorry, dimethyl disulfide. Yes.
Dimethyl disulfide, I'm sorry. I was and you've indicated that even based on that very limited sampling, that those chemical constituents are consistent with the research that's out there about human decomposition.
Those components are reported in the peer review literature as arising from human decomposition.
But as you said, they can coincidentally come from other separate sources.
That is correct.
Now, you mentioned to counsel that chloroform can come from a reaction between bleach, as an example, and certain organic components.
That is correct.
And that's in some literature studying the effects of finding small amounts of chloroform in people that have swimming pools.
I have seen one report, I believe it was from an Iranian journal, that did indicate that there was chloroform in swimming pool water and in people that had actually been in the pool. Yes.
And in potentially hazardous amounts or just in very, very minor amounts?
As I recall that article, it was in very minor amounts, not hazardous amounts.
Do those articles also reflect that there should be other component chemicals created by this coincidental reaction between chlorine and organic components?
If bromide ions are present, that's Br minus bromide, then it can react with the hypochlorous acid, which is from the Clorox bleach in aqueous solution, to form hypobromous acid. And the hypobromous acid, along with the remaining hypochlorous acid, can lead to not only chloroform, but also chloro compounds, methane, containing both bromine and chlorine.
So the reaction, if that were to occur, would create more than just chloroform. It would create other signature chemicals to reflect that had occurred.
As long as the bromide was there to form the hypobromous acid, yes.
And even in a case of is there any support in the literature or any case reports in the literature of chlorine being caused by a bathing suit being thrown in the back of a trunk?
I'm not aware of any literature discussing that.
Even if you had a coincidental or accidental creation of chloroform through chlorine and these other organic chemicals, would you still expect to find some residual chlorine that had not gone through that reaction and become chloroform?
By chlorine, I assume you're referring to chlorine gas, Cl2, which is the natural form of chlorine?
Yes.
I suspect that particular material would either hydrolyze with water to form hydrochloric acid, which contains chloride ions, or it would dissipate.
Did you find anything in your evaluation of the air sample that would lead you to believe that this chlorine came from some sort of inadvertent reaction between either pool chlorine or chlorine bleach and organic compounds? This kind of accidental thing that counsel was asking about.
There's nothing in our results that indicate the source of the chloroform or the tetrachloroethylene, which are the two analytes that contain chloroform. We simply know they're there. We don't know their source.
Now, when you examined, your background is not in studying human decomposition, correct? Hasn't been your specialty.
But that is correct.
When you worked with the trunk and you opened it slightly, did you detect an odor coming from the trunk?
Yes, there was an odor coming from the trunk.
But do you have any background in identifying that odor?
I do not.
No further questions.
Redirect.
The total number of samples you took, is it true that you found these slight traces of
I
chloroform?
believe it was number 3, which was the 40-minute solid-phase microextraction fiber from the trunk of the car, also contained those components. And the 2 solid-phase microextraction fibers from 7.5 hours, which you referenced in your question, also contained those compounds.
The 3 compounds we talked about a while ago.
Yes,
All right. And if I understood you correctly, you don't know the source from inside of any of those 3.
that is correct.
The final word is the main thing that was there was gasoline.
The predominant chromatographic profile was associated with or identified as gasoline.
And this is a report that you provided to the Sheriff's Department 3 years ago.
Yes, sir, I believe on July 30th.
Thank you very much for your help, sir. I have no further questions.
Reed Crops.
Based on the circumstances of where you examined the car, that it was in a garage, that the trunk liner and spare cover had been removed, did it surprise you at all to find elements of gasoline in the air sample?
I would say that I was not surprised to find that, no.
Now, no further questions. Thank you.
May the doctor be excused. Thank you, doctor. You may be excused, Dr. Sigmund. Thank you. The defense may call the next witness. You may.
Your Honor, the defense would call Susan Mears.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
My name is Susan Mears, SUSAN, MEARS.
You may proceed.
Thank you, Your Honor. Good morning, Ms. Mears.
Good morning.
Can you tell the ladies and gentlemen of the jury again where it is you're employed and what?
I am employed by the Orange County Sheriff's Office, and I'm the crime scene supervisor.
Okay. Now, I'd like to show you items, photographs, defense CN, CM, and CL. May I approach the witness, Your Honor?
You may.
Do you recognize those items?
Yes, sir, I took them.
And are those items that you collected off of Suburban Drive?
Yes, sir.
Okay. Can you describe what they are?
One of them is a red World of Disney plastic bag, and contained inside of that bag was a cool blue flavored Gatorade bottle.
And is this a bright red bag?
Yes, sir.
Okay. And do those photos accurately depict the items that you collected off of Suburban Drive?
Yes, sir.
Your Honor, at this time, we would move those 3 photographs into evidence.
They will be received in evidence as defense number.
May I retrieve the items from the witness, Your Honor?
Yep, you may.
And may I publish these to the jury?
You may.
While we're setting this up, Ms. Mears, can you tell me how far these items were from the skull?
May I refer to my report?
Yes. While she's doing that, may I publish these photographs, Your Honor, to the jury? Everyone see that? Do you have our answer?
Yes, they were approximately 7 inches away.
7 inches away.
Yes, sir.
Okay. And the Gatorade bottle was inside of the bag, correct?
Yes, sir.
Has everyone been able to see? I have no further questions for this witness.
Cross-examination. Witness may be excused. Defense may call the next witness.
Yes, sir. The defense will call Dr. Michael Rickenbach.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Michael Rickenbach, Rickenbach.
Sir, what is your position again? What is your position and your occupation?
I am a forensic chemist examiner within the laboratory division of the Federal Bureau of Investigation.
Your Honor, we would reassert that Michael Rickenbach has been previously designated as an expert witness in the area of forensic chemistry.
That's correct, he has.
Ladies and gentlemen, the certification still stands. You may continue.
Sir, I'd like to direct you to your a report you did in this case dated July 6th of 2009. Do you have that with you?
Do you have a copy? Or
Yes, I have a copy of it. May I approach the witness? After you've had a chance to review it, sir, let me know.
I'm ready.
Certain items of evidence to inspect and do tests on, sir.
Yes, I was.
Okay, and what were those items?
These items we designated with certain Q numbers. They were a bottle, liquid within that bottle, a syringe with a needle on it, and liquid within that syringe. It was an unknown substance within a bottle.
I can't hear you.
I'm sorry. Object to testing things that are not in evidence. Those items are not in evidence. We can approach them.
No. Are they in evidence, Mr. Baez?
Well, they're in the possession of the sheriff's
No.
department.
Are they
Can we
in
approach?
evidence?
I'd like to-
They're not in evidence. Objection sustained, but you can't approach.
Dr. Rickenbach, I'd like
Just a
to.
second.
I apologize.
You may proceed.
Dr. Rickenbach, I'd like to direct your attention to the report that you issued on December 11th of 2008. Do you have that with you, sir?
If you have a copy.
Sure. May I approach the witness, Judge?
You may.
Did you receive certain items from the Orange County Sheriff's Department?
I received items from my evidence control unit, which in turn received them from the law enforcement agency, yes.
And could you tell the ladies and gentlemen of the jury what those two items were for that report?
The items related to this report were one car seat, we designated as item Q47, and an item reported as being a steering wheel cover, item Q48, according to this laboratory report.
And Your Honor, I believe by previous stipulation, these two items were retrieved from the Pontiac Sunfire from the, with the tag number. Is the tag number on your report?
There is no information about a tag number on this report.
The Pontiac Sunfire that belonged to Ms. Anthony.
What says the state? You have to turn your microphone on, Mr. Price.
We don't have an objection to proceeding with that stipulation. We're going to check. We think that the steering wheel cover may actually be marked, and if that's going to move into evidence, but we're going to check and see if we did have it marked.
Okay, you may continue, Mr. Baez.
And what were you asked to test these items for, sir?
I was asked to test for the presence of volatile substances, particularly chloroform.
Okay. And can you tell the ladies and gentlemen of the jury what your results were?
That chloroform was not identified on either one of those pieces of items.
And why would you test the steering wheel cover? What's the purpose of that?
I'm not sure why it was requested. It was just when the items come in with a certain request from a contributor, we perform those tests.
Were you informed at any time that the purpose was to see if chloroform had been on someone hands that drove? May I finish the question? Chloroform that might have been on someone's hands would then possibly transfer to the steering wheel cover?
Go to ask the question, sir, in court. Mr. Ashton?
Checking hearsay and relevance.
Sustain
It would
what
go
you're
to,
saying.
Your Honor, would go to his items that might contribute to his opinion.
Sustain.
And the other item that you tested was exactly what again, sir?
Besides the steering wheel
Yes,
cover, was Q47, which is a car seat.
The child's car seat?
Yes.
And you found no chloroform on that?
Chloroform was not identified on that item.
Now, I'd like to direct you back to your previous report on July
Yeah,
609.
I'm sorry, may I clarify? Chloroform was not identified on the samples that I took off of that item. I cannot say for sure that I did not analyze the entire car seat. I took cuttings that were representative of that car seat that I thought, and no chloroform was identified on those cuttings.
Understood.
Let me clarify that, please.
Understood. And were you also given another item to inspect for chloroform? I believe that's noted on your report of July of 09.
The original report.
Correct, the first report I showed you. What were you given, sir, to inspect?
According to this report on July 6th?
Yes.
Do you want me to list all the items?
No, just the specific, if I can look at your report again, I can give you the Q number.
You have request the items marked, be put into evidence prior to testimony about.
Well, he can list what he's looked at. He can't test. He can talk about what he's seen, but he can't talk about any results until they go into evidence.
At the moment, Mr. Ashton.
You may.
Judge, at this time, I would move HR, state secret HR.
Was it logged for identification by the state, but not by the state?
Yes, sir.
It be receiving evidence as defense numbered.
Sir, were you given a doll to also check for chloroform?
Yes, the doll was submitted for analysis.
And did you conduct the examination on the doll to see if that had chloroform on it? And can you tell the ladies and gentlemen of the jury what those results were?
I did receive a doll for the determination if chloroform volatile chemical was present on that item. I took a sampling of that item, and the analysis of the samplings, chloroform was not identified.
I have no further questions for Dr. Rickenbach at this time.
Cross-examination.
As to the examination of the doll, was there not an early indication of the presence of chloroform that you had to go and get another doll to check? Am I remembering the right item?
When analyzing the doll, there were indications of that chloroform may be present, but in very, very small amounts. I requested that a similar doll be submitted. That was not available. A coworker submitted a doll that she had. I analyzed that. Again, very small amounts of chloroform, related product, and so it just was not enough for me to render a decision that chloroform was identified on that item.
So there was an indication of chloroform, but you
Object about on this and request a sidebar.
You may. You may continue.
if you would go and finish your answer about your exploration of chloroform issue on the doll.
What is commonly done is that the negative control is usually run with the same sample matrix. So in this case, it was the fabric or the stuffing of the doll. Because I got indications of possible chloroform, whether it be from chloroform or from the material during the process of examination producing chloroform. I wanted to get a negative control doll to say if the chloroform maybe just would come from the material itself. And I got the control doll, and it gave very, very low indications of possibly chloroform. So that with the very low amounts within the initial specimen, I was not comfortable in saying chloroform was identified in that item.
So you were able to obtain a doll, but not one of the same make models for doll, but the same make and manufacturer. You weren't able to get one identical, but you got one that seemed similar. And since it had chloroform, you were not comfortable in saying that chloroform in the doll wasn't just from its manufacturer.
He's correct in saying that I did not have a doll of the same type, but it's not that the doll had chloroform that I couldn't rule it out. It was small amounts, and it was just too small for me just to comfortably say that it could be identified as being a contaminant within the doll.
Oh, thank you very much. That's the only question I have.
Redirect.
So just so we're clear, sir, a coworker of yours has a child that her doll has chloroform on it.
No, that's not what I said at all.
Okay. You found another doll that had chloroform on it. Is that correct?
No, that's incorrect. I did not have the data enough to say that chloroform could be identified on either one of those items.
Okay. And that's because chloroform is found in many products.
I'm not sure where the chloroform came from. Chloroform is in other products. Whether the chloroform is in this product, I don't believe so. It may be because it uses heat and the technique, chloroform may have been produced from the material. That's why we use a negative control so that we don't falsely or incorrectly identify something that shouldn't be there.
And chloroform could be found in water as well.
If it's present in high enough amounts for us to detect and identify, yes.
I have no further questions.
Recross? Yeah. You may continue.
Yes, sir. Dr. Rickenbach, you also, I'd like to refer you to your report back in July dealing with the Gatorade bottle and substance that was inside of it. Do you recall those items?
Yes, I do.
Okay. And what were you asked to do in that report?
In the Gatorade bottle that was submitted, there was an unknown liquid within that bottle. Also, there was a syringe for the needle, and there was liquid within that syringe. I was asked to identify or try to identify what the liquid and the two liquids were.
Your Honor, may I publish State Defense 32 for the jury?
You're offering that provisionally?
Yes, sir.
Any objections from the state?
I believe the photograph is already in evidence.
Oh, it's in evidence?
Yes.
The photograph is, yes.
Oh, go ahead.
Yes.
You may. What's the exhibit number?
32.
You may.
Can you? Thank you, sir. Is this, sir, the Gatorade bottle that you tested? Does it appear to be?
It appears to be the Gatorade bottle that contained that the liquid was within.
Okay. And what was inside of it?
You want the results of my report?
Yes. Tell the ladies and gentlemen what you tested and what the results of your report were.
Okay. Just for accuracy, could I get the report back?
I thought I gave it to you. Sorry. May I approach the witness?
You may.
Go ahead and tell the jury what you found.
The liquid within the Gatorade bottle was a whitish, murky kind of liquid. While it was not fully identified, it could have come from some kind of type of cleaning product or cleaning product added to it. Additionally, a mixture of testosterone compounds were identified within that matrix.
And did you find a syringe as well?
There was a syringe with a needle on it within that bottle, yes.
And did you believe the syringe to contain, or did you find that the syringe to contain testosterone?
There were within the liquid of the syringe was an oily kind of liquid, yellowish oily liquid, and within that same testosterone compounds were identified.
Okay. Now, in this liquidy substance, what instrument did you use to detect these items?
The testosterone compounds?
Yes.
There was a technique called gas chromatography, mass spectrometry, and time of flight mass spectrometry, which was used to identify those compounds.
And in this liquid, did you also detect very low levels of chloroform as well?
Within the Gatorade bottle liquid, the one that could have come from some type of cleaning material, low amounts of chloroform were possibly present, but they were very small amounts.
And the reason you did not report those out is because, of course, they were at such low levels, and because they could have come from a cleaning product.
This is correct.
Your Honor, at this time, we would provisionally move to enter into evidence the items discussed and testified to by Dr. Rickenbach, which are specifically.
I don't believe you guys are here yet. I believe the agreement was that testimony was provisional upon the items being placed into evidence at some future point.
Okay.
I do agree with that.
All right.
I have no further questions for Dr. Rickenbach at this time.
Okay. Cross-examination on those issues.
The amounts of, you did not report out the chloroform in your report, correct? That is correct. Just like with the doll, it was such a small minor amount that was attributable to cleaning products, you didn't even report it out. That is one of the reasons. The other reason was it was more of what compound, what are these, more of an identification, not just specifically for chloroform. That the request was more for identification of what this compound was. Where your identification as a cleaning product, was that based upon the mass spectra other than just chloroform, all the elements taken together? Yes, there were indications that this was a cleaning product, and chloroform has been known to be in cleaning products, so it was not of any really surprise. So the GC mass spec would give you a total spectrum that would convince you it was just a cleaning product. The instrument can't identify a cleaning product. It just, based on my examination, the smell of it and the products that potentially came out, it was a possibility that it could have been a cleaning product added or from a cleaning product. No further questions.
May the doctor be excused?
Yes, sir.
Thank you, doctor. You may be excused. Defense may call the next witness.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
My name is Karen Korsberg Lowe. Korsberg is Korsberg, Lowe is Lowe.
Good morning, Ms. Lowe.
Good morning.
Your Honor, I would ask to recertify Ms. Lowe as an expert in hair and fiber analysis.
Ladies and gentlemen of the jury, Ms. Lowe has been previously recognized by this court to be an expert in hair and fiber analysis. You may continue.
Thank you, Your Honor. Ms. Lowe, I wanted to go over some of the reports that you didn't have the opportunity to testify about last time.
Okay.
Let's start with August 13th of 2008.
The FBI lab number, so both witnesses and I can pull out the correct report.
Okay.
Sure.
I'm sorry, could you repeat the date?
Yes. August 13th, 2008, lab number 0808, 1105, and 6. Yes. Yes. Do you have that report, ma'am?
I do.
Okay. Can you tell the ladies and gentlemen of the jury what you tested, where it came from, and what your results were?
There were items of clothing that were identified as coming from Casey Anthony's closet. These items were processed for hairs and fibers, and the hairs recovered were examined for any that exhibited characteristics of apparent decomposition, and none were found.
Okay. So the results were negative.
That's correct.
Okay.
I believe we already spoke about the other two
The other ones we
items.
spoke of already. Were you able to recover hairs from those items?
Yes, hairs were found.
Okay. So is it in your experience common that hairs are attached to clothing items, found on clothing items? I'm sorry, found on clothing items?
Yes, it's very common to process things like clothing and bedding to recover hairs and fibers.
Okay. All right, now let's go to your report of October 15, 2008. If I can have a moment, I'll give you the lab number. Mr. Ashley. Sure, Q58. You have that report, ma'am?
I do.
Okay. And what were you given here and from where?
This was debris that was identified as coming from a trash box, I believe, from the vehicle. Again, this was examined for any hairs exhibiting signs, characteristics of apparent decomposition, and none were found.
Now let's go to October 21st, 2008. And can you identify those items?
In
I'm
this,
sorry, Q25.
okay. In this report, I dealt with specimen Q25.1. It was actually a hair recovered when an item in the laboratory was examined by another examiner. This hair was examined for characteristics of the parent decomposition, and none were found.
Where this item came from?
Yes. Does it state in your report where the item came from?
It's Q25 was one of the pieces of trunk liner.
Okay. So this was an item that was found on the trunk liner, a hair that you examined that did not show any signs of apparent decomposition.
That's correct.
Now, on November 6th, for counsel, it's lab number 08-110-4009. Can you tell us where these items came from?
They were identified as coming from the vehicle.
Okay. And what were they, and what did you do, and what were the results?
It was 4 items of debris. 2 were identified as coming from a trash bag, 2 from paper towel. Again, they were examined for hairs with characteristics of apparent decomposition. On one of the items, no human hairs were found, and the remainder, the human hairs that were found, did not exhibit characteristics of apparent decomposition.
Now, I'd like to take you to November 6th. Now, June 25th, 2009. Okay. June 25th, 2009, you received quite a bit of items of evidence, did you not?
Well, this report covers 5 different laboratory numbers, so yes, there's quite a bit of evidence.
Okay. And let's start from the beginning and work our way through. Okay. The first section shows items from the trash. Is that correct?
That's correct.
And that would have been trash recovered from the vehicle.
That's how it was identified.
Okay. And what did you do with those items? Well, actually, count the number of items and then tell the jury what you did and what your results were.
As far as items that were identified as coming from the trash, there are 12. Items that are just identified as coming from the trunk, there are 8. These are all just debris, so items that were collected, what looked like hairs and fibers were
I'm sorry,
collected.
Ms. Lowe, can you speak closer to the microphone?
Sorry. These items were collected either from trash or the trunk, as how they were identified, and these were examined for any hairs with characteristics of apparent decomposition, and none were found.
So none of the items in the trash contained any, they all came back negative. The test for that.
If hairs, some of the items actually didn't have human hairs present, but of the items that did have human hairs present, none of them exhibited characteristics of apparent decomposition.
Okay. And then you received some items from the medical examiner's office.
Right. The next laboratory number deals with items that were either from the medical examiner's office or identified as coming from the residence.
Okay. Let's start off with the medical examiner's office. What did you do with those items?
Mr. Shaw handled the hair exam portion of this. So these items, I examined any fibers that were present and compared them to known samples of the trunk liner and spare tire cover, as well as some vacuumings recovered from the vehicle to see if there were any associations, any fibers that were consistent between the two, and I did not find any.
Okay, let's break that down a second. You took fibers that were recovered from items that were found from the scene or from the medical examiner's office?
That's correct.
Okay. And these were known to be associated with Katie Marie Anthony?
That's how they're identified.
And you checked the fibers from those items and compared them to the trunk of the car?
2 fibers either comprising the trunk liner and the spare tire cover, or fibers found in vacuumings.
And there was no match between those fibers?
There are no fibers consistent between the 2, correct? Or between the sets of items.
Okay. And then you received some items from the residence, did you not?
That's correct.
Okay. And what did you do with those items?
At this point, the vacuums were not examined. Those were covered in a later report when they were resubmitted. Also, with this submission, I was asked to do a fabric comparison between the fabric portion of duct tape identified as being recovered with the remains, and the fabric portion of a piece of duct tape that was identified as coming from the residence. To do a fabric exam, first you would look to see, you're looking at the color, the construction, and the composition. Are the colors the same between the 2 pieces of fabric as well as the fibers themselves? Are they constructed in the same way, and are they made of the same types of fibers? These particular fabrics were woven, so that the fibers intersect. There are yarns that run horizontal and vertical. So I'm looking to see, do they intersect in the same way? Are they the same number of yarns per inch? And then finally, are they comprised of the same materials? In the duct tape that was identified as coming from the residence, the horizontal yarns contain both polyester and cotton, and the vertical yarns contain only polyester. When I examined the tape that was identified as coming from the scene, the horizontal yarns only contained polyester, so I didn't find that cotton component. Based on that examination, I concluded that they were actually dissimilar and not consistently coming from the same source.
Okay. And then you receive, what about the other items from the residence? Did you receive a vacuum cleaner? Did you receive some vacuum cleaners from the residence?
I did. At this point, they were not examined, and that's covered in my next report.
Okay. And why were they not examined?
They were collected months later, and they were vacuums from the residence, so I questioned whether or not anything that I would find would really be probative, but they were resubmitted at a later date, and I did examine them later.
Okay. And then you received some other items from the medical examiner's office, is that correct?
That's correct. The next submission contains items that were identified as coming from the medical examiner's office, as well as the scene.
And what did you do there?
For these items, I examined hairs and compared them to FBI laboratory identifier Q59, which was the hair mass. At this point, we're using this as a known sample.
We have the identification of which items she's speaking of.
Sure, the hair mass?
Yes.
To what? But she's talking about comparing it to something. I think Counsel
I will.
make clear to the jury what it is she's comparing it to.
Kind of slow it down so they can follow.
My apologies. Yes, sir. To scene. And you compare them to? Well, you didn't do actual comparison, did you?
To the items in this laboratory number, I did.
Okay. And what did you compare them to?
There were a number of items of clothing, debris, plastic that were identified as coming from the medical examiner's office, and then numerous pieces of plastic and a blanket, a bag, a tape, and collection paper that was identified as coming from the scene, or were identified with items recovered from the scene.
Okay. And the items that you received from the scene, what did you do with those?
These items were examined for hairs that were present. These hairs were compared to the Q59 hair mass, which again, we're using as a known sample for the victim, to determine if there were any hairs that were dissimilar to the hairs in this hair mass.
And did you find any hairs that were dissimilar?
There was one Caucasian head hair that was found on a collection paper, which was microscopically dissimilar to the hairs in the Q59 hair mass. So this hair is not consistent with coming from Kaylee Anthony.
Okay. And that hair that you found, did you then do tests from or pull hairs from crime scene investigators to eliminate them as potential contributors to that one hair that you found?
We're going to need items of evidence and identification of individuals on this issue.
I think
This
she.
approach. Ladies and gentlemen, jury, we're going to take about a 5 or 10 minute recess to take care of some matters right outside of your presence, and we will be back with you. We'll take a 5 to 10 minute recess. Okay, you may be seated. Okay, have y'all been able to come to any sort of agreement on the issues that we've been discussing?
Yes, sir. I believe we have.
Yeah, the agreement is that counsel will be able to ask the witness the names of the individuals, but the agreement is that not every individual has contact with it was tested.
Okay, ready to proceed?
Yes, sir.
All right, let's return to jury. Okay, so you recognize the presence of the jury?
Yes, sir.
Defense?
Yes, sir.
You may continue, Mr. Baez.
Thank you, Your Honor. Ms. Lowe, I think we left off that you found an unidentified Caucasian hair. One was found at the scene, correct?
One was found on FBI Q number 107, which is identified as collection paper from items from the scene.
Okay. And do you know what those items were?
Specifically, what was identified with that paper now?
Okay. Now, that prompted you to then do a further examination of other individuals who were there at the scene, correct?
That's correct.
And refer to your report on March 30th, 2008. I'm sorry, not 2000. That would be 2009.
The 2010 report?
I'm sorry, 2010. Okay. And can you tell me who the individuals were that were tested?
I can give you the names. I don't know where they were.
That's not names.
Okay. There was a head hair sample identified as coming from Robin Maynard. It's Maynard. One from Christine Mankiewicz, Mankiewiczz. Melissa Cardillo, Cardilloo. Sarah Coble, Coerbel. Carrie Wood, Wood.
Is that Kelly Wood?
Oh, I'm sorry, yes, Kelly. Gerardo Blouse, Bloise. And Jenny Welch, Welch.
Your Honor, by stipulation, both the state and defense agree that this is not a complete exhaustive list of everyone that had access to the scene.
That's correct.
Thank you.
And ma'am, were you able to identify or exclude these individuals as potential donors of this hair?
Yes, the Q107 hair was microscopically dissimilar to the head hair samples that I've previously identified, so it's not consistent with coming from any of these individuals.
So currently that hair is unidentified. You haven't done any further tests to confirm whose hair that is, correct?
It was dissimilar from the Q59 hair mass. The individuals that I've mentioned, it was also compared to the head hair sample identified as coming from Casey Anthony, and it was dissimilar to all of those known samples.
Did you compare it across anyone else other than Kaylee, Casey, and these crime scene people?
These are the known samples that I was given.
Okay, going back to your June 25th report of 2009, were there any other items that actually, I want to bring that up. Were there any other items that you received that you inspected?
And this report covers items that were identified as coming from the scene, some additional items from the vehicle, the residence, and additional items from the vehicle.
Okay. And what did you do with those items?
The items from the scene were examined again for hairs that exhibit characteristics of, items from the scene were compared to, any hairs recovered were compared to the Q59 hair mass to determine if anything was microscopically dissimilar. Aside from the Q107 hair, the hairs were either not suitable for comparison or were consistent with the Q59 hair mass.
Now, you've issued 9 different reports in this case, correct?
That's correct.
And excluding the Q59 hair mass that we know came from Kaylee from the site, how many hairs would you say you inspected in this case that did not have any signs of apparent human decomposition?
It's not a number that I count, but many of the items had hairs present, whether or not they were suitable. So there could be hundreds of hairs, and there was only the one.
Okay. So out of the potential of hundreds of hairs, you only found that one.
Oh,
That's correct.
And these are from different locations, not including the home, the car, and the site off Suburban Drive.
The items that would have been examined for hairs of apparent decomposition would have been limited to the residence of the vehicle.
And that includes Casey's entire closet.
Should not in evidence.
Sustained.
That includes the clothing items that were given to you.
They were identified as coming from Casey's closet, correct?
I don't believe I have any further questions at this time.
Cross-examination.
The one hair that counsel spent some time talking to you about, the 107 hair, you have no idea. It came from collection paper from some item, but you don't know what item.
That's correct.
You don't know what relationship it had to the scene. You just know it was identified collection paper from something from the scene.
That's correct.
And the hair that you found, which had the apparent decomposition, was reported as being found in the defendant's car trunk.
That's how it was identified, yes.
Do you know whether during the period of time between June 16th and July 15th, let me just rephrase that. You don't know during the period of June 16th to July 15th where Casey Anthony was living, do you?
No.
So you don't know whether she was living at the house where the clothes were collected. You don't know.
I don't.
No further questions.
Any redirect on those issues?
Ms. Lowe, if you had been given items from where Casey Anthony was living during those 30 days, would you have tested those?
If they were available, I could have examined them for the same reasons that I examined the other items, yes.
But you were never given anything, were you?
Yes, sir.
Okay.
May the witness be excused.
As far as the state's concerned,
Thank you, Ms. Love.
Thank you.
is she excused permanently or subject to recall? I know she probably will.
Excuse means excuse. Nobody's put any
Yes, sir.
provisional requirements.
Thank you.
All right, let's move on. That was day 25. Apparently, that was it for day 25. So
Subject to recall, but can she return back to her? Yes, she can return back home. Okay, ladies and gentlemen, this concludes our presentation for the day. As I indicated to you, I have
we are back. This one's a long one. But we're going to get here from Cindy again. Let's see.
Okay, let the record reflect that the defendant was present along with counsel for the defendant. Both sides ready to proceed.
Yeah, Cindy's taking the stand. Not
Yes, sir.
now, but today.
Quickly, remember you were supposed to do that beforehand. Okay, let's return to jury.
And I'm sorry, I can't put on the captions for this for some reason. It's not allowing me. So hopefully the audio will suffice. Day 26, Casey Anthony's trial. We're getting close to the end, I believe.
Okay, good morning, ladies and gentlemen of the jury. Did you heed all my previous admonitions? Okay, let's state recognized presence of the jury. And does the defense.
Yes, sir. We do.
Okay, Mr. Baez, you may call your first witness for the day.
Yes, sir. Defense calls Susan Mears to the stand.
You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Susan Mears, SUSAN, NEARS.
You may proceed.
Please, court. Mr. Rainey. Good morning, ladies and gentlemen. Good morning, Ms. Mears.
Good morning.
You were asked to bring in certain items of evidence so they could be introduced, correct?
Yes, sir.
And that includes defense exhibit CP, which is the Gatorade bottle,
Yes, sir.
and including the defense CR, which would be, I guess, the cardboard which the syringe was in.
I don't actually know the contents originally of the bottle. I never opened it.
And you collected the items that were inside the bottle.
Yes, sir.
Okay. And the Disney bag.
Yes, sir.
And was that brought in as well?
Yes, sir.
That the defense CO. The Disney bag.
I don't know what exhibit number it is. I'm sorry.
May I approach the witness briefly, Judge?
Yes, sir.
Your Honor, I believe you have a stipulation that the items of evidence discussed by Dr. Ray the state has no objection to the introduction of those items.
I have no objection to the introduction of the ones that he's marked for identification. There was testimony about a syringe, and I don't believe that is contained within those packages.
Do you have the syringe, or does the Orange County Sheriff's Office have it? Or,
I have what I believe might be the syringe with me, yes.
okay. Your Honor, I believe there's no objection from the state to introduce this item into evidence as well. Hasn't been marked yet.
Let's get it marked so we know what we're talking about. Okay, would you hand them out to the clerk? I think you had some more that you had offered, but you had not handed to the clerk so she can receive those items in evidence. And there being no objections from the state, they will be received in evidence as defense exhibits.
CA will become exhibit number 34, CR will become exhibit number 35, CO will become exhibit number 36, and DE will become exhibit number 37.
We have no further questions for Ms. Mears.
Cross-examination.
None.
Thank you, Ms. Mears. You may be excused. The defense may call the next witness.
We would call Stephen Shaw, Your Honor.
Raise your hand, please. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
My name is Stephen Shaw, Stephen Shaw.
You may proceed.
Good morning, Mr. Shaw.
Morning.
You have since testified in this case, have you not?
I have, yes.
Okay. Your Honor, I would move to recertify Mr. Shaw as an expert in trace evidence, hair and fibers.
Okay. Mr. Shaw will be again accepted as an expert in those areas tendered.
Mr. Shaw, I'd like to show you items defense exhibit DC, DB, DA, CZ, CY, and CX. Mr. Shaw, do you recognize those photos?
I do recognize these.
Okay. And are they the photos taken of certain hairs that you have when you conducted your new study?
These are photographs of antemortem hairs stored in various conditions during my study.
And this is the study that you conducted after you were deposed in this case?
That's correct.
Okay. And when you say antemortem, you mean hairs taken from living people?
Correct. Hairs removed from living individuals.
I'd like for you to look at them and make sure that they are a fair and accurate representation of the photographs that you have taken of the hairs.
Yes, I recognize all these as photographs that I took during the research study.
And they are a fair and accurate representation of such?
Yes.
Okay. Your Honor, at this time, we would move these items into evidence.
You may.
Your Honor, at this time,
No
I would
objection
move...
overruled.
Sorry.
Go ahead, Mr. Baez.
Yes, sir. At this time, we would move these items into evidence.
They will be received in evidence as defenses.
Now, Mr. Shaw, you had, I guess, many hairs in the study, right?
I did. I had 600 hairs collected from 15 living individuals.
Okay. And when you did this study, you, of course, were trying to see if the darkening band could be developed from living people.
Sustain. Rephrase the question.
Yes, sir. One of your goals was to see if you can duplicate any banding, correct?
Sustain. Rephrase the question.
What was the purpose of your study, sir?
Purpose of my study was really inspired, as I mentioned previously, by a thesis at John Jay College had presented or I had come across. And during that study, they had taken hairs and submerged them in water or put them in water as well as in soil. And they suggested additional studies be done to simulate these conditions and other conditions and compare them to hairs known to be removed from post-mortem individuals. So that's what I did. So I put hairs from living individuals in various conditions, under various conditions, trying to see if indeed I could get post-mortem banding from these hairs.
And the person that suggested this was the person who was having their thesis done, correct?
That's correct.
Was it a master's thesis or a...
I believe it was a master's thesis.
Okay, so someone was trying to get their master's degree. They wrote a thesis. They came up with these new findings.
Just a second. You hadn't finished the question? Mr. Shaw, before you answer the question, wait for me to tell you to answer. Finish the question.
Sure. They came up with these new findings, and you as a scientist kind of wanted to expand upon that. Would that be a fair characterization, or do you have another characterization?
Sustain is the compound.
Rephrase
the question.
Yes, sir. Was the purpose of your study to expand on that prior study?
Yes, it was.
Okay. Now, the FBI has issues when they testify on post-mortem demanding exhibits. Do you recognize this exhibit, sir? Those states and vote.
I do recognize that, yes.
And so you can demonstrate to the jury what post-mortem banding looks like.
Yes, that's correct.
May I publish this to the jury, Judge?
Yes, you may. That was what?
States and vote.
You know, that's identification. I mean, is it in evidence?
This was demolished.
Okay. All right.
Your Honor, at this time, I would like to publish to the jury states evidence 123.
You may.
Sorry, not 39.
You may.
Defense, is it 39? You said states, 39.
Apologize if I said that. Okay. Defense 39. Can you tell us what we're looking at here? Sorry. Can everyone see that?
Counsel, expand it out so the witness can see the entire slide so we can identify. There we go. Thank you.
Can you tell us what we're looking at, Mr. Shaw?
This is a hair that was stored in water for 17 days. So it's a hair collected from a living individual and then stored in water for 17 days. And this is one of the hairs, as was another approximately 193 hairs or 190 hairs approximately that were put into the test that I spoke about earlier in my previous testimony. And so this is one of the hairs that was initially identified as post-mortem banding by one of the examiners that took that test in their initial analysis.
And what they did was, they identified this area here as post-mortem root banding, or is that the area?
I would assume that's the area.
Okay. And they mistook it for something like in this photograph?
Objection. Counsel used the word they since background evidence.
Sustain.
The examiner mistook the characteristics, which the characteristics appear similar in this photograph.
The examiner identified it as initially as post-mortem banding in their initial analysis.
Okay. And then, of course, another examiner had a different opinion.
That's correct. The other examiner did not identify it in their initial analysis, and when the two conferred, with the confirmed results, they excluded this hair.
Okay. And the both examiners were aware that this was a study and what the hypothesis of the study was, correct?
Objection. Leading.
Sustain.
Were both of these examiners aware of the study, that it was a study?
Objection. Leading. Same question.
Sustain.
I think it's an open-ended question. What knowledge did the individuals have who examined this hair about what they were doing?
They knew that it was a test. They knew that I had been conducting a study on environmental exposure to hairs. But that's all they knew. They didn't know, obviously, the answers to the test. They didn't know if I put any post-mortem actual hairs from deceased individuals into the test. So there's over 200 hairs that they examined. In their initial analysis, each examiner correctly identified all the post-mortem banded hairs. Examiner 1 did identify one of the antemortem hairs as banded. Examiner 2 did identify a different antemortem hair as banded in their initial analysis. They then had a confirmed results answer sheet where they excluded those two antemortem hairs and included all the post-mortem banded hairs.
Now, was it presented to them? Well, let me rephrase that. They didn't think that this was an actual case that they were working on. They weren't given hair like it came in from evidence with an evidence package and things like that. They were fully aware that they were being tested.
That's correct. They knew it was a test.
Okay. Now, I'd like to show you defense evidence 41. What are we looking at here, sir?
This is another antemortem hair, so another hair removed from a living individual submerged in water for 17 days. And this is the hair that examiner 2 initially identified as a banded hair in their initial analysis.
If I can zoom in a little bit, I don't know if and you can observe through this photograph the darkening area here, correct?
Correct.
And one of the examiners made a mistake with this one initially.
Yes, that's correct.
Does everyone have an opportunity? And they would be, this photograph somewhat resembles some of the characteristics in these photographs, do they not?
I believe they're clearly different.
Okay. You do, but one of the examiners does not.
In their initial analysis, that's true, but through their discussion and additional examination, they excluded this hair as post-mortem banding.
And what are we looking at here, sir?
This is another hair removed from a living individual and stored or buried in potting soil for 100 days.
And is there some apparent decomposition beginning to appear on this hair?
Yes.
And where would that be demonstrated? Can you show that for us?
Yes, there's some striations in this area.
If you touch, okay, got it.
In this area here.
Got it. I'm going to now show you defense 43. What are we looking at here?
This is a hair from a living individual buried in potting soil for approximately 100 days, or for 100 days.
And are there apparent decomposition beginning to start on this hair?
Yes, there is.
And can you show us where?
Yes, in this, sorry, in this area here.
I'm going to now show you defense 40. What are we looking at here?
That is another hair removed from a living individual that was submerged in water for 17 days.
And what's happening to it? What do you notice? Does it, actually, let me rephrase that. Does it show any apparent decomposition?
There was some apparent decomposition in this hair as well.
Okay. And can you show us where?
In this area.
And what about the roots? Is that normal, the darkening there? Right over here?
It can be. It can be dark at that end from living individuals.
Okay. So that's normal. That has nothing to do with what you might consider post-mortem mood banding.
That could be normal.
Okay. Oh, is there any other ongoing studies at the FBI on this type, on different environmental conditions for hair?
Oh, from living individuals?
Yes.
No, not normal. No, there's not.
Okay. So the only, how many studies are you aware of that have been done on environmental conditions affecting hairs?
I'm aware of 3 studies.
3. And is this an ongoing area of study for hair scientists?
Yes, and I am conducting research still in this area. It's a way to build on post-mortem banding in that discipline.
Okay. Now, sir, I'd like to direct you to your report that you wrote on January 27, 2009. Do you have that report with you?
I do. May I refer to it?
Yes.
Sure.
08121 3001. Q number 59, 60, and 62 to 64, 66. Sure. May I have a moment, Your Honor?
You may.
May I unpublish this, Judge? The info? Okay. Yeah, that's what I was. All right, Mr. Shaw, can you tell us what you were asked to do on this date, sir?
On in this report, I reported on hairs and fibers that were recovered from a hair mass, item identified to me as debris from the skull, as well as 3 pieces of duct tape.
Okay. And what were your findings?
Give the evidence numbers just so the record's clear. Which items.
Sure. Q59, the hair mass, and then Q62. Evidence 302. 271 is the hair mass.
The other one, 302 is the tape.
Right. Can you tell us what your results were in those examinations, sir?
Yes, there were no hairs suitable for meaningful microscopical comparisons purposes found on the duct tape that were also microscopically dissimilar to the head hairs recovered from the hair mass. In other words, there were head hairs, Caucasian head hairs on the duct tape. All these Caucasian head hairs were consistent with the hairs found in the hair mass.
And did you also recover textile fibers?
I did, yes.
And what was done with those?
Those were preserved on glass microscope slides.
Okay. Did you conduct any examinations on those textile fibers?
I did not.
I have no further questions for this witness.
Cross-examination.
So just so no one is confused, all of the hairs on the tape were consistent with coming from the same person that the hair mass came from.
That's correct. All the hairs suitable for comparison were consistent with that.
Now, the items that Mr. Baez showed you a moment ago, those are a small selection of some slides that you prepared for a PowerPoint that you discussed during your direct testimony but didn't show, correct?
Some of those, yes.
Now, you did studies of hairs decomposing in cars and car trunks, correct?
That's correct.
But none of the photographs that Mr. Baez just showed you dealt with those hairs, did they?
That's correct.
This time, Your Honor, I believe that it takes exhibit QL, which is the PowerPoint that was discussed during his direct testimony during the state's case.
Okay. You received an evidence that states
Yeah, just go ahead and close it. While she's doing that, Mr. Trout, would it be helpful in explaining the entirety of your study to utilize the PowerPoint to explain it to the jury?
Yes, sure.
Once she's done, we request permission to publish that.
You may.
Let me publish it to the witness and make sure that the, which one of these, should we start with, can you see the screen here?
I can now,
Okay,
yes.
should we start with figure 1? Which would be best to start with?
Yes.
All right, let's start with figure 1. All right, may I publish to the jury?
You may.
And Mr. Trout, if you just want to let Mr. Perez know when to advance to the next slide, we'll want to next kind of explain what we're looking at here and what it means.
Sure. As I said, there were 600 hairs from 15 living individuals used in this study.
Announced. You may continue.
So this is a representation of some of those hairs, photographs taken before and after their exposure. So you can see these are hairs stored indoors on a windowsill for 233 days. You can see on the left-hand side is the hair before it was exposed, and on the right-hand side is the hair after it was exposed. So there is some apparent discoloration by sitting in the windowsill, it appears, but there's no apparent decomposition in these hairs.
And the basic difference in the appearance of these two hairs from the before is the different color hair. Is that correct?
Of the
before pictures.
The before is the same hair as the after. So above is from one individual. The first two slides at the upper left-hand quadrant and upper right-hand quadrant, that is one individual, and it's the same hair. So it's the hair before exposure and the hair after exposure. In the lower half of this page, you have hair from a different individual, a single hair, and it's the same hair. The hair before it was exposed on the left-hand side, and the hair after it was exposed on the right-hand side.
My point was that these two people obviously have different color hair, which is why one of the hairs appears very light, the other darker.
That's correct.
So in interpreting something like post-mortem banding or any kind of decomp, you have to take into account what color the hair was originally and then how it changed. Correct?
No, I don't think you need to know the color of the hair in order to identify it as post-mortem banding. You don't need to know what color it was beforehand.
Next slide.
Next slide.
Next slide, please.
This is additional hairs stored on the dash of a vehicle. So this vehicle was parked in direct sunlight throughout the time period. So in this area, about 202 days in direct sunlight and not used during that time period. So you see the before is on the left-hand side, and the after is on the right-hand side.
Now, this vehicle sat unused, correct?
Correct.
And during what months was this?
This started in August and continued on for approximately 7 months, 6.7 months approximately.
And the hairs exposed in that regard, do they show any changes due to decomposition?
No, there was no apparent decompositional changes in these hairs at all.
You ready for the next slide?
Yes, please.
Next slide, please. Okay. How about these?
These were hairs stored in the same vehicle, but in the trunk of that vehicle during the same time period and for the same number of days as I mentioned earlier. On the left-hand side, you have hairs before, and on the right-hand side, you have the hairs after their exposure. So there was no apparent decompositional changes here either.
And this was in a vehicle trunk for almost 7 months.
That's correct.
And you said this was was it outside in the sun or was it in the shade?
This vehicle was parked in a non-shaded area.
So direct sunlight.
Direct sunlight when there were sunny days.
For 7 months.
For approximately 7 months.
And no change.
Correct.
Next slide, please.
These are hairs stored outdoors in a grass area, and this grass area was in an area where it could receive direct sunlight. And there was, as you can see in the upper half, the picture before and then the picture after, and you can see there is some change there, and some slight darkening and longitudinal striations at the proximal end or root end in the upper quadrant. In the lower half are additional hairs. Outdoors, what happened a lot was the roots were actually missing in many of the hairs, and it looked like there was apparent insect activity to the hairs lying outdoors. And so that's what it appears happened on the lower half of this page. There's the before on the left side and the after on the right side. You can see the root is completely missing.
Did you find some of that also in the Q59 hairs, the ones from the hair mass where the root was missing or badly decomposed?
There were some roots missing, yes.
Okay. Next slide.
Next slide, yes.
Next slide, please. All right.
This is a hair stored outdoors in a wooded area, so it did not receive direct sunlight. It was in a shaded area and it was stored for approximately 14 days or 2 weeks. And there is some apparent decomposition, as you can see, at the root end, but no post-mortem banding.
Explain to the jury why it is, and I'm circling this darkened portions here. Why is that not post-mortem root banding? From an expert's perspective, how do you exclude that as post-mortem root banding?
For post-mortem banding, you need to have an opaque band just above the roots. And so the root should be intact, at least mostly intact, and you should have a band above that root. In this case, the root itself appears to be decomposing. So the soft tissue of the root itself appears to be decomposing.
It takes a great deal of training to understand the subtle differences between various types of decomposition artifacts, doesn't it?
It does take some training, and also the microscope itself is a very useful tool, obviously, not just the photographs that you're seeing in two-dimensional, but using a microscope and focusing up and down on the hair, you can see where the hair begins to get its shape. So you can see that soft tissue of the root, and the hair doesn't have its shape at that point. But as you move up and just above the root, you can see that the hair is beginning to get its shape by focusing up and down on the microscope itself. You get more of a three-dimensional picture. And so that's what you're looking for. You're looking for that opaque band above the soft tissue of the root.
And is that one of the essential aspects of postmortem root banding, is the placement of the band in that very distinct area?
Yes, it is.
And without a three-dimensional stereo microscope, is it really possible to appreciate that distinction?
Not fully, no.
Okay, we go on to the next slide.
This is another hair stored outdoors in a wooded area for 14 days. And there was, as you can see, the before shot and then the 3 after shots after that. So there was some apparent decomposition with this hair as well, but no postmortem banding.
Next slide, please.
These are additional hairs, or this is an additional hair stored outdoors in a grass area that did receive some direct sunlight for approximately 107 days. And you can see some apparent decomposition in that soft tissue area of the root.
That would be, I'm circling this area here. Is that what we're talking about?
Yes.
But that's not postmortem root banding.
No.
Next slide, please.
This is an additional hair stored outdoors in a grass area again for 107 days. And you can see there is some apparent decomposition in this area. It's more, as you go up in magnification, you can see it's more actually longitudinal striations. So not really a band in that area, but more darkening and longitudinal stripes, if you will, in the hair.
Again, is that one of those subtle distinctions that with training and the right equipment, you can appreciate?
Yes.
Next slide, please.
This is two additional hairs stored outdoors in a wooded area. Before on the left-hand side, after on the right-hand side. You can see in this particular hair the apparent decomposition in the soft tissue of the root. And in the lower quadrant, you can see the root itself appears really to sort of be shriveling in that particular, in this lower half quadrant.
Is that the portion I just circled?
Yes.
Okay. Next slide, please.
This is a hair stored submerged in water for 17 days. And you can see there is some considerable change in the root, in the proximal ends. And so there's darkening in this area, but it is too far down into the root, into the soft tissue of the hair.
Is this one of the hairs that Mr. Byers was asking you about, the ones that one of the analysts originally thought was banding but then wasn't?
No, it's not.
This is different. So this hair, even though it does show that darkening, both of the analysts excluded that as postmortem banding.
Correct.
All right, next slide, please. Get the annotation out of there. All right, go ahead.
This is an additional hair submerged in water for 100 days. And there are some longitudinal striations in this area here. And as you magnify and see it at higher magnification, you can see striations in that area.
All right, next slide, please.
This is a hair submerged in water for 100 days. You can see some significant change in the root, in the size of the root itself, the soft tissue. And there is some darkening also in this area. And as you go up into magnification, you can see it's darkened, especially on the outside edges, but not an opaque band in that area.
Next slide, please.
This is a hair submerged in water for 100 days. And you can see some changes with this hair as well.
But not banding.
No postmortem banding.
Next slide.
This is hair submerged in water for 100 days. Some slight changes to those hairs, but no postmortem banding.
Next slide, please.
This is a hair buried in potting soil for 17 days. You can see some pretty significant changes again in the soft tissue, but no postmortem banding was observed.
Now this darkened area here, again, that's not postmortem banding.
No,
It's a little dark. Next slide, please.
This is another hair buried in potting soil for 17 days. And again, a lot of decomposition as far as the soft tissue of the root. And you can see just how much of that root soft tissue is missing, but there's no postmortem banding there.
Next slide.
This is a hair buried in potting soil for 100 days. And again, the soft tissue decomposes, or apparently decomposes, and giving you a darkened area at the end of the root.
But not banding.
But not banding.
Next slide.
Another hair buried in potting soil. Again, some changes at the root end, including some darkening and striations at this root end, but no postmortem banding.
All right, we go on to the next file. Pardon me. Let me hold on a second. Let me just unpublish for a moment while we get that set up, just in case. Go ahead, figure 2. All right, tell us about this. This first slide, this is one of the photographs that Mr. Byers asked you about on direct, right?
It is, yes.
Okay. Explain to us why that isn't postmortem banding.
Yeah, for one thing, the band itself is much longer than it should be for postmortem banding. So the darkening itself is much longer. There's also very little to no tissue intact on the end of the root itself.
Now, again, looking at this under a 3D microscope with the ability to zoom in, can you better appreciate exactly where the root starts and ends and that evaluation?
Yeah, as far as where the soft tissue starts and ends, especially, it's much better appreciated using a microscope in three-dimensional and focusing up and down.
But this hair was stored in water, right?
This hair was stored in water for 17 days.
This is not one of the hairs that was stored in a trunk or in a car.
That's correct.
Next slide, please. Is this one of the other ones that Mr. Bias asked you about?
Yes, this is the other hair that one of the examiners initially identified as postmortem banded.
Why is that not postmortem banding?
This one is too far down into the soft tissue of the hair.
So where would postmortem banding be on this hair? If you can tell from the photograph, if you can't without the microscope, I understand.
You really can't, without the microscope, determine exactly where it would be, but it should be further up. You can see a little bit of how the hair is changing its shape in this area and begins to get a shape here. At least it appears so in the photograph. But to really appreciate that, you do need a microscope.
And the difference between the importance of that difference is because the hair, in fact, changes at that period from being soft tissue to being hard. Is it keratin? Do I have that right?
It is right. It's not fully keratinized. The idea behind postmortem banding is that the follicle protects the soft tissue. So the soft tissue is further down into the follicle and it's protected. Then above where you see postmortem banding, the hair is completely keratinized. So it's not susceptible or as susceptible to decomposition. So what you get is this one localized area that is susceptible to decomposition. So you get this specific band.
So it's the interior is soft, so it's susceptible to decomposition, but the outside is hard. Did I understand you correctly?
No, no. The soft tissue, what happens is the hair grows, it continues to harden and develop as it grows and moves up the follicle. And just above where you see that band is where the hair appears to completely harden and become permanent and dead. Where you see the bands is the hair is not completely formed, it's not completely hardened, it's not completely keratinized. Below that band, the soft tissue itself, the reason that it's thought not to decompose with what we see in postmortem banding is because it's further down to the follicle and better protected.
All right, next slide, please. Do the annotation. All right, tell us about this one.
This is a hair removed from postmortem from a cadaver stored outside on the ground surface, and so the banded area is here. And this is one of the hairs used in the test.
And that is what you look for under, again, with the aid of the 3D microscope of postmortem banding.
That's correct.
Next slide, please.
This is another hair that was used in the test. This is removed postmortem from a cadaver stored outside on the ground.
Now, this does appear to have a bit of a striation going farther into the root. Why does that not exclude it as postmortem banding?
Because you still have a very distinct area where the hair is banded, just above the soft tissue.
So that's what you're looking for?
Yes.
Next slide, please.
This is another hair that was used in the test, removed postmortem from a cadaver stored inside a house.
Now, in addition to the postmortem banding, is there also other apparent decomposition of this hair?
I don't know that this is apparent decomposition. It could be just a dark area in the person's hair.
And again, is that something you can't determine without having it under the microscope, the ability to manipulate it, zoom in, zoom out, and really look at it?
Yeah, even with a microscope, I don't know that you could determine that was apparent decomposition. It depends. You may be able to, but it may also just be an artifact of that person's hair sample.
Next slide, please.
This is another hair removed postmortem from a cadaver stored in a vehicle.
All right. Next slide, please.
Another hair used in the test, removed postmortem from a cadaver stored inside of a house.
Next slide, please.
Another hair removed postmortem from a cadaver stored outside on the ground surface.
Next slide, please.
Another hair used in this test, removed postmortem from a cadaver stored outside on the ground surface.
Now, is each one of these hairs from a different cadaver, or there are some that are multiple hairs from the same cadaver?
There are some hairs from, there were 5 cadavers used in this study, so I removed hairs from 5 different cadavers, so some of these are from the same cadaver.
All right. Next slide, please.
Another hair removed postmortem from cadaver that was stored outside on the ground surface.
Right. Next slide, please.
Again, a hair used in this test, removed postmortem from cadaver stored outside on the ground surface.
Next slide, please.
This is another hair removed postmortem from a cadaver stored outside on the ground surface.
Next slide, please.
Another postmortem banded hair removed postmortem from a cadaver stored in a vehicle.
Next slide, please.
Another hair removed postmortem from a cadaver stored inside a house, and these are all hairs that we use in the test.
All right. And these are all evidences of what happens to they're evidence of what we call postmortem root banding.
Yes.
All right. I believe we have perhaps one other slide. Or whatever set of slides. All right. Okay. Again, these are examples again of the hairs from living people that were stored under various conditions and what you see.
Right. Yes, and this is hair that we discussed earlier. There are some apparent decomposition submerged in water, but not postmortem banding.
Not banding. Is there another slide?
This again is one of the hairs that we discussed earlier, buried in potting soil for 100 days.
And again, we see some changes, but not banding.
Correct.
Next. Yeah, error actually workforce on that one. Again, the condition is indicated in the slide. Some changes, but not banding.
Correct.
Next slide. Get rid of the annotation. How about this one?
A hair removed from a living individual and buried in potting soil for 100 days. So there is what may be some change in this area. I don't recall if I did identify that as change, but it appears there may be
some change, but certainly not banding.
Correct.
Next slide. Again. Thank you. Of all the slides and all the various environmental conditions that you have exposed these hairs to, based on the slide presentation we've seen, did you have any hairs which were stored in a car in a vehicle that displayed any kind of darkening that might be similar to or mistaken for post-mortem banning from
No.
vehicles?
No.
No further questions.
Redirect on those issues?
Mr. Shaw, the hairs that you tested in the trunk, did you put them in garbage?
No, I did not.
Did you have any that were in garbage?
No, I did not.
I know. I noticed in your PowerPoint that all of the hairs taken from living people have the number of days before they're collected, correct?
That's correct.
But all of the slides that contain hairs that come from post-mortem individuals don't have any dates. Is that correct?
That's correct. That wasn't put on the slides themselves.
All right, let's talk about these for a second. This hair that was outside of a house on the ground surface, how long was it there?
Can I refer to my notes for that?
Absolutely, absolutely.
Okay, I'm sorry. I can't see the slides.
I'm
so
sorry.
not sure.
May I publish to the witness, Your Honor? May I also publish to the jury? Your Honor?
You may.
Okay, let's go back for a second. Okay. What I meant to say, I'm sorry, I apologize. The jury didn't have a chance to see what I was referring to. Every slide that you have from a live person says the exact days on each slide, correct?
That's correct.
And we can go to the next slide. And every slide that you have from a deceased person does not have how many days when that hair was collected, correct?
That's correct.
Okay, let's start with this hair. How long was this hair outside on the ground surface?
That hair was placed in January the 27th of 04, and the hair was collected on March the 5th of 04.
So this is 3 months.
More
More or less 3 months?
approximately around 2.5 months.
Okay. And these were in Tennessee in the wintertime,
They were, yes.
which are completely different environmental conditions than in this case, right?
I'm sorry. Then
The environmental conditions of which this hair was exposed to are completely different. Tennessee in the wintertime is much colder than Florida in the summertime, right?
I would expect so, yes.
Okay. So the environmental conditions that this hair was exposed to are completely different than that which would be in this case.
Right. The outside conditions, yes, are.
And what about this hair?
This hair was placed on January the 27th of 04, and the hair was collected on February the 26th of 04, so approximately a month.
A month. And this was also Tennessee in the wintertime?
Yes.
Completely different than in this case. The conditions, the environmental conditions.
Complete different temperatures than I would expect in June, yes, in Florida.
Next one. Okay, we have this one stored inside a house. How long was this one in a house?
For approximately 1 month.
Okay. Do you know if they had heating in the house or air conditioning?
I don't.
Okay. And was this also in Tennessee in the wintertime?
Yes.
This one stored in a vehicle. How long was it in there?
Placed February the 28th of 05 and collected March the 16th of 05, so a little less than a month.
A little less than a month. Was this also in Tennessee in the wintertime?
Yes, it was.
And the car was outdoors. It wasn't inside a garage or anything, was it?
Correct. That's right.
Completely different environmental conditions than in this case.
Colder conditions than I would expect in the summer in Florida.
Next slide. Same thing with this one for the house? How
Yes.
long? How
Yes.
long?
Approximately 2 weeks.
Okay. And you don't know the conditions or the temperature of the house or anything like that?
No, I don't.
And of course, this was different environmental conditions than in this case.
Yes.
And this one, sir.
This hair was placed January 27th of 04 and collected February 18th of 04.
It's approximately a month.
A couple weeks, 2 or 3 weeks.
Okay. And this was also Tennessee in the wintertime.
Yes, it was.
Completely different than this case.
Different environmental conditions than I would expect in the summer. Yes.
Thank you, sir. What about this one?
This hair was stored in February for approximately 1 month.
Okay. Same environmental conditions, Tennessee in the wintertime.
That's correct.
Okay, next. And what about this one?
This hair was stored outside surface for 4 days.
Okay. And where was this? Tennessee in the wintertime as well?
Yes.
Next. What about this one?
This hair was stored in 04 for a little over a month in Tennessee.
Okay. And the next one? What about this one?
This hair was stored for approximately a month outside surface in Tennessee.
Okay. All right. Did your findings show that you got different reactions from the hairs based on different environmental conditions?
With the research study, yes.
Okay. And there is absolutely no way for you to replicate the exact environmental conditions that were the Q12 hair in this case.
Overruled.
I did not replicate all the conditions in this case. I'm not even aware of all the conditions in this case.
In fact, even if you were, you probably couldn't, right?
I don't understand.
If you knew more facts about this case, you still don't know how long that hair was there.
That's correct.
In fact, this hair could have been there for months.
Could have been, right.
And exposed to any number of environmental conditions.
Right, I don't know.
Okay. And of course, one day you hope to be able to determine what exact indicators come from a deceased person. Do you not in your studies?
I'm not sure I understand
I'm
that.
sure I'll rephrase the question. Do you as a scientist hope to one day be able to look at a hair and be able to determine that it came from a dead person?
Well, post-mortem banding is a well-established science. It's based on examining hairs from living individuals, examining hairs from deceased individuals. It's based primarily on experience of examiners throughout our field. And so it is well-established. The research is there to learn more. And so I wouldn't say I'm hoping to do anything. I'm just trying to learn more. And that's what this research was aimed at, gathering additional information.
But the science as it is right now is you cannot say that a specific hair, without knowing where it came from a dead person, correct?
We can't say that absolutely, right?
Okay. And you hope to one day, with all of your studies and the advancement of science, be able to determine that one day, right?
I wouldn't say I hope to do that. No, I just want to learn. We want to know as much information as we can about it, and whatever information that gives us, it makes us a better forensic scientist.
Wouldn't that knowledge assist you though? I mean, wouldn't you like to know one day, looking at a hair and be able to say, okay, this indicates that this came from a dead person?
Not necessarily. I mean, if we were able to replicate it, I did try to replicate post-mortem banding in this case. I mean, I put it in potting soil where I thought decomposition could be high. I put it in vehicles for a long period of time, intentionally parking them in direct sunlight, seeing if I could get post-mortem banding. So my intentions were to put it in conditions that I thought were conducive to decomposition. So if we saw post-mortem banding, then we would know, hey, under these certain conditions, we can get post-mortem banding. But I didn't see that.
My question, sir, is not to diminish the importance of your study. I understand that. My question is you want to be able to learn more as a scientist and to be able to give definitive answers in the advancement with more experiments, correct?
Yes, we do want to learn more. We want to know as much about it as possible. But I wouldn't say that I want to be able to say post-mortem banding only comes from deceased individuals. That's not the goal. The goal is to learn more about post-mortem banding.
And you would also like to learn more as to what environmental conditions create what indicators in hair, correct? I mean, you'd like to learn more. You don't want to just use your study in the thesis, the master's thesis, correct?
Sure, you want to continue to build on every discipline.
And perhaps one day the science will be sophisticated enough to be able to establish exactly what environmental conditions have what effects on an individual's hair, correct? Exactly.
As I said, I believe it is already well established. But yeah, we're trying to learn and gain additional information.
And this is well established through your experiments and through the experiments from the student getting her master's degree.
No, this is well established because of experience of examiners in our field. And again, that's examining hairs. We deal with homicide cases routinely. And so we examine hairs from deceased individuals often.
My question, sir, relates to the environmental conditions.
Even in casework, we have hairs, in cases throughout different locations in cases that are exposed to environmental conditions. And I have yet, in my experience, found a hair that I've not been able to associate with post-mortem banding that I've not been able to associate to a deceased individual.
And the examiner who misidentified one of these hairs, they can't make that statement in a court of law, can they?
Asked and answered argumentative.
Sustained as argumentative.
I have no further questions.
Any recrosses to those issues?
I do, briefly. The studies that you base your opinions on aren't just these hairs from Tennessee, correct?
That's correct.
I mean, you use these as an example, but the literature contains studies of hairs from many different areas of the country under many different environmental conditions. Isn't that correct?
Overruled.
There are publications with images of banding. But, again, it's based also on experience in receiving cases all over the world, really.
And to this point, the only environmental condition that has consistently been found to lead to postmortem banding is the attachment of the hair to a decomposing body. At this point, that's where the science is, correct?
That's correct.
No further questions.
Mr. Shaw, you did this study because you wanted to learn more, not because you had a little extra time on your hands, did you?
Objection, asked and answered.
Sustained.
Did you conduct this study because you wanted to learn more?
Sustained.
I have no further questions.
May the witness be excused.
State's concerned.
Defense.
Yes, sir.
Thank you, Mr. Shaw. You may be excused. Thank you. Okay, members of the jury, 15-minute recess and special recess. Special, 20 minutes till hour. Okay, let the record reflect that the defendant is present along with counsel for the defendant, assistant state attorneys. Both sides ready to proceed? Who will be the defense's next witness? The jury. Okay, state recognized person of jury. Defense.
Yes, Your Honor.
Okay, Sims, you may call your witness.
Your Honor, we would call Dr. Barry Logan.
You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help God.
I do. My name is Dr. Barry Logan, spelled Logan.
May it please the court?
You may proceed.
Thank you. Dr. Logan, can you tell us, please, your occupation?
I'm a forensic toxicologist and analytical chemist.
Okay, and you may need to get a little closer to the mic. I'm missing some of the words here.
Okay.
Could you repeat again what you do?
I'm a forensic toxicologist and analytical chemist.
All right. And can you give us the benefit of your education?
I have a bachelor's degree in chemistry and a PhD in forensic toxicology, both from the University of Glasgow in Scotland. I subsequently had postdoctoral experience at the University of Tennessee in Memphis, Tennessee.
You didn't get the accent, I take it.
No, this is not a Tennessee accent.
All right. How many years did you study at the University of Glasgow chemistry?
4 years.
And can you tell me whether or not you graduated with honors?
I did.
All right. And what board certifications do you hold?
I'm certified by the American Board of Forensic Toxicologists.
And can you describe that board for me, if you would?
It's a professional certification board that evaluates the education and experience qualifications of people who practice in the field. It determines if they're qualified to take an examination. If so, you take the examination, and if you pass the examination, you're certified as a board-certified toxicologist.
And what is a toxicologist?
A toxicologist is somebody who studies, well, toxicology in general is the study of drugs, poisons, chemicals, and their adverse effects on organisms. Forensic toxicology deals specifically with the medical legal consequences of a person's exposure to or ingestion of drugs and chemicals.
Are you a forensic toxicologist?
Yes, I am.
All right. And how long have you practiced forensic toxicology?
Approximately 27 years.
All right. Are you an assistant professor within a university?
I have an appointment as a clinical assistant professor at the University of Washington.
All right. And can you tell me whether or not you have any background in gas chromatograph mass spectrometry?
I do.
And what is that background?
It was part of my training when I was in both undergraduate and graduate school. Subsequently, it's a technique that I use basically on a daily basis for the analysis of drugs and poisons in biological fluids and tissues in death investigation or human performance type casework.
All right. And approximately how many times have you conducted these tests over the last 27 years? Utilizing this equipment?
Thousands. Basically on a daily basis. I either, earlier in my career, performed these tests myself, or laterally, I review the data from those tests performed by other scientists in my laboratory.
All right. And can you tell me whether or not you teach or have taught gas chromatograph mass spectrometry?
I do. I currently teach it to students at Arcadia University in Philadelphia. I've also taught it at the University of Washington and the University of Tennessee.
All right. And with regard to, I'm going to call it GCMS just to expedite things here. When you're using this equipment, are you testing tissue, fluids, and have you tested breath?
For gas chromatography, I've tested, yes, actually, tissues, fluid, and breath.
Okay. And are you familiar with cryotrapping?
Yes.
All right. And can you tell me your background with respect to cryotrapping?
It's a particular application of the technique called GCMS. It's a way to concentrate or amplify the contents of a sample to make them detectable.
All right. And what's your background in that?
When I was in graduate school, I participated in a project where we were examining chemicals that were present in automobile exhaust. So these chemicals were collected using a variety of different means, including collection on sorbent traps and in mylar or bags. And the contents of the bags were then injected into the GCMS, or introduced into the GCMS, into the cryotrapping mechanism, where the chemicals are condensed out and then introduced into the GCMS.
All right. And doctor, can you tell me, please, whether or not you're a reviewer for any professional journals? And if so, A, what is a reviewer, and B, what journals?
I am a reviewer for a number of journals, including Journal of Forensic Sciences, Journal of Analytical Toxicology, Analytical Chemistry, A reviewer is somebody who participates in the peer review process. So if somebody writes an article, does some research and writes a paper, and then submits it to the journal for publication, the editor of the journal sends that article out to people who practice in the field, who are familiar with the techniques, who provide some review and critique of it, either suggesting ways it could be improved or saying that it is suitable for publication. And based on the reviewer's input, the editor would decide whether or not to publish the article.
All right. And who is your current employer?
I work for a company called NMS Labs in Willow Grove, Pennsylvania.
And can you describe what you do for NMS Labs?
I'm the National Director of Forensic Services for NMS Labs. NMS Labs is one of the largest independent forensic laboratories in the United States. We do forensic testing for coroners, medical examiners, law enforcement agencies in all 50 states. My specific responsibilities as National Director of Forensic Services are to oversee the toxicologists, the professional board-certified toxicologists who review the data, review the results, work with our clients, answer client questions, help with the interpretation of results. I also participate in the process by which we determine what new tests we ought to develop to serve that client community, how the tests are to be validated and verified before they're put into production. I also consult on medical legal cases, either civil cases or criminal cases, where I'm asked to write a report and provide testimony. These are my principal responsibilities.
Do you also work with a nonprofit organization in your capacity as the director of the lab?
That's really a separate responsibility that I took on last year. I accepted a position as executive director of the Frederick Readers Family Renaissance Foundation, which is an educational nonprofit that specializes in forensic science education for both graduate students as well as to introduce high school students to forensic science.
All right, and you mentioned that you do consulting work. When you do consulting work and money is paid for the consulting work that you do, where does that money go? Does it go to you?
Well, it doesn't go to me personally, but it goes to the company.
What departments are there at the NMS lab?
There are about a dozen departments, and they're divided up based on the kinds of analytical methods that they use in the departments. So we include things like a screening department, a department that tests for the presence of metals, a department that does confirmatory testing by liquid chromatography, a gas chromatography department. So they're all specialized based on the type of instruments they use or the type of testing that they're performing.
All right, and Doctor, are you an analytic chemist?
I am an analytical chemist, yes.
Okay, and how many articles have you published on analytical chemistry and toxicology?
Well, in total, I've published 80 peer-reviewed articles that have been published in the medical and scientific literature. The majority of them have been on the topics of analytical toxicology or chemistry, but I wouldn't say they're all on that topic.
Can you break down for me what an analytical chemist does?
They apply their knowledge about the properties of chemical compounds and molecules to determine the best way to separate them from the background or from the sample they might be in, to make sure that they're properly identified, and then often to quantify how much of them is present. So it's a question of looking at what the compound is, understanding its chemistry, understanding how it can be separated from other similar compounds that it might be present with, and what kind of instrument would be most appropriate to measure it.
Okay, and can you tell me please what professional organizations you belong to?
I belong to the American Academy of Forensic Sciences, the Society of Forensic Toxicologists, the International Association of Forensic Toxicologists, the International Council on Alcohol, Drugs and Traffic Safety, National Safety Council's Committee on Alcohol and Other Drugs, the American Society of Crime Laboratory Directors, Canadian Society of Forensic Sciences.
What is the American Academy of Forensic Science?
It's the largest professional organization in which forensic scientists in the United States participate. It has about 6,000 members in all disciplines, from chemistry to toxicology to biology to pathology, a number of different fields.
And what leadership roles have you served with regard to that organization?
I have served. I've served as the secretary and chair of the toxicology section. I've served as vice president of the organization, and I'm currently serving my second term as treasurer of the organization.
And are you familiar with the term scientific working group in the forensic science arena?
Yes.
And what does that mean?
These are groups that developed within this forensic science community, first of all, unofficially, where people working in a particular discipline got together to determine whether there was consensus in terms of the best methods to use for doing various kinds of forensic tests. The scientific working groups publish guidelines or standards that other laboratories can choose to follow. Over the last few years, the management of the scientific working groups has been taken over by the FBI, and they manage the activities of these. There are over 20 scientific working groups now.
Okay. And can you tell me whether or not there is a scientific working group for decompositional odor analysis?
Objection. Relevance.
Approach. Objection sustained. You may continue.
Thank you. Dr. Logan, can you tell me, please, your background and experience with regard to accreditations and certifications having to do with forensic laboratories?
Sure. I'm board certified by the American Board of Forensic Toxicology, so the term certification applies to individuals. That group and some other groups offer a process called accreditation for laboratories. So the process of accreditation is ensuring that the laboratory requires with a certain set of standards in terms of how they perform analysis, how they select and train their staff, how they document what they do. They're typically lengthy standards. I serve on the board of directors of the American Board of Forensic Toxicology, and I was involved in developing the standards for the accreditation of forensic toxicology laboratories. That would have been in the early 1990s. Subsequently, my laboratory became accredited by ABFT, a laboratory that I object. I think this is beyond the scope of the question, and also relevance. His laboratory's accreditation is not relevant to this matter.
Overruled at this point.
The laboratory that I currently work for is also accredited by ABFT, so I participate in ensuring that the laboratory conforms with those standards. I meet with and am interviewed by auditors when they come to review the work of the laboratory. NMS Labs has a crime laboratory that performs drug testing and DNA analysis. That laboratory is accredited by a different organization called the American Society of Crime Laboratory Directors Laboratory Accreditation Board. That organization similarly has standards to which the laboratory must conform. These are enforced by the laboratory reporting its activities as well as on-site audits and inspections that take place every year. So that's the basis for my familiarity with the process of accreditation.
All right, and how many organizations have you been involved in that either certify or accredit labs?
Well, the ones that I've named, the American Board of Forensic Toxicology and the American Society of Crime Laboratory Directors.
All right, and are you involved in the auditing process, or have you been over the years?
Yes, I currently do participate in that inspection or audit process on behalf of ABFT. I've done that since the program was introduced. I also historically have performed audits on behalf of the Substance Abuse and Mental Health Services Administration of the federal government that certifies workplace drug testing laboratories or accredits workplace drug testing laboratories.
I lost you at the end part. You said you performed audits on other labs, is that correct?
Yeah, workplace drug testing, urine drug testing is regulated by the federal government, and there's an organization within the federal government called SAMHSA, stands for Substance Abuse and Mental Health Services Administration. So SAMHSA is the organization that's responsible for accrediting laboratories that do workplace drug testing. And I have served as an auditor for the SAMHSA laboratory accreditation process.
All right, Your Honor, at this time we would seek to offer Dr. Logan as an expert in analytical chemistry, toxicology, forensic science, and laboratory accreditation standards, gas chromatograph, mass spectrometry, and cryotrapping, those areas.
I would need to, I have no objection to the forensic toxicology as many others I would need to put on.
You may.
Let me do it from here so I can.
You may.
Your expertise in analytical chemistry, what kind of analytical chemistry do you perform other than that related to toxicology? Well, it's hard to separate the two. Analytical chemistry is the application of gas chromatography, mass spectrometry, other spectrometric techniques, the analysis of a wide range of chemicals and compounds in a variety of different materials. But the question is, when was the last time you performed an examination of analytical chemistry for something other than toxicology? Well, that's part of my daily responsibilities. The crime laboratory that I oversee performs drug testing in non-toxicological specimens, so drugs that are collected or chemicals that are collected in the course of law enforcement investigations. Well, in what circumstances? The question is, outside of toxicological examinations, what do you do in analytical chemistry that has nothing to do with toxicology? That's what I'm trying to find out. You seem to be telling me it's all. Go ahead. Well, the analysis of drugs in evidence. Well, toxicology deals with the examination of drugs in biological evidence. So that's toxicology. Sure. What I'm telling you is that I'm also responsible for the portion of the laboratory that conducts analytical chemistry on evidence that's not biological. So it would be unknown materials, mysterious white powders that are found in somebody's workplace or by law enforcement. Drug evidence is collected from people who are arrested for drug offenses. So you would agree that your work is limited to either toxicology or supervising people that do analytical chemistry looking for drugs? Not everything that we look for are drugs. Some of them are industrial chemicals, some of them are poisons, some of them are you don't do that materials. I apologize. You don't do that. That's not the part of the lab you supervise. You supervise the toxicology section of the lab, don't you? No, I do supervise the toxicologist, but I'm also the director of the crime laboratory portion of NMS Labs. Right. But your analytical chemistry is a very broad field, isn't it? It is a broad field, yes. It's a hugely broad field. Do you consider yourself an expert in every aspect of analytical chemistry? No, I don't. Right. So your experience is limited to that related to mainly toxicology. Is that correct? I would say that my experience is mostly in the area of toxicology and in the techniques and methods that are used in toxicology examinations. And your last experience with cryotrapping was as a graduate student, correct? Yes, that's correct. And that's over 20 years ago, is that correct? Yes. I need to go over and look at the other areas where I apologize. There are quite a few. You're not an expert in all areas of forensic science, is that correct? That's correct. Your Honor, without going too much time going back, this time I would object to any certification of expertise other than forensic toxicology. I believe this expertise is limited to that area.
Yes, ma'am.
This individual has a degree in chemistry with honors. And if I may also,
if it's going to be a long one, you need to come to the sidebar.
Well, if I could just ask him one question, that might.
You may.
Okay. What did you do in the capacity of being the vice president of the American Academy of Forensic Sciences with regard to all the other fields?
I served on the board of directors of the organization. It's the American Academy of Forensic Sciences promotes scholarship, research, education in the field of forensic science. So it's a way to bring all of the disciplines together to look for commonalities in terms of standards, well, in terms of good practice and professional development and education.
That's all I have, Your Honor.
Okay, the witness will be accepted as an expert witness only in the area of forensic toxicology and permitted to render opinions in that area.
Doctor, as a forensic toxicologist, I believe you testified that you use gas chromatogram mass spectrometry in your lab. Is that correct?
Yes.
Okay. Now, in this particular case, can you tell me, please, what material you were provided with and you reviewed prior to coming here today and testifying? What information were you given?
I was provided with some analytical records from the FBI laboratory with respect to the analysis of evidence collected from the trunk of Miss Anthony's vehicle. I was also provided with a report or a series of reports by scientists working at Oak Ridge National Laboratory that also related to the analysis of chemicals in evidence from the vehicle. I was provided with miscellaneous other documents related to the investigation of the case, including the autopsy records.
What about articles? What articles have you read prior to?
Objection. Bolstering.
Your Honor, I'm sorry.
Overrule at this point.
Yeah, I wasn't provided with any articles in the course of this case, but I did review a number of articles I had in my possession, as well as obtain some additional articles with respect to the particular chemicals that were analyzed in the course of the investigation.
Can you tell me whether or not you have reviewed the 2008 article authored by, in part, Dr. Arpad Bas with regard to decompositional odors?
I have.
That would be odor analysis of decomposing buried remains in the Journal of Forensic Sciences.
I have reviewed that article, yes.
Okay, I would like to talk to you about forensic labs for a moment. And, Your Honor, if I may have permission to use the tripod with the pad?
Yes.
Thank you. Now, you testified that your lab is a forensic lab, which is accredited by the American Society of Crime Lab Directors. I'm going to...
You may continue.
Thank you. This one?
Yes.
Dr. Logan, with regard to forensic labs, can you tell me, please, what the requirements are for the American Society of Crime Lab Directors?
Sustain answer that question.
What is the difference between a forensic lab and a research lab?
A forensic laboratory is one that does analysis of evidence specifically for the purposes of it being presented in a court of law or before some kind of administrative review board. Certainly forensic laboratories do research. It helps them develop and improve and discover new ways of testing for things that haven't been detected or been able to be measured in the past. Research laboratories are typically academic laboratories whose mission is to simply discover new things where the application of them isn't necessarily clear of what the ultimate value will be. So they make discoveries that may have applications in medicine or in technology or in space travel or in any variety of different fields just based on discovering new properties of compounds or chemicals or objects.
Can you tell me, please, whether or not the research labs, particularly in this case, conducted proficiency testing?
Objection. Basis of knowledge.
Sustain, establish a foundation.
Do you have any evidence that the Oak Ridge National Lab has the quality control standards in place?
Objection. Basis of knowledge.
Sustain.
What is a validation test in a laboratory setting?
When a laboratory develops a new test, before they start applying it to, well, particularly in a forensic context, before they start applying it to evidence, the test has to be fully characterized to find out what its level of sensitivity is, whether there are things that could interfere with it or cause a false positive result, whether there are limitations to the test that would prevent it from identifying what it was designed to test for, which we would call a false negative. Determining...
Let me object to the answer as applying a forensic lab standard relevance. You indicated specifically, particularly the forensic context, which is not relevant in this case.
Overrule, you can finish answering the question.
And then you have to establish what kinds of material are suitable to apply the test to and show that different types of material are not going to cause interference or erroneous results when the test is performed.
Can you tell me, sir, after the review of the material that you have, whether or not validation testing was done in this case with the testing that was conducted at the Oak Ridge National Lab?
Objection. Basis of knowledge.
Sustain, establish a foundation.
All right, I had asked you the documents that you've reviewed. Can you specifically identify them for me? The reports, the dates of the reports, the authors, etc.
I can if I refer to my records. Thank you. Well, I was provided with copies of laboratory notes from Oak Ridge National Laboratory made by Dr. Wise and Dr. Voss relative to the testing of the evidence in this case, as well as some additional materials that were done that were tested in evaluating the method. I reviewed a document entitled Forensic Report, Orange County, Orlando, Florida, Final Report, dated April 28, 2009, that summarizes the results of the analysis performed by the Oak Ridge National Laboratory. The report was authored by Dr. Voss, Dr. Wise, and Dr. Martin. I also reviewed deposition testimony by Dr. Voss and Dr. Wise.
When you say notes, are you talking about handwritten bench notes?
Yes, I am.
Okay. And can you describe what those are, what those purport to contain?
They're, if you like, a commentary on some of the things that happened while the analysis was being performed, when there were when the test didn't work, or when something was wrong with the analysis, or when an unexpected result appeared. Sometimes they'll give a very broad summary of what the result of the test was, and they identify the samples that were tested during the course of the analysis.
And as a result of your review of the forensic report and the bench notes and the remainder of the material and the articles that you have indicated you have reviewed, have you reached conclusions with regards to the procedures and methodologies utilized by Dr. Voss and Dr. Wise with regard to the experiment that resulted in their report of April 28, 2009?
Objections is beyond his area of expertise in forensic toxicology.
Sustained.
When you reviewed the bench notes, can you tell me, please, or the report, anywhere in the material that you saw, whether or not there was evidence that there was validation studies that were performed?
Objection. May we approach the bench?
You may.
Dr. Logan, can you tell me, please, after reviewing the materials that we just referenced, whether or not there were established, published protocols on how to conduct the testing that took place at Oak Ridge National Lab?
There were no formal protocols for the testing that was performed.
And what significance, if any, does that have with regard to results of such a test?
Well, the test itself, or the approach to the testing, has been described and published.
Objection to the question outside the area of expertise about its effect on the results of this test. It's not a toxicological question.
Sustained.
If a test is conducted without established, published protocols, what kinds of problems can occur?
Well, if you don't have a written procedure for doing the test, there's no way to ensure that the test is going to be done the same way every time, whether the instrument is going to be set up correctly to do the test, whether the results that would be produced if the test was run on different days would be reproducible, whether there are things that could cause false positives or false negatives with the test if it's not done according to a standard procedure. If somebody is unfamiliar with the process, or two different people are doing the test, there's no way to ensure that they're both doing the test the same way. It's critical that for a reliable scientific test that you have a written procedure.
Let's use your field of
Objection.
toxicology.
Move to strike the witness's opinion about whether something is a reliable scientific test beyond his area of expertise in toxicology.
Sustained. Approach the bench. You may continue.
Thank you. Dr. Logan, can you tell me, please, after reviewing the material, whether or not there was any documentation of protection against contamination with regard to the samples that were tested?
There's no evidence of what protection might have been taken with respect to preventing contamination.
And can you tell me, sir, in general terms, the purpose of having protection against contamination of samples that are tested, just in general terms?
Objection to the relevance of generalities not related to the facts of this case.
Sustained.
Can you tell me, please, whether or not there were quality assurance programs that were referenced or discussed or mentioned in the material that you reviewed?
Objection. Again, same as at the bench, the absence of information is not proof of the negative. It's not existence. Which then I'm going to study to.
You can answer that question if you can.
I saw no evidence of any quality assurance that was relevant to the analysis.
What is quality assurance?
Quality assurance is the process by which you document the performance of the test, in which you challenge it with samples that have a known composition to ensure that you get the correct result, to test samples that are known not to contain the chemicals that you're interested in analyzing to make sure that they're not present by contamination or carryover in the course of the analysis. Quality assurance also consists of a process called proficiency testing, where the test is applied to a specimen which the operator of the test or the person performing the test doesn't know what the correct answer is. They perform it blind.
Objection beyond the scope of the question was about quality assurance and laboratory procedures.
Can you tell me, please, after reviewing the material that we just discussed, whether or not there was documentation of how control samples were obtained, the manner with which proper control samples should be obtained, et cetera?
Objection. Compound question.
Sustained. Rephrase the question.
All right. Were proper controls discussed in terms of how they were obtained in this case in your material?
No.
And what is a control?
A control is a sample that contains a known amount of the chemicals that you're testing for, I'm sorry, I object. This is beyond his area of expertise in toxicology. None of these questions involve toxicology. What is the problem?
Sustain. Rephrase your question.
In toxicology, sir, do you utilize controls?
Yes.
And can you tell us what you mean when you say controls in terms of toxicology?
Objection to the relevance of toxicological controls in the context of this case, which does not involve toxicology.
Sustain.
When you reviewed the report and the records and the other material that you referenced, did you render or do you have any opinions with regard to, get my glasses here, specifically the bench notes as they discuss the manner with which the testing was performed on the samples, the control sample, the negative control, and the positive control?
I'm sorry, I didn't follow that question.
That's because it was a terrible question. Let me rephrase it. Do you have any opinions after reviewing this material, whether or not there was anything in the bench notes that caused you any concern about the manner with which the test was conducted?
Objection. Outside of your expertise in toxicology and attacking the other expert as in the Cuban case of the report notes.
Sustain.
What is your understanding with regard to the blank samples, specifically page 73 of the bench notes?
Same objection. Outside of your expertise in the Cuban case.
Sustain.
Can you define what a blank sample is in your field in terms of using a blank sample for gas chromatograph mass spectrometry?
Yes. A blank sample is a sample that's known not to contain the chemicals or the analytes that you're trying to test for. It's to ensure that there's no contamination or interference with the test when you're applying it to evidence.
And what happens if a blank sample is run, but the computer is not changed to be consistent with the blank sample?
Relevance and outside of your expertise.
Yeah,
Use of toxicology.
Maybe approach.
I'll permit him to answer the question.
I'm not sure I understand the question. It's about the computer?
Right, you're running a blank sample and you forget, or you don't make changes on the computer, and then you have to do that and go back.
Object also is a hypothetical, not based on the facts of this case.
Your Honor, may I respond? Or maybe approach?
Yes, ma'am.
Can you tell me what the effect of running a blank sample but not changing the machine can have on the results?
Well, if you don't have the instrument set up and the machine set up appropriately to do the test, you won't get a reliable result.
And can you tell me the effect of not seeing a positive control when there should be a positive control? What is the significance of that?
Well, if you're performing a test on a sample that's known to contain a particular chemical or compound, and you perform the test and the compound isn't present, it tells you there's a problem either with the way the test was performed or the way the instrument was set up. And it's an example of why you ought to have a written protocol for doing the test.
Objection, not responsive to the question and move to strike.
Sustain. Motion to strike granted.
All right, let me re-ask the question again, but ask you just to respond to the question, what is the significance of running a blank sample and the blank sample actually showing up as positive for a chemical when the chemical shouldn't be there?
If you're running a blank sample which is known not to contain the chemical that you're interested in testing for, and you get a result from your instrument that says it's present, then it's an indication of either contamination or a problem with the way the test was performed.
And what's the purpose of a blank sample in the first place?
It's to ensure that your test or technique doesn't give false positive results.
And what do you mean when you say false positive?
A false positive result is a result that's positive when the sample does not, in fact, contain what it is you're trying to test for.
All right, what is the significance of a closed valve essentially destroying or messing up a run? What does that mean?
I don't know that I think that question's too, I don't think I can answer the question that was asked.
All right, when you reviewed the reports and materials, did you see any issues with valves being closed?
Yes.
Okay, and can you explain what you mean by that?
The bench notes that I reviewed from Oak Ridge indicated that sometimes when the test was run, the valves were not set in the appropriate position, and as a consequence, the result failed or gave a wrong result.
And what about triple sorbent tap freezing? Did that occur in this case?
Objection beyond the area of expertise of the witness.
Sustain.
What significance, if any, would it have to you if a lab were to be changing the technique that they were using in the middle of the experiment?
Objection beyond the area of expertise and relevance unless it applies to the laboratory.
I can explain.
Sustain. Rephrase the question.
When you reviewed the notes that were taken in this case, can you tell me specifically whether or not any of the techniques were changed in the middle of the experiment?
Yes.
Okay, and describe that for me if you would.
The conditions of the analysis were changed over the several weeks in which the various specimens were analyzed in order to try to correct problems with the operation of the instrument.
What significance, if any, does that have in terms of the use of the machines and the manner with which they are interpreted.
Objection beyond his area of expertise.
Sustained.
What does that mean to you, the statement that you gave? In terms,
Objection, same question.
Sustained.
when you run a standard to determine if the machine is reading the standard, can you tell me whether or not that it is done typically on the same day that you run the experiment? Or you run, I'm sorry, that you run the sample?
Yes.
Why is that?
To ensure that you're testing the question sample or the evidence under the same conditions as you're testing the sample whose content is known.
Can you tell me, in this case, whether or not that occurred or did not occur?
It did not occur.
Do you know how many times?
It did not occur.
Okay. When you say did not occur, I need you to explain that. In other words, the standard's being run the same day as the sample?
I didn't count how many occasions that did not occur. There were specific instances in the notes where, or the materials that I reviewed, where the evidence was tested on one date and the standards to ensure the proper functioning of the instrument were run days or weeks later.
Doctor, what is oleic acid?
Oleic acid is a fatty acid.
And can you tell me what compounds or what this can be found in?
Objection, outside his area of expertise. Toxicology.
Overruled at this point.
I'm sorry, your question was?
Well, let's back up. Doctor, have you had an occasion to run tests in which there were fatty acids?
Yes.
How many times?
Fatty acids are prevalent in all kinds of biological materials, so they show up in the course of analyses that are done every day in toxicology laboratories.
So if you had to estimate how many times you engaged in testing wherein there was some form of fatty acid or fatty acids in the testing that you conducted, can you approximate for me?
It would be thousands of times.
Okay. Are you familiar with and have you engaged in testing in which the appearance of oleic acid occurred?
Yes.
What about palmitic acid?
Yes.
What about stearic acid?
Yes.
What about mysteric acid?
Myristic acid?
Myristic acid, I apologize.
Yes.
Okay. Can you tell me, please, whether or not you are aware of where what items can contain myristic acid?
Objection, beyond his area of expertise, and if beyond his area of expertise, it's toxicology.
Overruled at this point.
These fatty acids and many others occur in all kinds of biological materials, animal material, plant material, household products, foodstuffs.
When you said these, were you also referring to the oleic, the palmitic, and the stearic?
Yes.
As well as the myristic?
Yes.
You described some plant material. What other kinds of materials would you find this in?
It's
What kind of food products specifically?
It's present in dairy products, in meat products, cheese, butter, milk.
If you were to an item that contained oleic acid, palmitic acid, myristic acid, and stearic acid, let's say a towel, a paper towel, as a toxicologist, what conclusion would you reach with regard to those four items?
Objection, beyond his area of expertise. Those aren't toxicological substances.
Overruled on that basis.
You would conclude that those fatty acids were present in the paper towel.
Which can be caused, I believe you said, from a number of items, including cheese.
Yes.
And the percentage of, for example, which fatty acid may occur higher, let's say you have all four in a particular substance. Can you tell me, please, whether or not you are familiar with the ratio of fatty acids in meat pizza?
Objection, beyond his area of expertise.
Sustain until you establish a foundation.
Doctor, have you conducted any research to determine the relative ratio of these fatty acids with regard to pizza?
I reviewed published articles that describe the relative ratios of these fatty acids in foodstuffs, including pizza, yes.
And do you have an opinion or do you have an understanding as to what that ratio is?
Objection. I have multiple objections.
Yes. Okay, ladies and gentlemen of the jury, at this time we're going to recess for lunch. I'm going to ask you not to discuss this case among yourselves nor with anyone else. Please remember all of my other previous admonitions will be in recess to 1:30. Okay, let the record reflect that the defendant is present along with counsel for the defendant, assistant state attorneys, both sides ready to continue.
Stage ready.
All right. Let's have the witness back on the stand. Okay, let's return to jury. Okay, state recognized presence of jury.
Yes, Your Honor.
Does the defense?
Yes, Your Honor.
Okay, members of the jury, did you heed all of my previous admonitions during the recess? Okay, you may continue, Ms. Sims.
Thank you. I just have one final question. Dr. Logan, these four fatty acids that we've been talking about that can be found in food and biologic origin, et cetera, in this case, can you please tell me where those four fatty acids were found?
Objection. Where they found? No objection. Sorry.
They were found on a paper towel.
Thank you. That's all I have, Your Honor.
Okay. Cross-examination.
So is your testimony that all three of these fatty acids found in combination are found in vegetable material?
Take the testimony.
Overruled.
You're not saying that all three of these in combination are found in vegetable material, correct?
I'm not sure I understand your question. Combination of what?
Oleic, palmitic, stearic, and mysteric.
Are all of them found in?
Those aren't found in combination in vegetable materials, are they?
Yes, they are.
What vegetables?
In oily vegetables like palm oil.
Palm oil.
Yes.
Okay. Not in cabbage. That type of vegetable.
I'm not aware that they're present in cabbage.
But they are also present in decomposing animal fat, correct?
Yes.
Excuse me, Your Honor, I object. Mr. Ashton has objected with
He's
regard.
answered the question. Untimely.
Is there a difference in the length of the carbon molecules in milk, cheese, and butterfat versus adipocera?
The same fatty acids are present in adipocera as are present in dairy products.
Are there a difference in the length of the carbon molecules in those two different circumstances?
Well, there are multiple fatty acids in adipocera and in dairy products. The 4 fatty acids that have been discussed with me this morning are present in both. There are additional fatty acids that are also present in both.
Are the carbon chains in milk, cheese, and butter 4 to 10 carbons long, and carbon chains in adipocera 14 to 18? Sorry, 4 to 10 carbons long, and the carbon chains in adipocera are 14 to 18 carbons long. Is that true?
The carbon chains in oleic acid is 18 carbons long. The carbon chain in stearic acid is 16 carbons long. Carbon chain in palmitic acid is 18 carbons long, and the carbon chain in myristic acid is 14 carbons long. These 4 compounds are found in both adipocera and in dairy products. There are other fatty acids that have anywhere from 6 to in the 20s carbon chains. There's a mixture of them. They're complex mixtures.
Are there other compounds that are found in milk, cheese, and butter, particularly processed for human consumption, that are not found in adipocera?
Yes.
So upon chemical analysis, the difference can be determined.
If these other compounds are tested for, yes.
Now, it is not unusual in any kind of examination of evidence in any context for there to be special challenges in looking at, in analyzing evidence on a GCMS. Isn't that true?
Is it unusual? It's not unusual for there to be special challenges. It can happen with any kind of evidence. It depends how complex or unusual it is.
Particularly with forensic samples.
Yes, I agree with that.
Forensic samples are rarely pure, so there's always challenges involved in those, correct?
Where you have standardized methodologies that are designed to accommodate the wide range of forensic samples that you're likely to encounter, you're going to have fewer challenges.
What are there situations where scientists are faced with challenges that are not in protocols?
Yes.
And what should a scientist do when faced with a challenge that's not in a protocol?
They should either develop a new protocol or adjust their protocol to accommodate the special challenges of that particular piece of evidence.
And that is an acceptable scientific procedure.
Yes.
Now, the protocols for the examination of decomposition odor are published in the forensic science journal. Is that not correct?
The general principle is published in forensic science journals, yes, but not the detailed information as to exactly how the test is performed.
So the steps in the procedure are not published?
Correct.
So the Journal of Forensic Science does not give a step-by-step method of exactly how the samples are collected, how the triple open traps are desorbed, and how and at what settings it is run through the GCMS.
Well, with respect to those specific issues, some of that detail is contained in the published articles, yes.
Now, a blank is a sample of room air, in a sense of a air examination, is room air, which is run through a machine to determine whether there is any contaminants in the ambient air that should be of concern, correct?
That would be an example of a blank, yes.
And what should a scientist do when a blank shows some unexpected results?
They should investigate the cause of that, whether it's contamination or the instrument being improperly set up or operated, and ensure that and retest the sample to ensure that after these adjustments, it gives the appropriate result.
So you stop what you're doing, figure out what the problem is, correct it, and then run it again.
Yes.
When a scientist is faced with even something as simple as a human error of forgetting to close a valve, the proper procedure is to stop, correct the error, and start over, correct?
Yes.
And in both of those circumstances that you referenced in the bench notes of the work in this case, that is precisely what was done when these challenges were faced. Is that not correct?
The problem was diagnosed. The notes contain some detail about Dr. Wise's or Dr. Voss's opinion about why the test failed, and then what they did differently to ensure that it worked properly the next time.
And then they ran it again?
Yes.
And then reported the results of those tests?
Yes.
No further questions?
Redirect.
You were asked about challenges. What did you understand the word challenges to mean when you were answering the question?
Something that was unusual or unexpected about the sample that was being tested.
And what effect do challenges have on the reliability of the study?
Pardon, objection to an opinion of reliability in the abstract.
Excuse me, Your Honor, I'm objecting to speaking objections.
Objection, sustained.
I object to his objection.
You were asked about protocols with regard to the detection of decompositional odors. published protocols. Are there published protocols that you saw in any article or any of the material in terms of how to collect air from the trunk of a car?
No.
I didn't hear you.
No.
Are there published protocols on how to collect carpet samples from the trunk of a car? How much carpet? How thick it needs to be? Where to put it?
Compound question.
I'll stop it. Are there published protocols that you're aware of, sir, on how to collect carpet from the trunk of a car?
No.
What significance, if any, does that have to you in this case?
Opinion outside their expertise.
Sustained.
Dr. Logan, based on everything you've reviewed, including the report, the 2008 report that was referenced on cross-examination, all of the materials that you have, can you reproduce exactly this experiment that was conducted by Dr. Voss and Dr. Wise?
No.
And why is that?
Because there's a lot of detail missing either from the laboratory, the bench notes, or from what was published in the Journal of Forensic Sciences about what the expected sensitivity of the test is, what other possible causes there could be for the patterns of chemicals that were identified in the test. So there would be no way for me to know whether the way I did the test was the same way that Oak Ridge had done the test.
Thank you, Your Honor.
Recross on those issues?
Dr. Logan, your laboratory couldn't do this test if you wanted to, could you? Which test? The test of the carpet samples in this case. Your laboratory doesn't do that type of test, does it? We would be capable of doing that test. All right. I'm going to show you State's Exhibit 114 in evidence, State's Exhibit 143 in evidence, State's Exhibit 322 in evidence, State's Exhibit 323 in evidence. Have you ever seen any of those? No. If you had been sent one of those, could you have tested
it? All right. Mr. Ashton, your argument?
Yes, sir. I'm trying to find the case.
Okay, this
You may want to take a look at Hayes versus State, that argument, by noting that the defense only submitted one sample for testing and that the state sought to have more confirmatory testing performed. Accordingly, we do not conclude that the court abused its discretion in denying the motion for mistrial because the prosecutor's statement was a proper comment on the evidence and any potential error was not so prejudicial as to vitiate the entire trial. The defense's objection to the line of questioning is sustained in that it would violate due process by shifting the burden of proof to the defense. Now, earlier before we recessed for lunch, I asked the defense to read the case of Cuban versus State. Qualified, if you recall, in that Friday during the area, qualities of why you did through that door. There's a sheet point. So
What, putting the bags of evidence in light of the manner, and
well, on that, that would be sustained.
I have a feeling that would be just fine if we could remove those items and place them back on the table as well.
We can do that.
Quotation from the opinion you first read in this decision has exactly the appropriate curative instruction. That is,
I've asked the court reporter to do it because she can probably pick it up faster than I can strolling back through this. For the last question, I asked her to find it, and I would do that and let me.
If you had been sent one of those, could you have tested? At this point, Your Honor, that does not imply who necessary, because it does not imply the defense. Make sure I understand the court correctly. Is the court indicating that I should go no further into his ability to do it or not?
I don't think you can put cans up there and ask him about his.
I would whether he could reproduce the results.
Yeah.
Dr. Logan, in your laboratory, could you take a sample of this carpet, one of these cans, and put it in a Tedlar bag? Could we be capable of doing that? Yes. Could you heat it at 35 degrees centigrade for 48 hours, I believe what the notes say it was done? Yes. Could you extract an amount of air as indicated in the laboratory notes? Yes. Could you inject that into a GCMS with cryotrapping? We do not have an instrument that's set up to do cryotrapping, but if we had such an instrument, we could do that. Could you set the instrument in accordance with the laboratory notes on the carpet sample item that was tested? No. Why not? There is not sufficient information in Dr. Voss's published paper or in his laboratory notes to accomplish that. What is absent from the laboratory notes as to the examination of the carpet sample from the can that you would need to set your machine in order to run it? I'm not talking about interpreting the results right now. I'm just talking about running it. I would need to review his article, and I would need to review his article. So at this point, you're not sure. That's correct. All right. Well, if you need to take a moment to do that, aren't the settings for the machine in the bench notes? No. There's nothing about the temperature to be set, or that's not in bench notes. No, Judge, I'll just withdraw it. It's not.
No. The question by the defense, in some ways, opens the door, but not to the point that this whole area is just like walking on quicksand.
That's not Judge, I'll withdraw it.
Well, if you, to the defensive, when you're trying to impeach an expert, you cannot impeach the validity of the expert's opinion. You have to do that by showing another expert's conclusions were different. And what you're not you don't have an expert that has examined this to show that his conclusions are different. And that's the problem with this whole line of questioning. Both sides read the following case. Network Publications found at 756 7 2nd 1228. A 2000 decision of the 5th District Court of Appeals. We'll take a 10-minute recess. State recognized presence of jury. Defense. Okay, ladies and gentlemen of the jury, I need to give you the following instruction. It is a well-settled principle of law that the burden of proof is upon the state of Florida to prove every element of the crime beyond and to the exclusion of every reasonable doubt. The defense has no obligation to prove or disprove anything. You may continue.
Sir, your laboratory does not perform air sample analysis, does it?
Correct.
And you have not been involved in an air sample analysis since you were a graduate student over 20 years ago. Isn't that true?
That's correct, yes.
No further questions.
May the doctor be excused.
Yes, Your Honor.
Thank you, Dr. Lowe.
Thank you.
The defense may call the next witness.
Defense calls CSI Jenny Welch.
Remember her. She's going to be for about 30 seconds.
My name is Jennifer Welch, W-E-L-C-H.
You may proceed.
May it please the court. Good afternoon, Ms. Welch.
Good afternoon.
You are the crime scene investigator in charge of the recovery site off of Suburban Drive.
Yes, that's correct.
And in the recovery, numerous items were collected in evidence, over 300, correct?
Yes, that's correct.
Were there any socks or shoes recovered that belonged to Kaylee Marie Anthony?
There were no socks or shoes collected from the scene that I can recall.
Would your crime scene investigation then be consistent with the fact that Kaylee Marie Anthony did not have any shoes on or socks when she passed away?
Objection. Opinion. I'll cite this over the evidence she could possibly have.
Sustained.
I'll withdraw the question. No further questions.
Cross-examination. No. May the witness be excused.
Yes, sir.
Thank you, ma'am. You may be excused.
Thank you.
The defense may call the next witness.
Yes, sir. The defense calls Cindy Anthony.
Okay, everybody, you can wake up again. Cindy Anthony is going to be taking the stand now. And this is supposed to be very interesting testimony. So, wake up.
Do you sound like clear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Cynthia Anthony, C-Y-N-T-H-I-A, Anthony, A-N-T-H-O-N-Y.
You may proceed.
Thank you, Your Honor. Good afternoon, Mrs. Anthony.
Good afternoon.
Ma'am, you also lived on, let me rephrase that. You used the computer at your home, correct?
Which one?
The desktop computer.
Yes.
And that is, where's the desktop computer located?
It's now our spare room. It used to be Lee's bedroom.
And the computer, everyone in the house has access to this computer?
Yes.
And who used the computer at the house?
Everybody. Anybody that was at the house that needed to, or even friends of Casey's, used the computer.
Do you recall in March of 2008, you doing any types of searches for any items that might include chloroform?
Yes.
And could you explain to the ladies and gentlemen of the jury why you did that?
Well, I started looking at chlorophyll, and I was concerned about my smallest Yorkie. We have 2 Yorkie puppies. And the smallest one was having some issues where she was extremely tired all the time. And both of the dogs would eat the bamboo leaves out in the back. So I started looking up sources from the backyard that could potentially cause her to be more sleepy. Then it would affect the larger dog. And I started looking up chlorophyll, and then that prompted me to look up chloroform.
Wait, now, I don't understand how you could get those two mixed up.
Not getting them mixed up. If you look into chlorophyll, there's some bacteria associated with chlorophyll production. And looking up that, it comes from different species of plants that have red and brown coloring. And that prompted me to look up chlorophyll because some species of algae and seaweeds and stuff produce naturally chloroform.
Okay. And how do you know that you ran these searches in March of 2008?
Because I also ran a few other searches at the same time in March. There was a scare about using hand sanitizers around small children. There was an email that went around my employee at my work. One of my nurses had sent me an email knowing that, Kaylee was of age that she could be affected if we used hand sanitizer, and she got her hands on it. And that scare came out in March. And during the same time frame that I was looking up the issues about the dogs, I was looking up ingredients in the hand sanitizer, the alcohol. And then that prompted me to look up other things that we had in the house, like acetone, hydrogen peroxide, rubbing alcohol.
Did you run any other types of searches during that time frame that, and I'm specifically referring to March 2008, that might have to do with any types of injuries?
Yes, a good friend of mine was in a car accident and had multiple chest and head injuries and had a lot of blood loss. And I was looking up specific terminology that someone had asked me to look up. And at work, I don't have access to the regular internet. We had our own Gentiva internet. So I had to do those types of searches at home. I couldn't do it at work.
It's interesting you bring that up. We have your work records and evidence, and it shows that you work pretty much a regular schedule during that time period.
I took a day off during that time period, usually during the month of March. A couple important holidays fall in that time frame, and typically I would take certain holidays off because I had 6 weeks of vacation. And
why would your work schedule show that you were working?
could have been an error if my supervisor filled out my time card in my absence if it came on a day that our time cards would turn in.
Sustain.
Could your work
So her work records reflect that she was working, but she was really off.
schedule show that you were working and you actually be off? Has that, I'll rephrase it. Has that ever happened?
Yes, it has. And I'm also salaried, or I was salaried. So even if I put 4 hours in one day, I would mark down 8 because another day I might put in 12 or 14, and we were not allowed to show overtime. All we had to, we were supposed to show 8 hours of work each day. Supervisors were not allowed to show any overtime for the corporate. We were instructed never to do that. So we were supposed to only show a 40-hour work week, and my normal day was a 9-hour day. So by the end of the week, I would always have overtime.
Okay. I'd like to show you State's Evidence 79 and State's Evidence 80. May I show these to the witness and publish to the jury, Your Honor?
Yes. You showing which one now?
I'm showing State's Evidence 79.
Thank you.
I don't know if, well, I'll publish this one. Is there any way I could get rid of the glare a little bit? See how it's showing a bit of glare. Mrs. Anthony, do you recognize this photograph?
I'm guessing that it looks like it could be the trunk of the Sunfire.
I don't want you to guess, so I'm going to show you States 47. Actually, let me zoom out a little bit. That might help. Does that help you at all?
Yeah, I mean, it looks like the trunk of a car, and the car looks like it's white.
I'm going to show you another photograph. State's Evidence 47. Is that the Pontiac Sunfire?
Yes.
And where was this car purchased?
Where?
Yeah, from who?
Oh my gosh, I know it was on West Colonial, one of the dealerships out there. I'm not sure what the name of the
Who purchased the car?
George and I did
Okay. And when?
in 2000.
Okay. And then who drove the car?
Mainly George and Lee, but we purchased specifically for Lee.
And how long did Lee own the car?
We got it for him when he was a junior in high school in 2000, and then he drove it until I think 2005 when he got his Mustang. I think it was 2005 when he purchased his Mustang.
And after that, it was then passed along to Casey?
Pretty much, George or Casey would drive it. They had a car that they had a Corolla, and once they sold the Corolla, then they drove that car.
I'm going to show you State's Evidence 80, which is the trunk of the Pontiac Sunfire. A little bit of a close-up. Can you see if there is a stain in the trunk of that car?
There's a faint stain. Yes, I see it.
Okay. And have you seen that stain before?
Yes,
Where?
when we bought the car.
So it's your testimony that this stain was there when you bought the car?
There was a few little stains in the car when we bought the car, yes.
And when you saw the car again on July 15, 2008, and you sprayed the Febreze in there, did you see any other stains in addition to the ones that weren't there previously?
I think there was an indentation of a gas can temporarily.
Was it a cylinder type
Yes.
stain?
Yes.
Would you say that it would be consistent with this cylinder type?
Yes.
That would be the State's 283.
Thank you.
Has everyone had a chance to look? I can have just a moment to double check.
Cross-examination.
Thank you, Your Honor. Mrs. Anthony, is it your testimony that despite the fact that your work records show that you worked on Monday, March 17th of 2008 and Friday, March 21st of 2008, that you were home between the hours of 1:43
p.m. and 1:55 p.m. on March 17th of 2008?
It's possible, yes.
Were you home on March 17th of 2008 between 1:43 and 1:55 p.m.?
If those computer entries were made, then I made them. I was home. I know I took some hours off. During that week was Casey's birthday and my anniversary, and I did go home early a couple days.
All right. Now you have to work at 7:30 to 5 typically?
My hours are whatever I make them to be. I had to be there at least from 8:30 to 5 o'clock, and then my hours got extended within 2 hours after, within 2 weeks after I started working, the hours got extended to 5:30. So when I signed up, it was from 8:30 to 5, but after I got hired, it was from 8:30 to 5:30. And I would always come a minimum of a half hour prior to and stay as long as I needed to.
All right. So it's your testimony today that it's possible that you were home on that day, even though your work records reflect something differently. That's correct?
Overruled.
Is that correct?
Yes.
All right. Even though your work records suggest or establish that you were working on March 21st of 2008, is it your testimony in front of this jury that you were home between 2:16 and 2:28 p.m.?
It's possible.
Were you or weren't you?
That day,
Overruled.
the only thing that triggers that day for me is those computer entries. It was not a traumatic day for me like the last 3 years. So I can't tell you exactly what time I went home. If I had access to my work computer, I could tell you when I left that day.
Have you looked in the last 3 years to determine what time you went home on March 17th of 2008?
I have not been to work since July 15th of 2008. I never returned back to my employer.
Do they still exist?
Yes, they do.
If you wanted to, you could go and find out if, in fact, you left work on March 17th of 2008, even though your records reflect that you didn't.
No, I don't think so.
They won't let you in the door.
No, that's not the reason. The reason is because I had a working password
mad.
when I was an employee, and only I would know through my emails what time I left, and no one had a password to my emails, and I'm sure all those things have been lost by now.
You're guessing.
No,
Okay,
I'm not.
you're guessing.
No, I'm not guessing
Let me
because
ask you this. On Friday, March 20th,
Can allow the witness time to answer, complete their
He's
answer.
mad.
Ma'am, did you complete your answer?
no, I did not.
Complete your answer.
He was not expecting.
We had several passwords to get into our computer, and everything, I had at least 2 login passwords to my computer that only I had access to. It was against policy to give your passwords to even your supervisor. I also had a computer access password to my emails. And again, no one was allowed to get into my emails except me. And those computer passwords expire every 30 days. And without me being there to put in my old password to create a new one, no one would be able to get into my passwords.
do you have knowledge as to whether or not your company backs up your emails?
I don't know if they would still have them 3 years from now, because the reason I say that is because our emails had a memory that only lasted so long, and it depended on how much was in there, if we deleted them or not.
My question was, do you have knowledge as to whether or not your former employer backed up their emails on a regular basis?
Again, it would depend on the length of time that those emails were there. One office that I worked at, our company was nationwide. We were in 40-some states, and in each state, there was many, many Gentiva locations. Ours was just one. And the capacity that each office could hold was a little bit. And every day we just generated referrals, which came as emails for our patients, not counting the emails that I would get from other employees in the office and my staff. So there was only a capability that the computer could store those. So I do not believe that the company would still have the ones from 3 years ago. It would be virtually impossible to keep everybody's as a backup.
All right, you were aware of the fact that these computer searches were an issue as early as August or September of 2008, correct?
No, the first time I found out about the computer searches was with Detective Melich and Detective Allen come into my house asking why Casey might perform those searches. And
When was that?
That was prior to Casey's arrest on check charges,
All right, so this would have been in September of 2008.
whatever date that was, yes.
All right, I take it that you did not tell them that you made those searches, correct?
I did tell the law enforcement. In fact, I told you during my deposition in 2009 that I made those searches.
You told me at your deposition that you searched for chlorophyll, correct?
Yes.
And you spelled chlorophyll for me. You
Yes.
recall that?
Yes.
You recall denying that you made any searches for how to make chloroform.
I didn't look up how to make chloroform. I looked up chloroform. And I believe
Did
we
you
talked about it.
input into a Google search engine?
Excuse me, Ms. Greenberg. I would ask the witness be allowed to complete her answer before being
Ma'am,
interrupted by the prosecutor.
Did you finish answering your question?
I can't remember if she asked the question. And if she would read back what I said, then I might know if I had.
This prosecutor is just over it. She is really mad about this testimony.
Something else to say.
Okay. Madam Court Reporter, read back the last question and the last portion of Ms. Anthony's answer to her. And wait till she tells you to go ahead, Ms. Anthony.
Do you recall denying that you made any searches for how to make chloroform? Answer, I didn't look up how to make chloroform. I looked up chloroform.
Yes, I looked up chloroform, and the when you look up chloroform, you don't have to look up how to make it. On there, it tells you what the chains are.
All right. You testified in the past that you looked up chlorophyll, correct?
Impeachment.
Overruled.
Correct?
Correct. At the same time, I looked up chloroform.
You suggested that the Google search engine asked you if you wanted to change the spelling of chlorophyll when you made this search, correct?
Correct.
Because you spelled chlorophyll wrong.
Correct.
Did you input the words into the Google search engine, how to make chloroform?
I don't recall putting in how to make chloroform, but I did Google search chloroform, and we talked about it in my deposition.
The question is, and it's a yes or no, did you type in to the search bar on Google how to make chloroform?
The question has been asked and answered twice.
Overruled.
Did you type those words into the search bar on Google?
I don't recall typing in how to make chloroform. I recall typing in the word chloroform.
Do you recall denying that you searched for self-defense?
Yes, I did not search for self-defense.
Household weapons?
I did not search for household weapons.
Neck breaking?
I did not search for neck breaking, but I do recall that there was a pop-up that was showing a YouTube regarding a skateboarder that was skateboarding on rails, like if you're going, like a turnstile type rail, if you're going into someplace in the skateboarder. And I recall it saying a neck breaking feat.
Is this something that you're recalling now that you've changed your medication since July of 2009?
Again, it's not.
Yes?
No, I recall that at the time, but you didn't ask me
Okay.
about. I answered your question specifically at that time.
Did
But my
we-
memory is better than it was when I had my deposition in 2009.
Yes, ma'am. Did we cover whether or not you did a search for the word shovel?
No, I wouldn't need to look up the word shovel.
Right. On March 17th, did you look up the word inhalation?
Probably.
Do you know?
There were several searches that I did that day. I also searched regarding the injuries too.
Alcohol?
Yes, I said
Acetone?
I already answered Mr. Bias to that. Yes.
Peroxide?
Yes.
Hydrogen peroxide?
Yes.
Is this something that you've recalled since
No.
July of 2009, since your medication's been changed?
I recall doing that because of the email that I got regarding the effects if a child ingested hand sanitizer because of the alcohol content. That's why I looked up alcohol and I looked up those items because it triggered me to look up other household items that we used near Kaylee. We painted her nails. I used acetone near her.
What search engine do you use?
Whatever's on the computer, whether it's Google or Yahoo.
What browser?
I'm not even sure what you're referring to.
When you turn that computer on, which profile do you use?
Our home computer, the desktop, we left on pretty much 100% of the time. It was rarely shut down. So usually if I had to go on, it was already on. All we had to do was just refresh it.
All right, so are you testifying you don't know which profile you used?
Profile regarding,
There are only two profiles on your computer. Do you know that?
are you talking about my laptop or
No,
the
that-
desktop?
We're talking exclusively about the desktop.
I
There's a
didn't-
user profile and there's a Casey profile. There's usually an icon. When you turn it on, you pick one.
I don't
Do you recall
recall
that?
having to do that on my desktop, on my laptop, yes, there was two.
So on the desktop, you would not have entered a password, correct?
No, we did not have a password on our desktop.
Did you do searches for making weapons out of household products?
No.
Chloroform habit?
Chloroform habit?
Seems like something else.
There's already been testimony about this. Your Honor.
Overruled.
Chloroform habit?
I've never heard that come up before, no.
Chloro and the number 2? Was that you?
Chloro 2?
Mhm.
I don't know, there's chlorophyll 1 and 2.
Were you on druglibrary.org?
Oh, all the time.
Instructables.com?
Don't know.
Sciplat.com/chloroform?
I don't know if it came up that way.
Were you on that website 84 times?
I was on it several times.
Were you on that website 84 times?
I don't know. I don't know. They need to look up how many times I was on the chlorophyll website and compare it to the chloroform website.
Did you do 84 searches for the effects of chlorophyll on your animals?
I didn't do 84 searches of anything, but I don't know what my computer does while it's running.
Okay. In March of 2008, you did not have a MySpace account, correct?
No, I did not.
Did you have Facebook?
No, I did not.
If I may show and publish states 80 for identification. Your Honor?
You may.
Can you see that?
Yes, ma'am.
Where's this stain that was in the car when you purchased it in 2000?
The stain was somewhere up in here.
I'm sorry. Let me clear that because I think I took it away too fast. Tell us again.
The stain was up in the top section.
All right, near the letter B? Closer to
In
the
front
letter
of-
B than the letter A and the dryer sheet in the back.
Yes.
I have no other questions of Mrs. Anthony. Thank you.
Redirect.
Mrs. Anthony, I got a little confused. I want to make sure. The password protection was on your work computer, correct?
I had password protection on my work computer.
But as far as
But
your
not at
desktop at home, there's no password for that.
No.
And would you ever go on the computer after Casey would use it?
The computer was left on all the time. So a lot of times I would come home, Casey would be on the computer, and I asked her if I could get on for a few minutes.
And all of this stuff about chlorophyll and chloroform, you had told the prosecutors about that back in 2009, did you not?
Yes, I did.
And this is nothing new.
No, it's not.
Is this anything new?
Sustain is deleted. Rephrase your question.
Is this testimony anything new?
No, sir. I did tell the detectives and I did tell the state's attorney's office about the searches, and they knew that I had searched for chlorophyll as well.
No further questions.
Any additional questions? May the witness stand down. Thank you, ma'am. You may stand down. Defense may call the next witness.
Calls Sandra Khan.
You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
I'm Sandra Osborne, SANDRAOSBORNE.
Police Court. Good afternoon, ma'am.
Sir.
I apologize. I refer to you as Sandra Khan.
Former name, that's quite all right.
Okay. And you prefer Osborne.
Yes, sir.
And you are a detective
Yes.
and also a computer expert.
A computer forensic examiner, yes, sir.
Your Honor, I would ask that the court re-recognize Ms. Osborne as an expert in digital forensics, as previously designated.
No objection.
Ms. Osborne, who is the gentleman that followed you in today? I don't think it is relevant. But the previous time that you testified, did you have another individual follow you in that time? Ma'am, you were the first person to receive the Anthony's desktop computer,
That's correct.
and you then did a forensic examination of that computer.
You're referring to the Hewlett-Packard desktop?
Yes, I am.
Yes,
And one of the things that you did, you were asked to run a keyword search for chloroform.
that's correct.
And subsequent to that, what you ended up doing is you found a hit, correct?
Correct.
And then after that, you identified a unallocated space, a deleted internet history. Did you not? Tell us what happened next.
You have to refine that for me.
Sure.
Next, after I found
After
the,
you found a hit for chloroform, what did you find next? What did you do next?
what I did with the search hit that I found for chloroform,
Correct.
I identified it as a deleted internet history file, and I turned that portion of data over to my Sergeant Kevin Stinger.
And did the two of you consult on this matter?
He is my supervisor and my mentor. He supervises everything I do, so I worked with him and he mentored me through the process, but he worked with that, with the other witness that you've heard from before, John Bradley. So yes, I watched his work do that, but I was not directly involved with that.
Prior to that, did you recover the internet history using a program called Net Analysis?
I did, yes.
And then what that is that's a competing, well, let me rephrase it. Is that a competing software to this new cashback software that Mr. Bradley testified about?
It's a different forensic tool that we use that is widely recognized in the computer forensics field. Its functionality is slightly different. It's a different tool. I don't know if I would say it's competing, but it's a different tool that we use. We use both.
But they both accomplish the same thing. They help you reconstruct or re-get the internet history that's deleted.
It allows us to view the internet history.
Okay. And what you do with that information is you then, I guess, put that on an Excel spreadsheet.
With the net analysis, I don't do the reporting typically with the net analysis reporting feature because sometimes a large history file will be hundreds and hundreds of printed pages. It's just easier to export it out to an Excel spreadsheet so I can manipulate the data that way. Manipulating meaning collapse a column I don't want to look at or expand a column I do want to look at.
Okay. You don't change the data. You just are able to view it differently.
That's correct.
Okay. And when you did that, you turned that, of course, over to the prosecutor's office.
I would have submitted that with other reported documents and items to the detectives, which I'm assuming went to the prosecutors at some point.
I'd like to then show you what is marked as Defense Exhibit DF. May I proceed with Your Honor? Do you know what that disc is, ma'am?
Actually, I've not ever seen this disc, and that is not my handwriting.
Do you have with you, you were asked to bring with you all of your files, correct?
Yes, I was.
Okay. Do you have that portion which we were speaking about with you?
No, this label says Firefox from unallocated space. So that's not her handwriting. She's never seen it.
She's identifying the item in her hand, Your Honor. Okay. Do you have the item that we requested that you bring?
I did not work on this particular item. This is what I turned over to Sergeant Stinger.
Okay. And did you put together the Excel spreadsheet that you just testified about? Let me see if I can show you a printed out version. May I approach the witness, Your Honor? Does that appear to be a portion of the Excel spreadsheet that you prepared?
I believe this is a document Sergeant Kevin Stinger prepared. If this refers to the deleted Firefox history from the HP computer, this would have been that chunk of space from deleted space with the search hits that Sergeant Stinger and John Bradley worked on.
Okay. Do you recall issuing a report in this case?
Of course.
Okay. On October 20th, do you indicate that you prepared this Excel spreadsheet?
If I could refer to
Yes,
the
please go
report
ahead.
you're referring to.
Sure.
I issued 2 reports in this case. Can you refresh which one you were referring to?
I'm sorry?
Which report were you referring to? There are 2.
Okay. I'm referring to the Firefox header.dat. Oh, which report? The one, I believe it's your second report where you indicate summary of findings after August 20th, 2008.
And are you referring to in the middle of the paragraph where it says I exported evidence internet history HP desktop folder as
Correct.
Firefox header.dat?
Yes.
Yes, that's the portion of the deleted Firefox internet history that I copied out and then showed to Sergeant Kevin Stinger, and he worked on it from there. That's correct.
And then you indicate the net analysis report was exported and saved.
That's correct, I did.
Okay. And then do you indicate that it's an indicator that lists the internet history, correct? Why don't you review that portion and tell us what you're indicating there on your report?
Your question's a little vague. This refers to the deleted Firefox internet history where I found the search hit that you asked about.
Correct.
I exported it out of my in-case report where I was working so that my sergeant could copy it to his thumb drive or whatever he copied it to, I can't recall at the moment, so that he could take it back to his machine and work on it.
And then the next paragraph, right there where it says the Excel spreadsheet displays.
Yes.
Okay. What does it display?
My report says it displays in column format the URL page, the file's first access and last access dates and times, an indicator of whether or not the URL was actually typed by the user, and how many times the web page was visited. And then sites visited more than once will display different dates and times in the date and time column.
Can you read the exhibit number on the back?
Identification D Delta F Foxtrot.
I'd like for you to take a look at your screen. Do you see that?
Yes.
Okay. Do you recognize that as the Excel spreadsheet that you recovered from the Firefox unallocated space from the HD desktop computer?
This is in a different format. The printed format and the format you're showing me on the screen is different than the one I would have exported out. The reason I know that is because the columns in this spreadsheet that you're showing today are actually expanded to show all the data inside the columns.
Right.
The one I exported out, the columns are compressed and you have to expand them out.
Okay. But other than them being spread out so you can read what's there, you recognize this, correct?
I recognize some of the content, yes.
Okay. And does this appear to be a fair and accurate representation of that spreadsheet?
As best I can tell, yes, sir.
Okay. Judge, at this time, we would move Defense Exhibit H.
Yeah. What says the state?
Based on the witness's answer, I would object to the use of this document. She said, as best she can tell, as opposed to having knowledge that this is a fair and accurate copy. She said this was not the one that she prepared.
I believe she.
The state, you need to ask a few more questions. It's not certain at this point.
Ms. Osborne, I'm going to show you the original. That was a highlighted the portions that I wanted to discuss with you. I'm going to actually show you the original that was turned over to us and see if you recognize that. Okay, can you see that?
Yes.
Okay. Does this appear to be the URL, the Excel spreadsheet that was prepared?
I believe Sergeant Stinger prepared this spreadsheet, sir. I don't believe I did this. This does not look like the format that I would prepare the sheet.
So even though your report indicates that this is something you did, you're saying Sergeant Stinger did this?
My report specifically indicates that I found the search hit. I identified the internet history file. I copied it out to a different location than the computer forensic software I was working in so that it could be saved to a thumb drive and moved to a different computer. The spreadsheet that would have been created, highlighted, manipulated from there would have been Sergeant Stinger's work and not my work.
Okay. But you reviewed this, correct?
No, sir.
You've never seen this before in your life?
I did not work on this document. This is not my document.
Okay, very well. Judge, at this time, we have no further questions for this witness.
You need cross-examination?
The HP computer had a password, correct?
Yes, one of the user account profiles did have a password.
All right, it's correct that the owner account or the owner profile had an assigned password of Rico23 that was set on May 14th of 2008, correct?
That's correct.
That's all I have.
You wouldn't have to enter in a password if the computer was left on, would you?
It depends on the settings on the computer. If the computer is set to hibernate or go to sleep or reset itself, then yes, you would after a period of time. But if it's not reset and it just stays open, then any user could log in.
Okay, no further questions. We would excuse the witness subject to recall and ask that she stay. Your Honor.
Ask that she stay here, return to her office.
Stay here. We may recall her.
Okay. Judge Bosburn, you may stand there.
solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do. Kevin Stinger, Stenger.
You may proceed.
Thank you, sir. Good afternoon, sir.
Good afternoon.
You are a computer forensic examiner
I am.
and a sergeant with the police department in Orange County.
I am.
Your Honor, I would ask that the witness be recognized as or re-recognized as a computer forensics expert.
No objections from the state? No objections. Ladies and gentlemen, he's still an expert witness. You may continue.
Sir, I'd like to direct your attention to the HP desktop computer in this case, and specifically the net analysis report that was conducted. Are you familiar with what I'm talking about?
Yes, sir.
Okay. After the keyword of chloroform was found, you utilized a software called net analysis to recover that, did you not?
We used two different programs to do it.
Okay. The first one was net analysis?
That's correct.
Okay. And the second one was cashback?
That's correct.
Okay. The first one was done in August of 2008?
I'm not going to be able to tell you the dates.
Okay. Do you have a report of some kind that might remind you or assist you in refreshing your recollection?
I don't recall being the one that actually did the recovery. I am aware of the search, but I don't recall doing this myself.
Okay. Who would have done the recovery then?
It would have been Detective Osborne.
The woman who just left?
Yes, sir.
Okay. Do you recognize the computer printout on your screen, sir?
Yes, sir.
Okay. What is this that you're looking at?
This is a result of the program when it was run. This would be its printout.
And are you familiar with this document?
I am.
Okay. Is it a fair and accurate representation of the net analysis report that was run?
Yes, sir.
Okay. At this time, Judge, we would move this item into evidence.
What says the state?
Is it just this page that he is asking him to review, or do we have a hard copy of the document?
I have the disk, and I have to put on here on the screen that I'd like to question the witness about.
Does the witness view the entire document?
Can you continue going through the documents, sir? Specifically, I'd like to, and I will only be questioning you about the month of March. He's going to scroll down.
Actually marked as an exhibit, so we know what we're speaking about.
What's the identification number?
It is marked as an exhibit, offense with a DD.
Well,
You may. Just a second, we'll go ahead and take care of this other matter. We'll take a recess to 10 minutes to the hour of 4. Thank you. Okay, state recognized presence of the jury. The defense. You may continue.
Thank you, Your Honor. Sergeant Stenger, have you had an opportunity to review Defense Exhibit DK?
I have.
And is it a fair and accurate representation of a report you prepare?
Yes.
Your Honor, at this time we would move State Defense Exhibit DK as evidence.
You may state any objections.
object to the relevant portions of that exhibit and introducing evidence.
We received an evidence. I assume that the state has looked at the exhibit.
There are tabbed pages that Mr. Bias has indicated to me are all he intends to introduce.
Yes.
And I have no objection to those tabbed pages once they establish their relevance.
And I take it they're untapped pages.
Yes, sir, and I will not be addressing those at all. And we can, in fact, take them out, if that makes things
Well,
easy.
you need to take them out.
Yes, sir. Okay. At this time, Judge, we remove that item of evidence. DK.
We received an evidence as defense exhibit number.
Okay, sir. Let's get a little background on this item of evidence. Can you tell the ladies and gentlemen of the jury what it is?
That is a report of the deleted Firefox internet history using a program called net analysis.
And this is a competing software to the cashback software, is it not?
That is correct.
Okay. And this report was run before you even had the cashback, correct?
That's correct.
Okay. And you met John Bradley at a seminar in December of 2009, correct?
That is correct.
And that would have been after you had completed this report.
That's correct.
And you advised Mr. Bradley that you were having problems with his software, right?
Leading the witness on direct.
Sustain.
Did you advise Mr. Bradley that you were having problems with his software?
Sustain.
What, if anything, did you discuss with Mr. Bradley?
I asked Mr. Bradley if he could use his tool to examine the internet history that I recovered from unallocated space. And we had encountered a problem with the fact that dates and times were not being displayed correctly across the entire spreadsheet, because the time period that this covers is the time period from when daylight savings time changes. So in the tool that I was using to begin with, when I set the date and time, half of it would be correct and half of it would be incorrect. So I asked Mr. Bradley if he could use his tool, which was reported to be able to compensate for the fact that these records came from the two different time periods.
And so the only real issue that you were having was daylight savings time.
Yes, sir.
And did the cashback software recover more files or less files from the internet history that the net analysis did?
I couldn't tell you that, sir.
Okay. Do you know if they were identical?
If they were identical?
Yes, the same number of files.
I do not.
Okay. And did Mr. Bradley need some time to fix that issue?
I understand he did.
How many days did it take him to fix it?
It was at least a day.
Okay. Did he have to rewrite his software to make it work?
Detective Stinger, is that based upon your personal knowledge or based upon what someone told you, sir?
That would be based on what someone told me, sir.
Objection sustained.
Did you receive a report that you reviewed when utilizing your opinions that he had to rewrite the software?
Objection sustained. Same question.
Very well, Judge. I'd like to approach the witness if I may.
You may.
Sir, I'd like to direct your attention to March 21st, 2008 at 14:16 hours and 34 seconds. Let me know when you find that.
I found that, sir.
Okay. And that is, what is the website that is addressed with 34 seconds there?
The website is www.sci-spot.com/chemistry/chloroform.htm.
And how many times does it show that that website was visited?
One, sir.
Now I'd like to show you State's Evidence 166.
You may.
I'd like to direct your attention to the same website at 15:16 hours and 13 seconds.
Yes, sir.
How many times does it show on the, well, actually, what is this item?
This item is the report from Cashback.
Okay. And the report from Cashback shows that it was visited how many times?
84.
So there's a difference between the two softwares, is there not?
That is correct.
Okay. And if you look now on the net analysis report for 14:16 at 13 seconds, and tell me what website that is.
Within the net analysis report, there are 4 websites that list the date and time of 14:16 at 13 seconds.
The very first one
is www.myspace.com.
And how many times does it show? Does this report actually show whether the item was typed in?
It says typed on the report. That is correct.
Okay. And how many times does it show that that website was visited?
84.
So MySpace was visited 84 times, according to the net analysis report.
That's correct.
Can you look at the cashback report and see if that is even on the cashback report?
I do not see an entry around the same time.
Okay. So you don't, on the cashback report, even see a MySpace with 84 entries?
No, sir, not at that time.
Okay. Judge, I'd like to publish this page to the jury so I can demonstrate for them.
You may. Defense exhibit numbered what?
Can Your Honor publish it for the jury for me? I'm having the technical issues again. So Sergeant Stinger, what you just testified to was that the chemistry, the sci-spot was visited once for chloroform, according to the net analysis report, correct?
That is right.
And that the MySpace, which is just 2 columns down, was visited 84 times, correct?
Yes, sir.
Now I'd like to refer you to the time of March 20th, 2008 at 13:39 hours and 23 seconds.
Yes, sir.
Yes, this is.
Show it to counsel. You may.
Okay, sir. Do you see 13:39 and 23 seconds?
I do.
And that is 1 day earlier on March 20th, 2008, correct?
That is correct.
And this is MySpace typed in again, correct?
Yes, sir.
And how many times do you see MySpace the day earlier as being visited?
83.
Okay. So you understand 83 comes before 84, right?
Yes, sir.
Okay. And of course, July 20th comes before July 21st. I'm sorry. March 20th comes before March 21st.
Yes, sir.
Okay. Now I'd like to direct you to March 19th, the day before that, at 15:25 with 56 seconds. Let me know when you're up.
The 19th at
15?
Yes.
I don't have any.
I'm sorry, at 8:36 a.m. and 24 seconds. My
8:36:24.
yes.
Yes, sir.
Do you see the date, March 19th, the day before that? The day before the 20th?
Yes, I see March 19th at 08:36:24.
And do you see where it says it was typed?
Yes, sir.
And that basically means that it was typed into the browser?
Yes, sir.
Okay, and that's the part up top where you write www.myspace.com?
Yes, sir.
Okay. And how many times does it show MySpace was visited then?
82.
Now I'd like to direct your attention to March 13th at 10:37 a.m.
A lot of errors.
There are no March
There's-
13th dates.
I'm sorry?
There are no March 13th dates.
You don't have, maybe that was one of the
A lot of errors.
mine. I think I have. Do you see that it was, do you see that date on March 13th?
I do.
May I publish this to the jury on?
You may.
And do you see, sir, that on March 13th, there's an entry that was typed for MySpace 81 times?
That is correct.
Do you see any indication of any of these MySpaces on that cashback report?
You wouldn't, except for the one date that it has in common. That one cashback report is for the single day only.
Okay. And that report, let me see if I get, just so we're clear, that report only has for the 21st, correct?
Yes, sir.
So you can't see on that report the natural progression of the MySpaces, which starts with was visited 81 times, 82 times, 83 times, and 84.
That would only have the information from the history that was on the 21st.
And on that report, it does not include the MySpace that was visited 84 times.
That is correct.
And that MySpace that was visited 84 times is just 2 columns down from the size spot, which it says the size spot was visited 84 times.
In the net analysis report, I believe it's 2 columns down, 2 rows down.
And the cashback program is the one you were having problems with.
No, sir. The net analysis program was the one that was having the problems with the date and time split.
That was only because it was an hour off.
Sustain.
What was it because it was just an hour off?
Yes, sir.
Sustain.
What was the reason?
We were having problems with the dates and times.
Okay. And you don't know if the net analysis report came up with, well, now you know that the net analysis report came up with more internet history than the cashback did you not? Can you see that now?
The reports are different.
And that report, you prepared the cashback report, right?
I created the cashback report. That's correct.
Okay. The one that's in evidence in this case for this jury to consider, you prepared that report.
That's correct.
But you didn't testify to this jury about that report, did you?
No, sir.
And this report that was prepared, State's Exhibit 165. May I approach with?
You may.
You prepared that report as well, didn't you not, sir?
I did.
And that's the report. What is that actually? So
That is a cashback report for March 17th.
Okay. And you prepared that report.
That is correct.
Okay. It's an item of evidence in this case.
Yes, sir.
And you didn't testify to this jury about the contents of that report either.
That is correct.
Okay. Mr. Bradley did.
It's my understanding he did.
Do you know the reason why they called in Mr. Bradley to testify about your report?
Sustain.
If he's aware, Judge?
The witness is not competent to answer that question. Objection sustained.
Yes, sir. If I can have just one moment, Judge. Maybe.
You may.
Now, you don't need to say anything more. Great job. Great job by the defense. What can I say?
Have you ever had another computer expert testify about your reports?
Objection, relevance.
Sustain.
If I may approach, I just want to recover. I don't believe I have any further questions.
Okay, so that was the direct. We're going to take a little break before we get to the cross-examination. Almost done with day 20. It's day 26. Almost done with day 26. So we're going to take a little break. It's going to be a little bit longer than usual because I got some busy things I got to get busy with for a couple of minutes. So just pretend it's a lunch break, and we'll be back hopefully within the hour. All right. Sorry to do this, but that's what we got to do today. So we'll be back within the hour, hopefully. See you all very soon. All right, everybody, we are back. So let's continue with where we left off. Cross-examination. Very important for defense.
Cross-examination.
Thank you. Detective Stenger, you may have printed out that cashback report, but the data contained in it was collected by Mr. Bradley?
State rephrase your question.
How is it that you prepared a cashback generated report? Did you have that software?
Yes.
Okay. And so what process was it that was utilized in order to prepare filtered reports from cashback from March 17th and March 21st of 2008?
I simply set the program up to display only that information from those dates and printed the report.
Okay. The information contained on the report was provided to you by Mr. Bradley?
I actually created the report myself.
The information that goes into the report was nothing that you had worked on, correct?
The program itself generated this information.
Why is it then that you had Mr. Bradley look at your data?
I asked Mr. Bradley to examine the data since he was the person who actually wrote the software. If I had a question regarding an Apple computer and I had the ability to ask Steve Jobs, who is the creator of Apple Computer, I would have done so. The same thing if I had access to the developer of the program, I would ask the developer of the program if he or she was available to examine it if they were willing to do so. And in this case, Mr. Bradley was.
May I have page 1 of the defense exhibit, the one that was highlighted in green and red, and may I publish that to the jury, Your Honor?
You may, and what's the exhibit number?
What's the last number? Let me first ask the witness, do you see that?
I do know.
Oh, I'm trying to use that to scroll down. Can we scroll up on this to wherever the page in evidence ends? To wherever the page that is in evidence ends. Okay. Do you see displayed on this page that was introduced in evidence any of the Google searches that were conducted on March 21st of 2008?
Approximately 8 rows above is a Google search.
Okay. Are the Google searches for how to make chloroform displayed on this page in evidence presented by the defense?
If you can expand the column H, right above the MySpace, you'll see a Google search specifically for the words how to make chloroform, spelled with an A.
May I publish this to the jury, Your Honor?
Direct.
Overruled. You may publish.
All right, since that's been expanded, can you tell the jury what it is that you were just referring to, the how to make chloroform right above the MySpace entry?
When you type a search into Google, you will see the results of the words that you typed in the bar right above when your search returns, and that includes all the words that you actually typed into the search. In this particular instance, the words how to make and chloroform were entered.
Okay. Would it appear that way if somebody typed in a search regarding chlorophyll?
No, it would not.
What is it that you can do in net analysis to determine whether or not the dates and times that appear on net analysis are accurate?
You can simply go in and take a look. Software constantly gets revised, and this would have been several years ago. Since then, changes have been made to different programs that are used. So normally all you do is you go in and you compare the dates in an effort to see if they're accurate or not.
Do you have confidence that the dates and times on this net analysis report are correct? Or would you rely on the report from Cashback as to the date and times for these searches, for these entries in the internet history?
The dates and times on these two different reports appear to be accurate. I can't speak to how they were interpreted by the different programs since I actually did not write the code for either program.
Which column on this piece of evidence displays the date and time that this internet history was made?
Can you scroll all the way up to the top of the column?
Here, I'll unpublish that. And does that assist you in
Yes.
refreshing your recollection? Okay, and if we can scroll back to the part that's in evidence. May I republish that?
You may.
Which column would that be? You can use the telestrator if need be.
The first column, 14, 16, 34.
Did I accurately place a box around that?
Yes.
So even in the net analysis, the times between the myspace.com entry and the next how to make chloroform are 20 seconds apart?
Yes, ma'am.
No other questions, Your Honor.
Redirect on those issues and those issues alone. You may.
The visits for chloroform that are on the net analysis report show that on March 21st of 2008, those were the very first time those websites were visited. So it's only one time, right?
In which report?
For the net analysis report. Can you see that?
I don't have that up on screen.
May I publish to the jury as well?
What are you going to publish?
The item that's in evidence defense, I believe it's.
What it is, Madam Clerk? Yes, you may.
All these websites were just visited once.
According to the net analysis report, correct.
And then this right here, maybe the second time. Correct?
Yes, sir.
And the total amount of time spent on those websites, could you look at that and see approximately how much time anyone spent looking at chloroform before moving on?
Approximately 3 minutes.
3 minutes of time. Now, your cashback that doesn't show the MySpace entry, you purchased this after you had purchased the net analysis software?
That's correct.
Okay. And it doesn't have certain items that net analysis does?
That's correct.
I gotta get your cashback.
Sustained.
Now, sir, were there any other issues that you had with the cashback program?
I didn't encounter any problems with the cashback program.
And the only problems that you had with net analysis was just the time?
That's correct.
Okay.
Recross.
It's true, is it not, that even if the consecutive entries on an internet history show that those were done in a 3-minute time span, that doesn't negate the fact that the user could just be opening up new tabs in their internet search, correct?
That's correct.
So each of these tabs can be open for minutes or hours until the person decides to close the tab again, correct?
Correct.
So the fact that these entries are in the internet history shows that they were done in a particular sequence, but tells us nothing about how long that person spent reading whatever was on the web page or whether or not they actually printed that item for subsequent education.
That's correct.
Thank you, Your Honor.
As to that issue.
This report here, does that give you any indication about this tab stuff?
No, sir.
So what was just asked you, that's pure speculation, is it not? You don't know if that ever happened.
I do not know if that happened.
And you're a detective, you're a sergeant involved in this case, correct?
Yes, sir.
And has anyone ever informed you that through the search warrants or at any time there was any pages recovered that were printed out that has anything to do with chloroform?
Nobody informed me of that.
No further questions.
Excuse. Thank you, Sergeant. You may be excused.
Thank you, Your Honor.
Okay, ladies and gentlemen, the jury, that concludes the presentation of witnesses for today. We have some legal matters we need to take care of that will expedite things in the morning. Again, have a good evening and abide by all of my previous admonitions. Thank you. Good morning. Let the record reflect that the defendant is present along with counsel for the defendant, Assistant State Attorney. Both sides ready to proceed.
Yes, sir.
Okay, who will be the defense's first witness?
It would be Cindy Anthony. If I can have just 3 minutes, Your Honor, we're still marking items for exhibits.
That's why I asked y'all to be at 8:30.
We have been, and there's some things that we wanted to add that weren't previously there.
Okay, let's get to it.
Yes, sir.
Okay, what are y'all trying to mark? Okay, let's return to jury. Good morning, ladies and gentlemen. The jury, did you heed all of my previous admonitions? Okay, does the state recognize the presence of a jury? And does the defense?
Yes, sir, we do.
Defense may call the next witness.
Defense calls Cindy Anthony.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? So help you God, yes.
You may proceed.
Thank you, Mr. Court. Ms. Ring. Good morning, ladies and gentlemen. Good morning, Mrs. Anthony.
Good morning.
I wanted to talk to you, ma'am, about the shorts that Kaylee was found in when they found her remains off Suburban Drive. You've seen a photograph that's been introduced into evidence of those shorts, correct?
Yes.
And you testified previously that the shorts no longer fit her?
I testified that she was at the last time I saw her, she was in 3 toddlers, 3T.
And though that photograph was taken, you said early 2007.
Yes, I believe it was spring of 2007.
Is Kaylee like every other child that grows incredibly fast or grew incredibly fast?
Kaylee was on the high end of the growth chart, yes.
And that day when that photograph was taken, you actually videotaped her on that day, did you not?
Yes.
Okay. And I'd like to bring up the video so you can see and identify.
Relevance.
Approach the side, bro. You may proceed.
Thank you, Your Honor. Mrs. Anthony, you've had a chance to review this video,
Yes.
correct? And it is the video that's marked. That's EH. Mrs. Anthony, may I approach the witness room?
You may.
And ma'am, is the video a fair and accurate representation of what Kaylee's size was back in early 2007?
Yes.
And is it a fair and accurate representation of what occurred, of her size and everything, her interaction?
Yes.
Judge, at this time, we would move defense item EH into evidence.
It'll be entered in evidence as defense numbered.
We would at this time like to publish that video to the jury, Your Honor. See it? Yeah. Ladies and gentlemen, the jury see it. Let's play. Mrs. Anthony, how much had Kaylee grown since this video was taken?
She's grown quite a bit.
And how do you know this video was taken in early 2007?
Because the date stamp on it says April of 2007. And I remember the clothes I was wearing at that time, the skirt that I was wearing kind of was out of date after that. I didn't wear it much after that.
Now, you've seen, what you're referring to are things that we haven't seen.
No.
Right. And you've seen this video numbers of times.
Yes.
And you were wearing a skirt that was out of date. Can you tell us exactly why you believe that was taken early of 2007, aside from Kaylee's size?
I watched that video hundreds of times since I haven't seen Kaylee in 2008. And there's still pictures of me holding Kaylee on the same day. And I recall the skirt, it was like a Hawaiian print. And even though I still have the skirt, I hadn't worn it. I don't recall wearing it after that. It was kind of like not popular after that.
Okay. I'd like to now show you photographs that have been marked. I'd like to show you today. May I proceed?
Mike?
Do you recall I've shown you this photograph and you've testified about it previously?
Yes.
Okay. And is it a fair and accurate representation of you and Casey at your brother's wedding?
Yes.
Judge, at this time, we will move defense exhibit A into evidence.
What says the state? Relevancy for this testimony?
If you like, I can proffer at sidebar. I think it's
You
been
may.
made relevant.
Objection sustained.
now show you a photograph of this defense exhibit DO.
You may.
Do you know what that picture is of?
Yes,
And can you tell the ladies and gentlemen of the jury what it is a picture of?
it's a picture of our backyard swimming pool.
Okay. And is that a fair and accurate representation of what the pool looks like with the ladder connected?
Yes.
Okay. At this time, Your Honor, we would move defense DO into evidence.
What says the state? We received an evidence that states defense exhibit numbered.
I would ask to publish it to the jury, Your Honor. Mrs. Anthony, does this ladder disconnect?
Yes.
Okay. And can you use the tool there and show the ladies and gentlemen of the jury how you would disconnect that ladder?
Right at the top, there's a little hinge there, and you just lift it up, and then the ladder comes off. You just pick it up, and it comes off.
Now I'm going to show you the DS. May I approach the witness, Your Honor?
You may.
And what is the photograph that I've just shown you, ma'am?
It depicts where we would place the ladder after we removed it.
Okay. And is it a fair and accurate representation of what your pool looks like when the ladder is down or
Yes.
off?
Yes.
Your Honor, I would at this time move into evidence defense exhibit DO.
What says the state? We received an evidence as defense exhibit numbered.
May I publish that to the jury?
Yes.
May I approach the witness? And is that another photograph of your swimming pool?
Yes.
And is this just a slightly different angle of what the ladder looks like when the ladder's off and off?
Yes.
Is it a fair and accurate representation of such?
Yes.
Judge, at this time, I would move into evidence defense exhibit DT.
What says the state? It will be received in evidence as defense exhibit numbered.
May I publish to the jury?
You may.
May I approach the witness with DU?
You may.
Do you know what that photograph is of, Mrs. Anthony?
Yes.
Would you like to take a break? Do you need a break?
No, I'm okay.
Can you tell the ladies and gentlemen of the jury what that is?
It's a picture of Kaylee walking up the ladder, and I'm behind her holding her.
Okay, approach.
May I approach the witness, Your Honor, as we proceed?
Yes.
Mrs. Anthony, I'm showing you a photograph of DU. When was that photograph taken?
I believe it was the summer of 2007.
And this was approximately 1 year before Kaylee passed away.
Yes.
And is that a fair and accurate representation of what it depicts?
Yes.
Your Honor, at this time we would move item DU into evidence.
Noted, let me see this. Noted previous objections, objection would be overruled. It would be received in evidence as defense numbered.
May we publish to the jury, Your Honor?
You may.
Since this photograph was taken, can you describe what you're doing here, Mrs. Anthony, or what Kaylee's doing?
She was climbing the ladder, and
And how much are you supporting her? In her efforts?
my hands are on her, but not firmly. They're right there, just like a light touch.
And after this time period, as the year went on, did she become better at climbing the ladder of the pool?
Oh, absolutely. Even at that point, she could climb into the pool by herself.
And for safety reasons, you would always just be there as a safety net.
Yes.
I would like to now approach the witness, Your Honor, with defense exhibit DV.
You may.
And what is that photograph of, ma'am?
It's Kaylee still climbing the ladder. It's just another image from the last one.
And is that where she's a little further along up the ladder?
Yes.
Is that a fair and accurate representation of what it depicts?
Yes.
Your Honor, at this time we would move defense exhibit DV into evidence.
What says the state? Okay. Objection will be overruled. Be received in evidence as defense exhibit number.
May I publish to the jury, Your Honor?
You may.
May I approach the witness, Your Honor?
You may.
May I unpublish, Your Honor?
May.
What is that photograph DW of? What's happening?
It's Kaylee, that same day when she made it to the top platform of the ladder.
And is that a fair and accurate representation of what that depicts?
Yes.
Could you read the letters on the back? I want to make sure we're getting. Is it DW?
Yes, DW.
Judge, I would at this time move DW into evidence.
What's asked the state? Objection will be overruled. Be received in evidence as defense exhibit numbered.
May I publish to the jury?
You may.
May I approach the witness, Your Honor?
May.
Mrs. Anthony, what is the photograph depict that you're looking at?
It shows me attempting to go around Kaylee as I usually did. We used to have Kaylee sit once she got to the platform with her feet on the first step in the water, and then whoever was with her would get around that way. We would get in the pool before her and then receive her.
And is that a fair and accurate photograph of what it depicts?
Yes.
And the letters on the back side of it are?
DX.
Judge, we at this time would move defense exhibit DX into evidence.
What says the state? Objection will be overruled. Will be received in evidence as defense exhibit numbered.
May I publish to the jury?
You may.
Now, Mrs. Anthony, this is a photograph of Kaylee on the first step getting in the pool?
Yes, the first step on the inside ladder.
Now, you're actually behind her, correct?
Yes.
Did she often get anxious to get in the water and sometimes want to get ahead of you?
Overruled. You need to repeat your objection. The court reporter did not hear your full objection.
I said objection to relevance. It's also improper opinion testimony.
That's the second. As to the overrule.
You can answer.
For the most part, she, would just sit there and wait for us. Occasionally, especially as she got older, the following year, she was a lot more anxious because she was more familiar with the pool. As she got older, she would run, but we'd still have her wait. But we always had a life jacket on her. So.
And during the summer of 2008, how often did Kaylee go swimming?
I can't remember when I put the pool together. It was probably sometime, maybe March or April. So she probably would have swam maybe 3 to 4 times a week.
And that was always with the life vest on?
Yes.
And when you were on vacation during June of 2008, was it 1 week or 2 weeks off?
I had 1 week off at that time.
How often during that week did Kaylee go swimming?
Every day.
Your Honor, may I approach the witness with defense DY?
You may.
Can you tell the ladies and gentlemen of the jury what that photograph is of?
Yes, it's me entering the pool and holding on to Kaylee, and Kaylee was in the pool.
And is that a fair and accurate depiction, representation of what it depicts?
Yes.
Can you read the letters on the back?
DY.
Your Honor, at this time, we would move the defense exhibit DY into evidence.
What says the state? Objection will be overruled. You received in evidence as defense exhibit numbered.
May we publish to the ladies and gentlemen of the jury, Your Honor?
You may.
Mrs. Anthony, is this at a time period where you were trying to get in the pool?
Mm-hmm. Yes.
And does Kaylee appear to be anxious to swim off, but you've got to hold her?
Yes, once I made it to the other side and got my feet in the water, it was usually okay for her to start going in. I had to be at least on the other side of the ladder. But yes, she was anxious to get in.
And did you take numerous precautions around the pool with Kaylee?
Yes.
Can you share with the ladies and gentlemen of the jury some of those precautions that you would take?
We made sure that once Kaylee started walking, we used to have a pole deck. A pole box, a deck box right next to the pool. And it was just a little bit further from where the ladder was in that picture where it showed that the ladder was down. And once Kaylee was a toddler, and we moved that and put it up against the house, where you can see in the background where it looks like a ficus tree, and then there's 2 hangings on my house right back there. It was below that where the tree is, right below that area. We put the deck box so that she could not climb up on the deck box to get into the ladder. And we took extra precaution every day to keep the ladder off the pool unless we were going swimming. And then we put it on and then we take it off. We also made sure that we taught Kaylee that she had to be with us, one of us, to go into the pool, and that she had to wait for us. I mean, we took precautions on teaching her how to go up the ladder and down the ladder, backwards and forwards, just like you would stairs in a house, so that we knew she could come up and down, but we told her that, we had to be with her, and why. We showed her why she could get hurt. And we kept the life vest inside the back patio. Kaylee's wearing a swimsuit at that time frame with one of those.
Let me stop you there. Did this vest fit her a year later, or did you buy another one?
No, that one was actually the second one we had bought for her. She grew out of the first one, and then she grew out of that one, and we actually bought a removable life vest that would go over her suits.
Now, these photographs, they were taken after the video that we showed the ladies and gentlemen of the jury first, right?
Yes, a few months later.
And she even outgrew this vest as well?
Yes, by the following summer, she had outgrown that vest.
Okay. Now, I'd like to show you Defense Exhibit EB. May I approach the witness, Your Honor?
You may.
Can you tell the ladies and gentlemen of the jury what that photograph depicts?
It's a picture of Kaylee at the sliding glass door from the living room going into our screen patio.
Now, does Kaylee appear to be much bigger in that photograph?
Yes.
And is that a fair and accurate representation of what that photograph depicts?
Yes.
Your Honor, can you tell us the numbers on the back?
EB.
Your Honor, at this time we would move Defense Exhibit EB into evidence.
What's asked the state? Objection be overruled. Received in evidence is defense exhibit number.
Your Honor, at this time we'd like the jury. Prior to the last time you saw Kaylee, was she about this height, or was she bigger, or can you describe her size?
She may have been an inch taller. It's hard to. Just trying to figure out where that door would hit me. She might have been a little bit taller, but she was also wearing tennis shoes in that picture, so it might be the accurate height if she was in her bare feet versus those tennis shoes.
And did Kaylee ever leave the house barefoot?
You mean to go out in the backyard?
No, I mean leave the house to go to the store or things like that.
No, we always. I mean, I'm 99% sure that we put shoes on her every time we went out. She liked to wear shoes, actually.
And was it your custom to always put shoes on her?
Yes.
Was it Casey's custom to always put shoes on her as well?
Sustain this for the last question.
And the sliding glass door that you have here, I know some of them have like bars that preclude them being opened. You don't have one of those on this door, do you?
No, we didn't put one in, no.
Now, could Kaylee open doors fairly easily at her age?
Yes, you could.
Okay. Can I unpublish?
You may.
Now, on June 16th, 2008, did you come home and notice that the pool ladder was up as depicted in the photographs?
You mean on
the ladder?
Yes, it was attached to the pool.
And was that a highly unusual event for you to see that?
Yes, so much that I called George at work to see if he had left the pool ladder up, because I also noticed that the side gate was open at the same time.
And the next day, did you go to work and tell anyone?
Yes, I think so.
Who did you tell when you went to work about the pool ladder being on your pool?
It was probably either Debbie or Charles or both.
When you say Debbie, are you referring to Debbie Bennett?
Yes.
Or Debbie Polisano?
Debbie Bennett.
Okay. Would you have told Debbie Polisano?
If she was back in our work area, she might have heard me say that. A lot of times when I come in the morning, Deborah Polisano would be in the kitchen, which was right next to our work area, making a cup of coffee. So we had cubicles, so you could hear just about everything that went on in the back if you were back there.
And why did you tell your coworkers about the pool ladder being up?
Sustain.
Now, during this time period that you were, June 16, 2008, were you having any marital problems?
Sustain.
May we approach?
You may. Okay, ladies and gentlemen of the jury, we're going to take our standard 15-minute recess unless you want another one, a special one. That would be nice. Okay, we will. To 25 minutes past the hour, that should be enough time for you to take your special recess. I'm going to ask you not to discuss this case among yourselves, nor with anyone else. We'll be in recess to 25 past. You may be seated. Let the record reflect that the defendant is present along with counsel for the defendant, assistant state attorney. I've reviewed the Mateo case, which was found at 932 7 2nd 376, a 2006 decision of the Second District Court of Appeals dealing with the issue of theory of defense. Exactly, Mr. Baez, you correct me if I'm wrong, but your theory of defense was that this was an accidental drowning, that your client's behavior subsequent to the drowning was caused by long-term sexual abuse of Miss Anthony at the hands of her father and brother, correct? Well, among other things, like what? Because that's the only thing you said in your opening statement. I've reviewed the case. I've reviewed the cases that are cited within this case, and all of these things, the Mateo case had to do with issues of police retaliating. In Mateo, the state had agreed to stipulate to a tape where the witness who was going to predicate the tape became ill, was going to have surgery, and couldn't show up, and then the state sort of semi-reneged on their promise, and then interposed an objection of relevancy, and as long as the evidence is relevant to that particular issue and also admissible. So what is your theory of defense? Because you cannot use the broad blanket of theory of the defense to just get any and everything in. So if I'm mistaken, and the only thing I can base it upon is what you said in your opening statements, that's why I admitted the photographs of the victim, Kelly Anthony, climbing up the steps into the swimming pool. Now, if your theory of defense is ever changing, maybe you just simply need to tell me what your theory of defense is. At least somebody try to explain it to me. Yes. Let's have the witness resume the witness stand. You guys return to jury. Okay, state recognized presence of jury. The defense.
Yes, sir, we do.
You may continue.
Thank you, Your Honor. Mrs. Anthony, on July 16th, 2008, did you advise the lead detective, Yuri Melich, about the ladder being left up on the pool? Hearsay for statement.
Overruled. Your advice and answer should be either yes or no answer.
Yes.
And was that within 24 hours of calling the police?
Yes.
And how many times have you advised law enforcement that you thought Kaylee had drowned in the pool? This is most recent fabrication, Judge.
Sustained.
Was this a topic that you constantly brought up with law enforcement?
Approach the sidebar. Objection sustained. Next question.
We have no further questions.
Cross-examination.
Thank you. Good morning, Ms. Anthony.
Good morning.
Even after your granddaughter Kaylee was missing from your home beginning in June of 2008, you maintained her bedroom, correct?
Yes, I did.
You kept all of her clothes in the drawers?
Yes, I did.
You even kept any presents that she had received because while she was missing and before her remains were found, she had a birthday.
Yes.
In the past, as Kaylee began to outgrow certain clothing, you would have garage sales, correct?
Yes, ma'am.
And you would get rid of clothes that were too small.
Some of them, yes.
Right? Or you would store them in plastic containers so that they could be maintained, perhaps to sell later or for some other purpose.
Correct.
On June 15th of 2008, was Kaylee potty trained?
She was pretty much potty trained, but we would still carry diapers if we went out. A lot of times she would just wear little panties.
Underwear?
Yes, underwear. And if we were at home, then that's what she would wear. If we went out, we would have pull-ups on her just in case we were driving or someplace where we couldn't get to a restroom quickly. Little kids usually wait till last minute to tell you that they have to go. So
when did Kaylee make the switch from full-fledged diapers to pull-ups?
Oh, wow. I don't know, probably sometime early of 2008.
In the photograph, which is introduced as states 314 in evidence, may I? Is Kaylee wearing a diaper, a pull-up, or underwear?
It's hard to tell.
I don't think the photograph calls for speculation. Based on
Overall?
that photograph, it calls for speculation.
Overall?
It looks like either a pull-up or a diaper. It doesn't look like a panties. It looks, it's up, it looks like it could be a diaper or a pull-up.
There's something coming out of the back of the shorts.
Yes.
Is why you're making
Yes.
that assertion. And it is your testimony that she was wearing those pair of shorts in April of 2007, correct?
Yes, ma'am.
Okay. You recognize in prior testimony in this court that you've said that those pictures were taken shortly before her second birthday, which would be August of 2007, correct?
Yes, ma'am.
Proper impeachment.
Overall?
Yes, I stated that it was, several months before her second birthday.
So in 2007, based on the testimony that you've already given here this morning, Kaylee was still wearing diapers.
Yes.
If I may approach the witness with a series of photographs marked RF, RE, RG, RH, RI, RL, RK, and RJ for identification.
You may.
We talked about this before.
It would George, myself, or Casey. It was mostly myself or George.
Who bought Kaylee's clothing?
Casey and I, and relatives and friends. I mean, typical. She got a lot of gifts, but primarily Casey and I did.
Did you do a lot of shopping at Target?
Yes, ma'am.
You recognize that the Circo brand on a lot of Kaylee's clothing is a Target store brand, correct?
Yes, absolutely.
Can you take a look at those photographs that have been handed to you and tell me if you recognize any of the clothing in the photographs? If there is something that you don't recognize, segregate that out.
Object at this time, these photographs do not show clothing, they show tags.
Tags on clothing.
Objection overruled. She's just looking at them from now. She's not testifying to them.
Do you recognize everything in all of those photographs?
The only one I'm not certain of is RE. I'm not sure if that's a shirt or a dress, and it looks familiar, but I can't say what it is.
All right, keep that one side then. What do you recognize the other items to be?
Mostly tops and a pair of shorts, one pair of shorts that's Kaylee's.
And where do you recognize them from?
Her room.
Were those clothing items that were in Kaylee's room in June of 2008 and maintained there by you until they were seized by law enforcement?
I believe so.
So what size clothing did you have in Kaylee's drawers?
I had 2 tees. Those depicted 2 tees, but there was 3 tees as well.
Now, like many children, Kaylee was a little bit stocky when she was a baby, correct?
Yes.
And as she got older and more mobile, she began to thin out.
Yes.
That process takes place, or took place with Kaylee, sometime between the age of 1 and 2, and as she becomes even more mobile as she approaches the age of 3, correct?
Yes.
It would be fair to say then that there are clothing items that Kaylee had that could last for as much as a year, even if she's growing taller, correct?
Yes, ma'am.
These shorts that we looked at states 314 in evidence, and the ones displayed in the video that we saw during your direct testimony, those were shorts that were kept in your house, weren't they?
Yes, ma'am.
When was the last time you saw them?
Sometime in 2008, towards the end of 2008. Those shorts?
Yes. When was the last time you saw them before June 16th of 2008?
Oh, you mean, what, excuse me, I'm not sure. Are you talking about the pictures you just showed me? Okay, I thought you were talking about the pictures we just looked at. I'm sorry. Okay.
Were those shorts kept at your house?
Those particular shorts, I hadn't recalled Kaylee wearing those shorts for some time.
The question was, were those shorts kept at your house?
You mean every day? There was several pieces of clothing throughout Kaylee's life that wasn't at my house every day.
Would that be because they were packed in some sort of diaper bag or backpack?
Calls for speculation. The witness testified she hasn't seen the shorts in over 6 months. So the question is posed to ask her to speculate.
Overruled.
Can you repeat it?
We were talking about the fact that there were clothing items that you would have recognized as having been in the home because you washed the clothes or you bought the clothes that were sometimes transported in a diaper bag or in a backpack.
That's correct.
Correct. And then you had seen or had knowledge of that diaper bag or backpack being placed in your daughter's car, correct?
Yes, or my car.
Or your car or your husband's car,
Yes.
whenever you all might have taken Kaylee somewhere.
That's correct.
You had to change clothes.
Yes.
You. So do you have any recollection as to the last time you may have seen those shorts that are in the photograph that I handed to you or that had appeared in the video that you indicate was taken in early to mid 2007?
I'm sorry, can you repeat that one more time? I just want to make sure I get on the same page.
When was the last time you saw those shorts?
Those weren't shorts that I dressed Kaylee in quite a bit. I mean, there was quite a few things that I didn't dress Kaylee in, and that outfit was not one of my favorite outfits. And she had more clothes hanging in her closet than she did there. So unless Casey had her in them, and she may have worn them after, but I didn't see her that much after 2007. I do not recall seeing Kaylee in those shorts after 2007.
Okay. The photograph and the video taken of her in the shorts was taken at your house, correct?
Yes, ma'am, it was.
So you would agree that it stands to reason that at some time those shorts were kept at your house?
Yes, like I said, they were at our house, but no, I can't say they were there every single day. Yes.
Okay. The picture of the ladder that you testified about, how heavy is that ladder?
I don't know the actual weight. I know I can't lift it with one hand. I have to use 2 hands to lift it.
You would agree that it is nothing that Kaylee would ever be capable of moving or manipulating on her own, correct?
Correct. She could not.
How heavy is that sliding glass door that you showed us in the picture with Kaylee touching the handle?
You have to put a pretty good force to it to open it up.
Now, even though Kaylee was 2, almost 3, the last time you saw her, she was a very compliant child.
Yes, ma'am.
And it was your testimony that you were very careful to give Kaylee instruction about whether that's going outside or putting on any sort of life vest or climbing up the ladder of the pool.
That's correct.
How deep is the pool?
I think we went through this before. It could go up to 4 feet, but we don't fill it up naturally all the way to the top, so it's just a little bit under 4 feet.
Standing outside of the pool, can an adult reach in to retrieve objects in the pool if they are not at the edge?
You have to be at the edge of the pool to reach in and get an object.
Okay. If an object is not at the edge, but you are, can you reach in and retrieve it without getting wet?
No, not unless it's within a few inches from the edge of the pool.
When was the photograph taken of Kaylee at the sliding glass door?
I can't tell you a month, but I would say it was probably the spring of 2008.
I also imagine that you would never permit Kaylee to be left home alone at your house.
Absolutely not.
One of the things that you testified on direct examination had to do with the incident that you discussed relative to the ladder being back on the pool and the side gate being open. Remember
Yes, I
talking
remember
about that?
Yes.
It was your testimony on a prior occasion. Would you agree that there is absolutely no way that Kaylee would have been able to open that gate?
Oh, there's no way she could open the gate to the from the backyard to the front yard. There's no way.
And as far as the date of that ladder incident, you have in the past testified that it was in the week before the gas can incident, haven't you?
Yes.
Okay. Today you say that that was the night of the 16th, but do you acknowledge that you've said it was the 17th or even subsequent dates during that week?
Yes. I mean, when I was looking back, early on I was asked about it, and I knew it was either the 16th or 17th. I knew it was in those first 2 days after I didn't see her anymore.
You said that you called George when you made that discovery.
Yes, I did.
Did you call George from the house phone?
I'm not sure if I used the house phone or my cell phone, but I did call George.
Okay. Well, those would have been your only two options, right? The house phone or the cell phone.
Correct.
And if George wasn't at the house, as a call to him would suggest, you would have only the option to use his cell phone.
Correct.
To reach him.
Correct.
It's not like there was a work phone where you could get him at his security job. You had to call him on his cell phone.
He had two phones. He had a work phone and his cell phone. And sometimes I did call him on his work phone if he didn't pick up on his cell phone, or he would call me, from either or, depending on, which phone he was using.
Do you recall if you left a message for him that day, or did he pick up when you called?
I know I spoke to him. I can't remember if I spoke to him after I had left a message or not, but I know that we had communicated.
You acknowledge as well that as it relates to dates in June of 2008, that you've already made other errors. Specifically, when you filled out your initial sworn statement, you indicated the last time you had seen Kaylee was.
Just a second. Response outside the scope.
Your Honor, we're talking about, he in direct examination asked questions about specific dates. I'm attempting to get the witness to acknowledge that she has made errors on dates in June of 2008 in the past.
Overruled.
Ms. Anthony, you recall that your first sworn statement to law enforcement as to the date that you last saw Kaylee had an error, correct?
Yes, ma'am, I do. I'm aware of that.
You had indicated that the last time you saw her was actually a week prior to Father's Day.
Correct.
And it was the video of her with your dad.
Yes.
That refreshed your recollection as to the accuracy of that date.
That's correct.
You said that you went to work and told some of the people at your office about the incident with you believing somebody was swimming in your pool.
Yes.
Okay. You also told them about the gas can incident that was reported to the police on June 24th, correct? I'm not going to ask her questions about that. I'm asking about what she is reporting to her coworkers, since there was a question about, did you tell them at work about certain things that happened in June of 2008?
Overruled.
Yes.
Are you sure you were at work on June 16th of 2008?
Yes, I know I was at work on June 16th of 2008.
Okay. Your time card reflects that you were at work on June 16th of 2008, does it not?
I would imagine it would, but I haven't reviewed that time card in 3 years.
May I approach the witness with 318 in evidence?
You may.
Have you located the entry for the week ending? Let me think. 20. Yes. Shows you were at work on June 16th of 2008?
Yes, ma'am.
Okay. That's accurate? Yes. Are you sure you were at work on June 17th of 2008?
Yes, without looking at this, I'm sure I worked June 17th.
Every day that week?
Yes, I had
Through the 24th of June when the gas can incident was reported?
Yes, I had just come off vacation. So yes, I was back to work.
Okay. That time card accurately reflects that June vacation, doesn't it?
Yes, it does.
Your daughter Casey was home between August 22nd of 2008 and October 14th of 2008, correct?
Sustained.
Did you have contact with your daughter aside from what was on the videos that were done at the jail?
Outside scope, Your Honor.
Sustained.
You showed us photographs of Kaylee getting in and out of the pool. Did your daughter tell you that there was an accident involving the pool?
Objection, Judge, outside scope.
Overruled.
No, ma'am.
In fact, she continued to assert to you after July 15th of 2008 that the child was kidnapped by a babysitter, correct?
That's correct.
Those are all the questions I have on the issues presented, Your Honor.
Redirect.
May I approach the witness, Your Honor?
You may.
This is Anthony. I'm showing you the photographs that Mr. Rayburn just showed you. States RD, states RF, RG, RH, RI, RL, RK, and RJ. Now, first off, those are just photographs of tags, are they not? You can see some of the garment, can you?
Overruled.
That's true on all but one.
Okay. And are all of those garments pretty much knit type garments? Material.
All but one.
Okay. Can I show you that it's not? Now that one that you showed me, that is of jean material, correct?
Like a cotton. There's pictures of jeans in the background, but that one's like a cotton.
And the shorts that Kaylee was found in are jean type material, correct?
They're a cotton type material.
Okay. The knit material is material that is much stretchier. Would you agree to that?
Absolutely.
Okay. So are Kaylee's clothing, does Kaylee grow out of clothing that are of that rougher, thicker material a lot faster than they would of the knit material?
Yes.
And you also have kept lots of clothing from Kaylee that she has outgrown, have you not?
Oh, yes.
You haven't sold it all at yard sales?
No, most of her stuff we have kept.
Okay. And a lot of this would be kept in Casey's room?
We had 3 locations, depending on whether or not Lee was home. If he was living at the house, then we wouldn't use that closet. But when he moved out, we used that closet or Casey's closet because she really didn't have a closet. She had an armoire. And then the drawers in her, dressed in her armoire, and then the changing table was full of drawers.
So Kaylee's clothing that she had outgrown would have been kept throughout the house?
Correct.
And the jeans, the shorts that Kaylee was found in, you testified with Mr. Burdick that you hadn't seen it for several months, right?
I hadn't seen her wearing those for several months.
And the only occasion that you would see them is if you had the occasion to wash them, right?
Correct.
You don't, back in those days, you weren't deciding to, I haven't finished.
Stay.
Where on those days, where in early 2008, was it a frequent custom of yours to just go looking for clothing that didn't fit Kaylee anymore?
There were specific times that I would go through Kaylee's drawers, like Christmas time. If she received a lot of gifts, you would tend to take out the ones that were smaller and then put the larger size in. Birthdays the same way, any holidays.
And would you do these, would you best characterize that as spring cleaning type deal?
Or if I was putting something on her and noticed it was too tight, I'd note that. Sometimes I would set it on her dresser or may even leave it in the drawer with the intention to go back and go through all the clothes to kind of see if I had time to go through and see what fit and what didn't fit.
And unless you were washing these clothing, you wouldn't see them on a regular basis.
That's correct.
And that's consistent with what you just said, what you testified to, that you hadn't seen those clothing in a long time, those shorts in a long time.
I would say so.
And I know that this is going to sound odd, but Kaylee was a child, right? Almost 3 years old.
You mean instead of it being a baby?
Yes. She was a regular toddler.
Yes.
And as to her being obedient or not, did you treat her and discipline her like as if she were in the military or anything like that?
No.
Okay. Were you overly strict with her?
No.
So she ran and played like any other toddler?
Well, depending on her surroundings.
And she was just your average, if not above average, toddler?
I felt she was above average.
Thank you. No further questions.
May witness be excused? Any more questions from the state?
Just very briefly. Mrs. Anthony, the fabric in the shorts that you were talking about, they're pink cotton?
Yes, ma'am.
Shorts. Was that the same fabric as the shorts in the photograph? I believe it's 314. You can correct me if I'm wrong, but the one that we saw that you said was taken in 2007. Yes, it's similar. The sturdy cotton that has less give than a knit fabric. Yes. That's all I want to clarify.
Okay, may Mrs. Anthony stand down. Thank you, ma'am. You may stand down.
Thank you.
The defense may call their next witness.
Call Lee Anthony.
All right, back to Lee Anthony now. How are we going to get George one more time?
You may.
Lee Anthony, L-E-E-A-N-T-H, online.
Good morning, Mr. Anthony.
Good morning.
Mr. Anthony, did you at one time own the white Pontiac Sunfire?
Yes.
Okay. From what year to what year did you own that car?
Approximately 2000 until early 2005.
I'd like to show you some photographs. Your Honor, I'd like to publish to both the witness and the jury states Exhibit 47, 79, and 80.
You may publish.
Can you see that, sir?
No, you want me to do it?
Thank you, Judge.
Yes, I can see it.
Is that the white Pontiac Sunfire that you once owned?
Yes, sir, it is.
Okay. I'd like to now show you photographs. States 79. You see that, sir?
Yes, I do.
Does that appear to be the trunk of your of the car you once owned?
Yes, it is. I recognize the amplifier in the back.
Okay. Give me a second. I'm trying to clear up the glare if I can. Okay, can you see that now?
Much better.
Okay. Now, when you owned this car, was there a stain in the trunk of the car?
There were a few, yes.
Okay. Can you show with the illustrator, just kind of circle on the screen where these stains were?
Okay. I specifically remember there being 3. They were all outside of the
Go ahead and mark on the.
Okay, they're all outside of the tire cover. There was one there approximately. There was one higher up below the amplifier, and then there was a smaller one just kind of on the side over here.
And were they there when you purchased the car?
From everything I remember, yes. I remember seeing those numerous times throughout the time I owned it.
Did you have an occasion to stay in the trunk of your car on any occasions? How long did you own it again? I'm sorry.
Almost 5 full years.
So in those 5 years, did you ever create any stains in the trunk?
I'm sure I may have, but I don't recall specifically making any of those 3, but I do remember seeing them. You know, it was just normal to see those.
Okay, I'd like to show you another photograph. Is this a little better view of the trunk?
Yes.
Can you show us where?
States what?
States 8.
Thank you.
Can you show us where on this photograph the stains were?
Sure. And then the other was off the picture.
Okay. And how long would you say those stains were there?
If not I don't know for sure. More often than not, longer than for the majority of the part that I owned them, if not the entire time I owned them.
Now, they don't come up too well on these photographs.
No, they don't. No, they don't.
But they were there when you would be able to see it. Is that correct? When you
Absolutely.
opened the trunk?
Yes.
Okay. May I unpublish, Judge?
You may.
The jury's finished. Mr. Anthony, can you tell us when's the first time that you noticed that your sister was pregnant?
You may. Objection overruled.
Can you first tell us about the very first time you suspected that your sister was pregnant? Or noticed?
Yeah, it's hard to give an exact time, but it would have been early to mid 2008.
Now, this was during the time that you were living in the home?
Yes, I had not moved out at that point.
Okay. And describe to the ladies and gentlemen of the jury how that occurred.
How I saw Casey?
Yes, how you first saw Casey showing.
Okay. It would have been later at night. Our bedrooms are right next to the bathroom, so I was waiting for her to get out of the bathroom, and when I went in when she was coming out, I could see her, midsection, and it was showing. So at that time, it struck me as odd because I guess I just hadn't noticed it prior to that.
And what did you do with this information once you saw this? What did you?
Overruled.
I believe I made some kind of comment towards Casey that said, like, excuse me, what the hell is that? And she just kind of waved me off. And then the next time I would have seen my mom, probably in the next couple of days, I recall asking her, is Casey pregnant? Looks that way to me.
Not responsive narrative.
Sustained.
What happened next?
Objection. Relevance calls for hearsay.
Overruled at this point, but the question should not have listed a hearsay answer.
We're not offering this for the truth of the matter.
I don't know what's coming out, so approach the side. You may continue.
Now, Mr. Anthony, you were saying that the next day you had advised your mother that you thought Casey was pregnant, correct?
I confronted her with that within a day or two. Yes.
Okay. And then when's the next time you saw Casey being obviously showing?
This would definitely have been in the middle of 2008. She came and picked me up at the airport.
Okay, Kaylee was born in 2006, right?
Oh, I'm sorry. Yeah, I'm sorry. I have the years wrong. No, she was born in 2005.
Oh, excuse me. So you're referring to 2005?
Yes, I apologize.
Okay. Did there come an occasion where you saw or you noticed this again to any greater? Did you see her showing more?
Absolutely. It was brutally honest at that point that she was pregnant.
Okay. And was it known in your family, or was it discussed in your family at all that she was pregnant?
Here's a specific, not specifying individual in your family.
Your mother,
Sustained.
Your mother and your father.
Compound question.
Sustained.
Was it discussed with your mother that at this point that Casey was pregnant?
Myself and my mother?
Yes.
Prior to asking her a few months before? No.
Okay. And then after you talked to your mother about it and you confronted her, was there about a month later that you saw Casey again? Did she pick you up at the airport or anything like that?
Assumes the fact, not an evidence that you confronted anybody.
Sustained. Rephrase your question.
Was there an occasion where your sister picked you up at the airport?
Yes, there was.
Okay. And how was she showing when she picked you up at the airport?
Far enough out to where I know she just wasn't putting on weight.
I'm sorry?
Far enough out to where I know she wasn't just putting on weight.
Okay. Are you saying that she obviously looked more pregnant?
Yes.
Okay. And was this how long after you had already confronted your mother?
An evidence.
Sustained.
Comment.
Let's continue. Next question.
Yes, sir. Can you give us a time frame from when she picked you up at the airport to when you had confronted your mother about Casey's pregnancy?
Same fact, not an evidence. I've objected twice.
Sustained.
Did you have any discussions with your mother or your father about Casey's pregnancy when she picked you up at the airport?
No, I did not.
During the time period between the time you confronted your mother and the time that you had picked her up at the airport?
Let him finish answering the question. Sit down. Mr. Anthony, do not answer a question until I tell you you can answer the question. Ask your question, Mr. Baez.
Yes, sir. Were there any discussions between the time that you confronted your mother and the time that that Casey picked you up at the airport that had anything to do with Casey being pregnant?
Any objections to that question?
As rephrased, no, sir.
You may answer.
From the time I confronted her with that until that time, we never spoke about it again. No.
Okay. And when you say again, what does that mean?
Until just a few days before Kaylee was born.
Okay. And are you saying that the very first time there was any discussion about Casey's pregnancy was, other than the time you confronted your mother, was just a few days before Kaylee was born?
That's the only time it was acknowledged to me that that was indeed the situation, yes.
And when Kaylee was born, did you go to the hospital to see your sister?
Regrettably, no, I did not.
And why didn't you go?
I was a little hurt. Just didn't want to be there.
Who were you angry with?
Relevance.
Sustained.
Why were you hurt?
Relevance.
Sustained.
Can you explain to us the reasoning behind why your actions?
Relevance.
Sustained.
Your Honor, may I approach so I can explain?
Yes, you may.
No, thank you.
You may proceed. Objection overruled.
Thank you. Mr. Anthony, can you tell us why you were angry and who you were angry with as to why you didn't go and see Kaylee and Casey at the hospital?
I'm sorry. I was very angry at my mom, and I was also angry at my sister. I mean, I was just angry at everyone in general that they didn't want to include me, and didn't find it important enough to tell me, especially after I'd already asked. So I was very hurt, and I don't think I wanted to believe it, you know. I'm sorry.
I'm sorry, what do you mean they didn't want to include you?
Interpretation of someone else's.
Sustained.
Were you angry because they hid the pregnancy from you?
Asked and answered and deleted.
Sustained as deleted.
Do you need a moment, sir?
I'm okay.
Why were you angry?
Asked and answered.
Sustained.
Are there other reasons why you were angry?
Objection. Asked and answered.
Overruled as to that question.
Were there other reasons why you were angry?
No answer, sir. Other than the answer that you've already given, were there other reasons? Yes or no?
No.
I can have just a moment.
You may.
I have no further questions. Thank you, Mr. Anthony.
Okay, time is about 5 minutes to the hour of noon. We're going to recess for lunch. I'm going to ask that you not discuss this case among yourselves, nor with anyone else. Any additional instructions on behalf of the state?
No, sir.
Or the defense? We'll be in recess to 1:30. Okay, let's return Mr. Anthony to the witness stand. Mr. Lee Anthony, and once we get him in, we'll return the jury. State recognized presence of jury.
Sir.
Defense. Members of the jury, did you heed my previous admonitions during your recess? All right. Mr. Ashton, you may begin your cross-examination, sir.
Thank you. Could we begin by publishing State's Exhibit 80 in evidence?
You may.
Mr. Anthony, you see the photograph State's Exhibit 80 in front of you?
Yes, sir, I do.
This is the photograph that you were discussing with Mr. Bias, is that correct?
Yes, it is.
You indicated that there were stains pre-existent in this trunk from approximately this area, and then one that's off the picture. Is that correct?
That is correct, yes.
This large stained area on the spare tire cover, about the size of a basketball, that was not in the car when you owned it, was it?
I don't recognize that one as something I'm familiar with now.
And when you owned the car, it didn't have stench, did it?
Is that one, I'm sorry?
Didn't have stench and stink?
No.
Overruled.
I'm going to unpublish now, Judge Money. Now, Mr. Anthony, in preparation for this trial, were you requested to meet with a member of the prosecution team to go over your...
Let's go.
It goes to Bias, Your Honor.
Overruled.
To meet with a member of the prosecution team to go over your testimony to prepare you for what questions we would ask you on direct?
I believe so, yes.
And you refused to do that, did you not?
Yes, I did.
But Mr. Baez requested a meeting with you this week to prepare for this testimony, did he not?
To my knowledge, when he asked me, it was not to prepare for this testimony, and I had previously refused to meet with him prior to this week also. I had reached out to him prior to this week, and then we followed that up with a meeting earlier this week, yes, sir.
So you reached out to Mr. Baez?
Last week I did, yes, sir.
For what purpose?
I'm going to object and ask that the instruction be read as requested by Mr. Ashton.
Your Honor, there's no implication of impropriety by counsel.
Overruled at this point. Let's continue.
The question was, why did you, after refusing to meet with anyone on the prosecution team, reach out to Mr. Baez?
While I was in court, the last time that I was in court, prior to me getting called onto the stand, during a break, I sat in with my folks, and there was a discussion, or I was present during a discussion, where information came out that I thought it was important for for Jose specifically to be made aware of. So I then took it upon myself a few days later, as I had no indication that he was going to be made aware of. I took it upon myself to do that.
And was this on the subjects that you have discussed under examination today?
No, sir. None of those items were discussed. No.
All right. Now, in reference to your discovery of your sister's pregnancy, did I understand you to say on direct that you did have a conversation with Casey when you discovered what you refer to as the bump?
If I said bump, I apologize.
No, I didn't mean offense by that. Speak evidence that you thought.
I more or less made a remark. I don't know if I was even expecting a response because I didn't really get one. I just said something of, kind of what the hell is that in passing.
Do you recall having your deposition taken on July the 30th of 2009, almost 2 years ago, in reference to this case?
Yes, I do.
And you were under oath at the time, were you not?
Yes, I was.
And you were questioned by Mr. George, is that correct?
Yes, I was.
And Mr. Bias was present along with other counsel, correct?
Yes, sir, he was.
This is for page 30. Let me start at 30. Page 31, line 6. Can we show that to the witness? Let me publish to the witness. All right, can you show about line 6 to line 15? Do you recall that series of questions and answers about the event of your seeing the bump or the bulge?
I recall this testimony, yes.
And in that testimony, you were asked whether you, I believe the word was, called her out on it, that being the bump.
Right.
Impeachment. The witness has already testified that has refreshed his recollection.
This is impeachment, Judge. This is not.
Overruled.
And in that event, you said, when asked if you called her out on it, you said, it wasn't really my place. I think if I did, not directly to her. You recall saying that?
It's here, so yes.
So in July of 2009, you indicated that you did not say anything directly to her about it, but your testimony here today was that you did.
Well, sir, I also did not call her out on it when she showed up at the airport to pick me up, and it was quite obvious at that point as well. I don't know exactly which scenario this one's referring to. Maybe if you refer to a
Can we show the witness
date or time or something.
Can we show the witness page 30, and we'll let you read the whole context?
Thank you, I appreciate it.
No problem.
I would ask that counsel read his entire answer, not just half of it.
Read the entire answer.
Your Honor, if I may, the remainder of the answer does not deal with this subject matter. Deal with a separate subject matter.
Yes, sir.
Just a second. You can do it on redirect.
You read the context?
I didn't really have a starting point. I just kind of started in the middle. So would you like me to read that entire page?
Just to yourself, just to establish the context of whether this was the first occasion you saw the bulge or the
Yes, sir.
airport occasion. This was a reference to the first occasion, wasn't it?
I read that entire page.
What you were referring to the first time that you noticed, correct?
I do not recall. There's nothing in here that makes me think that that was unique to the first time or the incident at the airport. There's nothing specific asking me that.
Now, when your parents learned of the pregnancy, they were very excited, weren't they?
Couldn't tell you. They didn't admit it to me.
Well, is it your testimony that from the time that you learned it till the date of Kaylee's birth, there was no activity in the home indicative of preparations for the birth of a child?
I'm not saying that at all. Actually, that was one of the reasons why I was so angry. And I decided not to go see my sister in the hospital, was because I was not included on it. And when I did ask about it one time early on, it was denied to me and I was told to let it go. So that's what I did.
Your parents were over the top about this, weren't they?
Especially afterwards. Absolutely. Yes, sir.
No, even before. They were over the top. You described them as over the top. Isn't that right?
My parents are very over the top. Prior to my sisters actually having Kaylee, to be honest with you, I didn't really pay a lot of attention. It was something that I was told to let go and not address, and I was frankly quite angry that I wasn't included in it. So a little easier to block it out at that time.
So you said, Mr. Anthony. Can we have page 35 of the deposition, please? Could you just read that whole page, Mr. Anthony, for me?
Yes, sir.
To yourself.
Sorry, I'm just reading my last
Sure.
paragraph because I kind of ramble in there, so it's hard to get my point. Okay.
In that paragraph, you discuss the period of her pregnancy before Kaylee was born, correct?
Is that 14 through 23?
Yeah, the whole page.
The whole page? Yes, yes, sir, yes.
And in that, you indicate that that you felt your role was just to be there in the background to support, not really be over the top, because of course my parents wanted to be the ones to go over the top. They're grandparents, but just be there. That correctly reflects your parents' response to the imminent birth of their granddaughter, does it not?
In regards to them wanting to be over the top?
Yes, that is a description of their emotion, how they felt about it, their excitement. That's what you meant to convey by that, didn't you? Asking what he meant to convey by the answer.
You can answer that question, yes or no.
I believe that was the impression that I was under. I mean, I wasn't asked to be involved with things, so all I could deduce from that is my role was to sit back, be non-judgmental, as I referenced in there, be in the background, and they would take care of it. They would do whatever's necessary, and their nature would be to be over the top.
What preparations of the house did they make for the imminent birth of Kaylee?
I believe they got her a crib.
Didn't they redecorate?
What else? I don't remember.
Didn't they redecorate an entire room that had formerly been a family computer room that they completely redecorated for Kaylee?
To my knowledge, yes. I wasn't personally involved in it, but to my knowledge, yes.
But you saw it, correct?
After the fact, yes, sir.
And it's, your parents, particularly your mother, never did anything halfway. It was decorated to the nines, wasn't it?
From everything that I got to see, eventually, absolutely, yes, sir, it was.
And that was in preparation for Kaylee's arrival.
I imagine during preparation it was like that. If she'd do everything she could, yes, sir.
Well, you were there during the period of time leading up to Kaylee's birth, weren't you?
I lived there. I lived in the room right next door, actually.
And you know that your mother went nuts decorating this room for the birth of her first grandchild. Winnie the Pooh everywhere.
I know there was Winnie the Pooh everywhere. Again, I never walked in the room. I never went into the room until a little bit after the fact, after she was born. But I could imagine that she did that ahead of time, absolutely.
And your mother and your sister went shopping and bought all kinds of stuff in anticipation of Kaylee's birth.
I'm sure they did.
And they had a party, didn't they?
If they did, I wasn't invited.
Should they have a baby shower?
If they did, I wasn't invited.
Were you aware of them having a baby shower?
Yes, I believe so. It was in maybe June or so.
And they invited their friends? They invited Casey's friends? Did they invite Mallory?
I believe so.
You believe so?
I said I don't believe so.
But you know that they had a party.
I wasn't invited, so whatever did transpire, I have no knowledge of it.
Well, where were you when the party occurred? Let me rephrase. It happened at the house, correct?
I would imagine.
Well, you saw the aftermath. You saw the presents and all the stuff that people got for Kaylee. It was at the house, right?
I didn't put any thought into it. I didn't ask to see presents, and I didn't go out of my way to do so. It was something, sir, that I was not involved in. It was something, sir, that was, I felt for a while, that was either hidden from me or something that I was not being made a part of. So I'm not going to go out of my way to invite myself or to know everything that's going on if I'm led to believe that I shouldn't be involved with it. So if that hopefully answers your question on why I wasn't an attentive potential uncle, I wish I was, but I was not.
But your parents weren't hiding this fact from their friends and loved ones. They invited them to a party.
This witness's knowledge of what his parents would do with their friends.
Sustained.
During this deposition, Mr. Anthony, we discussed the period of time leading up to the birth of your niece, and we discussed, in fact, whether you were present when she was born. Is that correct? Recall that?
I don't recall if we did, as far as me being present or not.
Okay. Page 36, just for the witness, line, let me just make sure this is only published for the witness. Yes. Line 22 and to the end of the page, just like that for the witness. You recall that question and answer?
I see the portion of my answer, yes, sir, and I recall the question.
Did you cry during that portion of this deposition, Mr. Anthony? Do you
don't recall if I did. I don't think so.
What was different 2 hours ago in this courtroom about that question that caused such raw emotion today, which was not present 2 years ago when you were asked the same thing?
There was other things that were asked in my deposition, specifically if I believed Kaylee was...
Objection, Your Honor, non-responsive, move to strike. The question, Mr. Anthony, is this.
Yes, sir.
What was different about the question being asked of you?
I think we need to hear what the answer is.
I sustain objection to the question.
Question before you, Mr. Anthony, is this. What was different about the way, the emotion with which you answered that question 2 hours ago? It was different than the emotion that you did not display when asked the same question 2 years ago.
2 years ago, I did not 100% hold the belief that Kaylee was dead at this very moment, and 2 hours ago. And during that 2 year span, I've come to the place where I believe that she is. And my emotions are elicited from those facts that I have regrets, and I wish I could have been there a lot more than I was.
Mr. Anthony, you attended and spoke at a memorial service for Kaylee in January of 2009, 6 months before this deposition was taken, didn't you?
Yes, sir, I did.
No further questions.
Redirect us to those issues.
Mr. Anthony, you were asked about a stain somewhere in this vicinity, the size of a basketball. May I publish this, Your Honor, to both the jury and
Yes, what's the exhibit number?
80.
State's Exhibit 80, you may publish.
Yes, I was asked about that.
Do you see a basketball-sized stain there, or?
Photograph speaks for itself.
Do you see any basketball-sized stain there at all?
I see a few stains. Nothing necessarily that's the size of a basketball, no.
Do you see white powder of some sort?
Not, the photograph speaks for itself. The witness has no basis to answer that question.
I do, and that's not what I would even reference necessarily as a stain that I was referring to. A white powder is a lot different than a stain.
Point to me where you see a stain in that area where Mr. Ashton was questioning you. If you see one.
In this section, I do not. It's very hard to see from this photo, but there is a stain here, and there's a stain here. There's also things that are circling right here at B. There looks like a different color, maybe powder or some kind of substance. I don't know exactly what that is, but the stains I was referred to were darker in nature, almost like I apologize, I'm colorblind, so my interpretation of them might be a little different, but more like a red or like a black, sort of just a darker, deeper color.
Did you see your mother use a entire bottle of Febreze in the trunk of this car?
Seek the scope across.
Never.
Did you see law enforcement spray the entire trunk with a Blue Star?
I don't even know what that is, and no.
Okay. Now, Mr. Ashton asked you about whether you had met with myself in reference to your testimony. Did you meet with the defense any time prior to trial? Let me rephrase that. Let me narrow that down a bit.
Okay.
Did you meet with the defense prior to you testifying for the state of Florida against your sister?
No, sir, I did not.
Did you advise us of any testimony you intended to give for the state of Florida against your sister?
No, sir.
Did you testify truthfully when you testified for the state of Florida? Can I bring up page 34? The question and answer asked by during this deposition. I'd like to question the witness about it, Your Honor.
You can question him, but show it to the witness and the witness allow. Go ahead.
Yes, sir. Page 31.
What page?
I'm double checking where. Can you go to 30? Sorry.
Page what?
30. I'm just double checking. I want to follow up on a question. 31, I'm sorry. 31. You were asked, can you review lines 12 through 14?
I've read 12 through 14.
Okay. And you were asked during cross-examination, and the first sentence was read into evidence. Can you read the second sentence?
The second sentence says, I think if I did, not to her directly.
Or?
Third sentence is, or I would have had, or excuse me, or I would have said something to my mom or to a friend of mine, you know.
And that's what you were referring to when you testified about telling your mother?
I'm sorry, could you repeat the question?
That's what you were referring to when you testified, that when you first told your mother?
First asked her about it, yes, sir.
Okay. So what you said in the deposition is what you testified to?
Misstating what's in the record, not what he said.
It's not. The witness can answer if it's true or not.
Witness can't change the answer.
Folks, if you want to read the answer to the deposition, you can read it. It would speak for itself. So if you want to read the entire answer, read the answer.
We just did that, Judge.
Okay,
that's fine.
it speaks for itself.
Yes, sir. And, sir, when you testified under cross-examination, you said that you were told to let it go. Who told you to let it go?
My mom told me to let it go.
And that's referring to your inquiries about Casey's pregnancy.
My inquiry, yes.
And can I have page 33? Lines 13 through 18. Page 33, lines 13 through 18, if you can bring them up a bit. I'd like for you to look this over, if you can, Mr. Anthony.
I read it.
Now, during cross-examination, Mr. Ashton suggested to you that your parents were over the top and ecstatic. But that's not necessarily what.
Overruled. He hasn't finished the question. Let him finish asking the question.
Is
Mr.
that
Anthony, before you answer the question, wait for me to tell you whether or not you can answer the question. You may ask your question, Mr. Baez.
Mr. Ashton mentioned that your parents were over the top of happiness prior to Kaylee being born. Is that what you testified to in your deposition?
You may ask a question, Mr. Anthony.
I believe it's to the extent of that in my deposition, yes.
Are there any other opinions you gave about your mother not being happy or not thrilled?
Yes. I gave an opinion that was my impression, or thoughts that she was not thrilled that Casey would have a baby out of wedlock.
And the baby shower that was had for Kaylee, that actually occurred after Kaylee was born, did it not?
Sustain, rephrase the question.
Did Kaylee's baby shower occur after she was born, since everyone didn't know she was pregnant?
The fact, not an evidence. Move to strike.
I'll rephrase the question.
Sustain, rephrase the question.
Did Kaylee's baby shower occur after Kaylee was born?
I don't recall. For sure, I don't recall. I'm sorry.
Okay. You were asked why you didn't cry during the deposition.
Yes, sir.
Is sitting here today much different than sitting in the state attorney's office 2 years ago?
Overruled.
Absolutely. And can you share with the ladies and gentlemen of the jury why?
I don't want to be here. I don't want, my sister to be here, my parents to be here, and I'm also emotionally and all that stuff in a much different place, than I was a couple of years ago, and this is obviously just very, very emotionally draining and very difficult.
Mr. Ashton asked you about giving a speech at Kaylee's memorial prior to your deposition, and you testified about at your deposition not believing Kaylee was dead. Is that correct?
I was not willing to write it off at that point in time. I didn't want to believe it. I couldn't believe it at that time.
So you were able, after having a funeral for your niece, to block her death out of your emotions for approximately 6 months?
Objection, leading.
Sustained.
Were you able to block that emotion out of your compartmentalizing?
Same question.
Sustained.
What were you able to do in regards to the death of your niece emotionally for 6 months?
I don't know the exact time frame. I don't even know when I really came to the belief that I have now that she is no longer with us. I mean, I can still tell you, even with that belief, if there's someone that looked familiar to her today, it would turn my head in. It would make me look twice or 3 times or 100 times. I don't know when that really changed for me. I know last year was particularly hard for me around Kaylee's birthday and my birthday. But during the time of the deposition specifically, and they had even asked me at one point if I believed that she was dead, and I remember it being a big joke to some people that I didn't want to believe it or couldn't believe it. At the time, I didn't believe it, I couldn't believe it, and right now I do. So I have a very, very tough time with that.
Who is it a joke to?
Objection. Relevance.
Sustained.
I have no further questions.
Recross.
Mr. Anthony, you remember when you testified for the state of Florida? State of Florida, remember?
July 2009, I think you referenced it earlier.
No,
Yes,
no,
sir.
when you testified for the state of Florida, as Mr. Bias pointed to.
Yes, sir. I apologize.
How many times did Mr. George have to step up to you and show you your deposition to refresh your recollection about?
Objection, Judge. The record speaks for itself.
Goes to Bias, Your Honor.
And relevance.
Overruled.
Probably as many times as I've been showed something here today by yourself or Mr. Baez. A handful of times, 2, 3 times. I don't recall. I wasn't counting.
In your direct examination by Mr. Bias, did he need to refresh your recollection at all? I don't.
He did reference me to a few pages that he asked me to read. I don't believe he qualified anything to say that he needed to refresh my recollection. No, sir.
During his initial direct examination, your testimony is you recalled him having to refresh your recollection.
I don't believe so.
Your recollection was just fine for the questions that Mr. Bias asked you in his initial direct, weren't they?
On all these, I believe they were, yeah.
But when Mr. George attempted to question you on direct examination, your memory was more troublesome.
It's hard to remember something you did 2 years ago. Absolutely.
Could I have, just for myself in the witness, page 31, the deposition? Page 17, line 17 through 24. I'm sorry, line 15 through 24, please. You were asked the question at the deposition, did you say anything to your mom? Say, hey, Casey's looking. And your answer was probably, at a minimum, probably of passing. I don't think I ever made a big enough deal because, if my mom didn't make it a big deal or if she shrugged me off or whatever reason. It is impeachment, Your Honor.
Overruled.
She shrugged me off for whatever reason, then either I was wrong or my sister was just getting fat, or for whatever reason, they don't really want me involved in it, whatever, either way. So at deposition, your recollection was at best that you probably spoke to your mother.
That's what this says here is probably. I do remember speaking to my mother, but that says probably.
So your recollection is better today than in July 2009 at the deposition.
If you assume that because I didn't say the word probably today? Sure.
Well, you will admit that your recitation seems to be somewhat not a big deal. Don't really remember it very well, correct?
Sustained. That's the last question.
You said probably at minimum of passing. I don't think I ever made a big deal.
Excuse me, Mr. Ashton. My objection is this has been asked and answered. He's read this already.
Sustained.
If we go to page 33, please. Lines 1 through 8. Read that, please.
To myself?
Yes, to yourself. Thank you. And if you need to see the page before, I'll be happy to show it to you. But
Redirect.
yes, Judge, it's in reference to when the baby shower and the preparations were.
Overruled.
In that, you indicate, does that refresh your recollection about that the baby shower was in the months preceding Kaylee's birth?
Yes.
No further questions.
Mr. Baez, any additional questions? Remember when you... Okay, Mr. Anthony, you may stand down, sir.
Yes, sir.
Hello. And guess who's coming back to the stand now? Cindy.
yourself out there on the ledge. Well, why don't we do this? While you're waiting on your witness, this would be a good time to take a 15-minute recess to a quarter till. Okay, let the record reflect that the defendant is present along with counsel for the defendant, assistant state attorneys. Both sides ready to proceed?
Yes, sir.
All right, let's return to jury. You got your next witness on tap?
Yes, sir. So from what we had discussed earlier, I think that's going to be an issue. Just letting you know.
Tell your colleagues. Okay. State recognized presence of jury. Defense?
Yes, sir.
And members of the jury, did you heed all of my previous admonitions during the recess? Case, defense may call the next witness.
Defense calls Cindy Anthony.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Cynthia Anthony, Cynthia, Anthony, Anthony.
You may proceed.
Mrs. Anthony, when was Kaylee's baby shower?
It was postponed because of her birth. I believe it was around the 27th of August.
Was it before or after Kaylee was born?
Kaylee was supposed to be born in September. We had the shower slated for August the 13th, and Kaylee was born on the 9th, so I had to switch the invitations. I had to contact everybody and change the date of the baby shower.
So just so we're clear though, but was it the baby shower held before Kaylee was born or after Kaylee was born?
I just stated it was after Kaylee was born because Kaylee came a month early.
I understand. I just wanted to be clear about that. Your Honor, may I approach the witness?
You may.
What is that a photograph of? Defense, sorry, excuse me. I'm showing you defense exhibit ER.
Pardon?
Mr. Bias has shown these photographs to me, and I have an objection to the series of them on grounds of relevance.
Okay, we'll wait till you get rid off.
Sir.
Well, I object to a description of the photograph prior to its admission.
Okay. All you need to do is establish that you recognize it and whether or not it adequately and accurately describes the subject matter that they're in. And you can offer them, and we'll see if they object.
Do you recognize the photograph, Mrs. Anthony?
Yes.
Is it a true and accurate depiction of what it actually is?
Yes.
At this time, Your Honor, I would move exhibit, I believe it was ER, into evidence.
It's not. Oh, I'm sorry, sir.
I would have an objection at this point, as indicated on relevance grounds.
You want to approach the sidebar, Mr. Bias?
Yes, sir. May I approach the witness, Your Honor?
Okay, the objection as to the last exhibit will be sustained. You may continue with your direct examination.
Yes, sir. May I approach the witness?
Yes, sir.
You recognize that photograph?
Yes.
And is it a photograph that was taken at your brother's wedding?
Yes.
And is it a photograph of you and your daughter?
Yes.
Okay. And at the time that photograph was taken, did you believe that your daughter was pregnant?
No, I did not.
Did anyone advise you that your daughter was pregnant?
Exception to the hearsay rule, Mr. Bias?
Then I withdraw the question.
Okay.
Judge, at this time, that's exhibit A.
State,
The objection is previously lodged on relevance.
objection to be overruled. That would be admitted.
Mrs. Anthony, who attended the baby shower?
Casey's grandmothers, her aunts, some of my friends, Jesse Bren's mother, neighbors.
Was Lee present?
No, none of the guys were present.
I have no further questions.
You may. Cross-examination. The witness may stand down.
Thank you.
The defense may call the next witness.
Ryan Eberlin.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? I do.
Ryan Eberlin, last name Eberlin.
I always say it wrong. I said Eberlin. I'm sorry.
All right.
You are a member of the Orange County Sheriff's Department?
Yes, sir.
Were you so employed in July of 2008?
Yes, sir.
On or about July 15th, sir, were you dispatched to a residence on Hope Springs Drive?
Yes, sir.
You know who lived there?
The Anthony family.
Had you ever had any contact with the Anthony family prior to that time?
No, sir.
Sir, when you arrived, did you participate in overall just kind of controlling the scene and what's going on and asking questions?
Yes, sir.
And at that point in time, sir, did you observe a white Pontiac Firebird automobile?
I did, sir.
Did you notice any particular odor about that car when you were looking at it?
No, sir.
In addition, sir, after you had some interview there, did you have occasion to put handcuffs on Casey Anthony?
Yes, I did, sir.
And were you subsequently instructed by Sergeant Hosey to remove the handcuffs?
Yes, sir.
Thank you. No further questions.
Cross-examination?
Thank you. Deputy, you were the junior deputy on the scene, so to speak,
Yes, ma'am.
and Sergeant Hosey was there as well.
Yes, ma'am.
The handcuffing of Ms. Anthony was for 2 or 3 minutes.
Yes, ma'am, approximately.
Okay. And after that, she was immediately released and went back into her house and was free to go about her business, correct?
Yes, ma'am.
Why was Ms. Anthony handcuffed?
While Casey was inside the house, her mother, Cindy, had approached me while I was outside and informed me that Casey had stolen her.
Open the door, Your Honor.
Still here, sir.
Exception to the hearsay rule?
Your Honor, the complainant formed the basis for probable cause for this individual.
That should be sidebar.
Okay. Okay. Okay, members of the jury, there's going to be a brief legal matter we need to take up outside of your presence. We will get back with you as quickly as possible.
Approached me while Casey was inside her residence while I was on scene and came out with receipts stating that Casey had stolen her credit card and made fraudulent purchase with that credit card. And she wanted to press charges for or against Casey. I then went inside the house, detained Casey, brought her into my car, and was going to continue the investigation of the fraudulent use for credit cards. At that time, when I placed her in the car, that's when Sergeant Hosey had told me, we're not concerned about the fraudulent use of the credit card at this time, only the kidnapping that we were investigating, and informed me to take her out of cuffs, which I did, and she went inside.
All right. Now, as it relates to the timeline of events, this happened after Ms. Anthony did her written statement for you at 1 in the morning, correct?
To the best of my recollection, yes.
Okay. But before at the time, Corporal Melich arrived at 4 a.m.
Yes.
That's all we have for the proffer.
Okay, argument. Mr. Mason and then the state.
Sure, for free and or instruction to the jury that she's not a property.
I'm sorry, Mr. Mason, can you repeat that last part?
What did you not hear? All of it?
Repeat it again, Mr. Mason.
I'm happy to read you.
Not on trial for any other.
Not on trial for any of those allegations, but with his credit card or car or otherwise.
Okay. The defense raised the issue of the handcuffs being placed on Ms. Anthony and then elicited questions that the officer removed the handcuffs without any particular explanation as to the reasons why, which opens the door for this particular testimony. The court will fashion a jury instruction to deal with this. Just a second. Okay, this is the instruction that I propose to give. The evidence you're about to hear concerning the reason for the handcuffing of Miss Casey Anthony is solely to explain why the deputy did what he did, and is not to be considered for any other purpose. The defendant is not on trial for those acts, and you should not consider it for any purposes except to explain why the deputy did what he did. Any additions, deletions from that particular instruction? State.
No, Your Honor.
Okay, this is the final version. The evidence which you are about to hear concerning the reasons missed for deputies. State recognized presence of jury.
Yes, Your Honor.
The defense. Ladies and gentlemen, the evidence which you are about to hear concerning the reasons Ms. Casey Anthony, the defendant, was handcuffed is solely to explain the reasons why the deputy took those actions and is not for any other purpose. The defendant is not on trial for those acts, and you should not consider it for any other purpose except to explain why the deputy handcuffed the defendant. You may proceed.
Thank you. Deputy, you had indicated Ms. Anthony was handcuffed for a very brief period of time, correct?
Yes, ma'am.
Okay. Was that done after she had provided the written statement that you countersigned for her?
Yes.
After that occurred, Mrs. Anthony, Cindy Anthony, came to you when you were outside and indicated that she wanted to press charges against her daughter Casey for the fraudulent use of her credit card, correct?
Overruled.
Yes.
And in order to further that investigation, you went into the house, handcuffed Ms. Anthony briefly, at which point in time your supervisor, Sergeant Hosey, told you that he wanted the handcuffs off.
Yes, ma'am.
At that point, Ms. Anthony was free to go back into the house while the investigation continued into the alleged kidnapping of her daughter Kaylee, correct?
Yes, ma'am.
Corporal Melich showed up at least an hour or more after that, correct?
I don't recall the gap in time, but
Was it after?
yes, the detective showed up after that.
All right, and he was not present for this exchange between you and Cindy Anthony, correct?
No, ma'am.
Or you and Casey Anthony, for that matter.
Correct. No.
And then once Corporal Melich arrived, you were not involved in any way, shape, or form in the taking of additional statements from Ms. Anthony, either at her residence at 4 o'clock or so that morning, correct?
Yes, ma'am.
And you were not involved in taking any statements from her on July 16th at Universal Studios, correct?
Correct.
Thank you. That's all I have, Your Honor.
Redirect. May the deputy be excused. Thank you, deputy. You may be excused, sir. The defense may call in next witness. Okay, ladies and gentlemen of the jury, there is another legal matter that we're going to need to take up outside of your presence. I will get back with you as soon as possible. Please do not discuss this case among yourselves nor with anyone else. Okay, let the record reflect that the jury is outside of the courtroom. Mr. Mason, you may proceed with the proffer.
Thank you, Mr. Edwards. I ask you, sir, if you knew Linda Tonelli,
I met her through the investigation, yes, sir.
and who did you learn, what did you learn was her involvement initially in this case before you did further things with her?
I'm sorry, I can't hear you
What
very
did you
well.
learn about her first, as far as this case is concerned?
She was brought to my attention by an individual by the name of Lori Cree that was a volunteer for Texas EquiSearch. And I don't remember the date off the top of my head, but at any rate, I want to say it was about the time, somewhere in the December timeframe when we visited Texas EquiSearch. And while we were out there, I received a phone call, I want to say, from Lori Cree. And that's when she brought Linda Tonelli to my attention, I believe the first time. I could be wrong on that date. But at any rate, from that conversation with Lori Cree, Linda Tonelli was a volunteer at the Kid Finders tent and spent a great deal of time there assisting with the Kid Finders and the Anthonys, or George Anthony, anyway. That answer your question?
Yeah. Did she coordinate one of the tables in the overall, the volunteers searching for Kaylee?
I know that based on the communication we had with her, because John Allen and I interviewed her shortly after returning from Texas, I think she was in charge of maintaining the volunteer sheet or something of that nature.
Did you have occasion to discuss with her, sir, any issues regarding duct tape?
I did. I showed her a photograph of a image that had been provided by one of the local media outlets. I'm not sure which. And because that, I believe, now that you say that, I believe that's what Lori Cree had said, that Linda may have even brought to her attention that she recalled that Mr. Anthony brought some duct tape to the Kid Finders tent at one point. And I'm not sure that was one of the reasons that we interviewed Ms. Tonelli.
Did you show the picture of the duct tape, in fact, to Ms. Tonelli?
I'm sorry?
Did you show the picture, the photo of the duct tape?
I showed I can't recall if it was a video and we captured one image of that, or if it was a download of one photograph. I can't recall off the top of my head. But I know we did show her it was kind of a fuzzy image of one of Kaylee's missing pictures with the duct tape on it at a tent, is my recollection.
Yeah. And did she identify seeing the duct tape with George? Mr. Anthony, excuse me?
She, and I'm going off memory here, she didn't specifically say that's the tape that I can recall. She just described a very strong tape for whatever reason. And
Mr. Mason, without looking at that transcript again, I can't recall everything off the top of my head, but I would have brought to someone's attention, or I think it would have been more of a deal if she said, that's definitely the tape, because it's very, you can identify it due to the writing or the markings on it. So that doesn't stand out in my mind.
After the remains were found, did you, in your official capacity, contact Ms. Linda Tonelli?
Do you have something that could refresh my memory? Because I know there was another time when John Allen and I had driven out and met her and contacted her again because of some correspondence or communication she had with the Anthonys.
Do you remember, sir, going to her home in around March of 2009?
Yes, sir.
And did you at that place and time discuss with her placing eavesdropping equipment in her house, like a bug on a lamp in the living room?
Quite possibly, yes, sir.
And did you do that, sir, for the purpose of getting her to invite George and or Cindy over to speak with her and try to capture their conversation?
My recollection of that is they were asking to meet with her and to talk to her. And I believe what she had told us at that point was she had visited the Anthony home and told them that we had met with her. And after that point, she had been receiving communication somehow from the Anthonys. And our concern at that time was what they would maybe ask her to say. Yes, sir.
You wanted to capture their conversations with Ms. Tonelli?
If it was made available, yes, sir.
All right. And in fact, sir, did she ultimately decline? That is, Ms. Tonelli declined to do that?
I don't recall that off the top of my head. I recall her being somewhat uncomfortable because she would have had to get her husband's permission, and she didn't want to. Maybe that came across a little too intrusive to her personal life, is what I remember. She didn't say no. My impression was she was willing to entertain other ideas. However, that one she wasn't a real big fan of that.
So you never did it?
That's right.
Thereafter, did you contact her again?
That would be the third time in the
at Lowe's.
Correct.
And you and Detective John Allen and Detective Yuri Melich appeared there. Do you remember?
No, sir. That was just Sergeant Allen and myself. Is what
That's
I remember.
The two of you?
Yes, sir. And
did you at that time ask her if she would in fact wear a concealed wire microphone on her person?
We may have entertained that conversation.
And was the purpose of that so that she could further try to capture candid conversations with Mr. George Anthony and or Cindy Anthony?
Possibly, yes, sir.
And did she do that?
She did not. The window of opportunity never made itself available.
That would be the proper with respect to that aspect of his dealing with Mr. Nelly.
And Mr. Mason, you have any questions, Ms. on the proffer?
I do not.
Yes.
Aware, sir, of any voicemail messages left on Mr. Tonelli's phone by Mr. Anthony?
By Miss Anthony. I believe it was Miss Anthony. Called Miss Tonelli. She allowed us to retrieve that from her phone. I believe it was Miss Anthony. Do you have a transcript I can review?
No.
Off the top of my head, I want to say it was Cindy Anthony that called and left Linda a phone message.
Do you recall the substance of that phone message that was left?
I believe I would be more comfortable answering that question with a review of a transcript. I know that.
Did you call the transcript to be prepared of that phone message?
I believe Sergeant Allen recorded that contact on that date, so he would have to answer that question. I myself am unfamiliar with it.
Okay.
All right, Mr. Mason. What material fact does this evidence tend to prove or disprove, or what relevancy this has to the theory of defense?
How much time do I have?
As much time as you can take.
Judge, as I said before, it does reveal only that the focus of the investigation was otherwise directed, not just at the defendant on trial, but at others, because of the processes of the law enforcement investigators. As to being able to establish a material fact in the absence of the recording, it doesn't.
Part two to the question. What relevancy does this have to the theory of defense?
The theory of defense, as presented to you earlier, deals at multiple levels, but as far as this would be concerned, the dysfunctionality and the circumstances involving what happened after the accidental drowning and who did what in an effort to conceal or cover that up. And the investigation carried on in that regard, and it goes to the theory of defense to suggest that the detectives involved in the case were so interested in following that road that they asked the woman to wear on two occasions a wire or concealed interception of communications to try to find out and get incriminating statements from the parents.
And since the next witness is out there, were they successful in getting incriminating statements?
You said, did they?
Were they able to get?
No, sir.
Okay.
No, sir, they were not, because she actually, after being requested twice, she declined to do it. What she otherwise would only be able to testify to, which is what we already have in evidence about the duct tape.
Okay. Thank you. State.
Your Honor, as I argued at sidebar, it is obvious from the proffer, as well as what was argued at sidebar in open court, that this line of questioning is designed only to invite the jury to speculate on the motives of law enforcement without actually ever asking what their motivation was to do something, because their motivation would be irrelevant because it is for
The court regulation, yet we're asked to
Ms. Strain, understand what goes to an argument and what does not go to an argument. So there's no jury. So the objections about arguments, folks, is just a needless waste of time. So let him finish his argument. State, anything else it would like to say in concluding remarks? Okay. The Florida Supreme Court in the case of Wright versus State, 1970, goes on and is relevant by proving theory of that and relevant a theory. So the deputies, do you still intend to call the next witness? Okay, is it for a different purpose, or is it for the purpose of the proffer?
although you did reference part of it, I'll take out.
Yeah, the duct tape. Okay. I just want to make sure that we don't have to send these folks out again on the Pop-Tart route. All I'm asking is if there are some matters we're going to need to take up and have a sidebar, I would much rather do it now than to have the jury come back in and we have to go through this exercise again. I have no idea who this would be. Mr. Ashton's machine. Is the defense's real time working?
Command Center, what was value, say this time, any relevance, a specific brand, but that was what was used.
Can't say victim.
Frame, time.
Going to testify, was it the volunteer tent? It's admissibility. Be very interesting because I'll wait for another time.
Yeah.
That is admissible. Ready?
Ready?
All right, let's return to jury.
All right, jury's coming back.
Say, recognize present jury. The defense?
Yes, sir.
Defense may call the next witness.
Linda Tonelli.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the whole truth?
Linda Tonelli, LINDA-TINELLI.
Good afternoon, Ms. Tonelli.
Hi.
Do you know George and or Cindy Anthony?
Yes, I do.
You tell us when and how you first met them?
When I heard Kaylee went missing, they had a command center. I went down to the command center on Publix at Lake Underhill in Chickasaw and offered my help as a volunteer.
You were a volunteer helping to coordinate the search issues, is that it?
No, I coordinated the table where they gave donations and handed out T-shirts and pins and bracelets.
And did you volunteer at that command center on occasions with Mr. George Anthony?
Yes, I did.
And at that time, those times and places, that was been during the late summer, early fall of 2008, would that be correct?
From towards the end of July till December. The last day was December 8th.
During that period of time, ma'am, did you observe Mr. George Anthony having duct tape?
Yes,
Duct tape.
I'm sorry.
Yes?
There was duct tape at the table, yes.
And do you know how it was used at that time and place?
Yes, we had like plastic tablecloths and we would like take the tape and hold the tablecloths on because it was windy sometimes and they would blow, and we also put posters up with them of the missing children.
When you say we, does that include yourself?
Correct.
And Mr. Anthony?
Yes.
Thank you very much. That's the only questions I have. You were talking about the wind blowing the tablecloths and so forth?
Correct. They were plastic tablecloths.
What, if anything, did Mr. Anthony do about that in your presence?
Well, we would like take the tablecloths because they would go like around the tables, and we would just tape them underneath to hold them so they wouldn't blow off.
Thank you very much. That's all.
Cross-examination. May the witness be excused.
Yes.
Thank you, ma'am. You may be excused. The defense may call the next witness.
Defense calls Detective Yuri Melich.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
My name is Yuri Melich, Y-U-R-I-M-E-L-I-C-H.
You may proceed.
Thank you, Your Honor. Please court. Good afternoon, Detective Melich.
Good afternoon, sir.
Detective, as previously testified, you are the lead investigator in this case.
Yes.
And pretty much that means you're in charge of the case.
I have a supervisor I answer to.
Right. But you are the, I guess, the coordinator of everything.
For most of it, yes, but I also have a supervisor who has input on certain decisions that are made, and he has a supervisor that he answers to as well.
And were you first called out on July 15, 2008?
I believe it was after midnight. Would that be July 16th?
16th, I apologize.
Yes.
And when you were called out, you were made aware of the smell of the Pontiac Sunfire pretty early on when you first arrived.
I don't know if I would say early on. As I testified to before, at some point somebody at the house had mentioned the smell in the car.
And that somebody was George Anthony, wasn't it?
Yes, correct.
And the next day, well, let me stop you there. You didn't do anything with that information.
No, not until later that day.
Okay. And when you say later that day, you mean you were there at nighttime or early morning hours late?
I don't believe I returned that night. We had car brought to our central operations center later that night, later on the 16th.
Right. What I'm saying is you arrived in the early morning hours on the 16th.
That's correct.
Then later on, after you had spent several hours there, you left.
I don't know if it was several hours, but after a short period of time, enough to do the interview, yes, I left, came back, and then left again.
How much time did you spend at the Anthony home in the early morning hours of the 16th?
My initial arrival, to include the time it took to take the original tape statement, maybe a little over an hour.
And then after that?
Just long enough to drop Ms. Anthony home after she showed me the locations.
And then as soon as you dropped Casey Anthony off, you had more interaction with Mr. Anthony, correct?
Yes, at the driveway as I was about to leave.
Okay. He wanted to speak with you privately.
I don't know what he wanted, but ultimately he talked to me at the car as I was at the end of the driveway. I was still in the car. He approached the car.
And the purpose of his conversation with you is to focus a little more on Casey, correct?
Objection. He's asking you to speculate on someone else's state of mind.
Sustain.
What was the purpose of that meeting?
Objection. He's asking witness to speculate.
He can answer from his perspective.
I don't know what his purpose was. My purpose was simply to drop her off and then go do my investigation.
Did you obtain any more information from that private meeting that you had with Mr. Anthony?
Just what I noted in my report, what he'd said.
Okay. And then the next day, I want to say you left in the early morning hours around 7 a.m.?
Approximately, yes.
And then you met with Miss Anthony around noon that same day?
Yes, at Universal Studios.
And how many police officers were there while you were at the Anthony home?
I can recall 2 uniformed officers and myself. Not to say that there wasn't another uniformed officer present, but I wasn't really paying attention to the uniformed officers. I was paying attention more to the Anthonys and Miss Anthony.
Did you see Sergeant Hosey there?
Yes.
Did you see Adriana Acevedo there?
I don't recall who else I saw aside from Sergeant Hosey. And I recall him because I believe I had a conversation with him when I arrived on scene. I believe that was him.
Have you at any time come to realize there were approximately 7 or 8 officers there that evening?
I wouldn't believe that there were 7 or 8 officers. No, but again, I wasn't paying attention to the officers there. I believe if there had been 7 or 8 police cars, it would stand out, but that does not stand out.
Did any officer that was there that evening, whether you saw them or not, later on come to you or advise you at any time that the car should be confiscated or crime scene should be called out because the car smelled?
I don't recall.
Sustain.
Now, after you actually didn't go confiscate the car until after Miss Anthony was arrested, correct?
Correct. I had already made arrangements with Mr. Anthony, and another detective went to take the car and items that were inside or had been inside the car.
So the process of how this all went down was you showed up that evening, the next day you met with Miss Anthony, you arrested Miss Anthony, and then you went and looked for the car or confiscated the car.
Not entirely correct. It was all one day. This all happened on the 16th. So when you're referring to the next day, it's all still the same day.
Okay, forget the days. But the sequence of events goes like that, correct?
That's correct.
And it wasn't until she was under arrest that you decided to look for evidence in that car.
That's correct.
And the reason you arrested Casey was because you thought she might harm herself.
The reason I arrested her was because she had the elements of the crimes what she was arrested for. Part of my determination on making an arrest, yes, I had already explained it and I testified to, that I was concerned that she may hurt herself. And this is based on my opinion on another case that was in the media at the time.
And because that other case from the media at the time ran through your head, this was what kind of facilitated you arresting her at that time.
Again, she had already fulfilled the elements of the crimes I arrested her for. So that's one of the thoughts I had at the time that I won't deny has helped me with the decision on whether to make a physical arrest or do another option. But yes.
And now after she was placed under arrest, the focus of the investigation focused heavily on the car then.
The focus of the investigation was always to find this missing child or kidnapped child. Yes, we did focus our investigation towards the car, but it wasn't the sole point at that point or at that time.
And as part of your investigation, obviously you wanted to do a thorough job.
Yes.
And that would include looking at every possible scenario.
Correct, but keeping in mind that we were going off of what we were told happened, and that included that this child was kidnapped by a known individual, and we had all these other names to go with it.
And you were also told by everyone in the home that the child went missing on June 9th, correct?
Initially, yes, they all said June 9th.
And that included George Anthony.
That's correct.
And that later on turned out not to be the correct date.
After a few days, we were able to find out that it was not the correct date, yes.
In fact, the correct date was June 16th.
Yes.
And you had in your possession at that time all of the knowledge of this nanny, Zanny the nanny.
I wouldn't say we had all the knowledge. We had what Ms. Anthony and the Anthony family had mentioned concerning the nanny or the kidnapper. But we still had yet to talk to friends and other people that she was associated with, including these outcry witnesses, to identify who this nanny was.
And shortly after the investigation, you were able to determine that the Zanny the nanny did not exist.
I wouldn't use the word shortly after. It took a while because we still had Ms. Anthony never changed her story about the nanny. In conversations that I monitored between communication to her and her family at the jail, she was still talking about the nanny. So I wouldn't use the word shortly. Ultimately, yes, we don't believe this nanny exists, but I can't tell you, I can't pinpoint a day that I made that determination beyond a reasonable doubt.
Now, you didn't have any prior contact with anybody in the Anthony family before July 15 or July 16, 2008?
Not to my knowledge, no.
You didn't know Casey Anthony, correct, prior to that date?
Correct.
You didn't know George Anthony?
Correct.
Or Cindy Anthony or Lee Anthony?
Yes.
And at that time, in July of 2008, you subpoenaed Casey Anthony's cell phone records.
I had asked another detective to do so, but yes, that was on my instruction.
And you could have also asked a detective to subpoena George Anthony's cell phone records, correct?
We ultimately did.
Okay. Do you recall which time period you asked for?
I cannot recall.
You have no idea what cell phone records you requested in this case from George Anthony?
I do, and I know that we were also working in conjunction with some investigators at the Metropolitan Bureau of Investigation, and they were assisting us with a lot of things to include getting cell phone orders, court orders on particular cell phones.
The reason you requested George Anthony's cell phone records was to exclude him from the searches that were done in March, correct? Searches on the home computer?
We subpoenaed his records multiple times. We also subpoenaed for June and July.
Really? And did you give these cell phone records to the prosecutors?
Yes.
And when did you do that, sir?
Trying to think now, you mentioned March. I'd have to look at the cell phone records to see which ones were subpoenaed. I do specifically remember the March ones. Perhaps I'm getting confused. I'm getting confused with the home phone records, so I apologize. I don't believe I subpoenaed George's cell phone.
Okay. So you only subpoenaed the home phone records for June and July 2008, but you never subpoenaed George Anthony's cell phone records for June and July 2008.
I don't recall, no.
Overruled at this point.
I don't recall.
Go ahead, Counsel.
I don't recall, sir.
And cell phone record could tell you not only what calls a person makes, but their text messages?
Yes, depending on the company, some cell phone companies retain the text information.
What other information can you get from a cell phone record? Can you tell the ladies and gentlemen of the jury that?
It'll tell you calls dialed, calls received, duration of phone calls, and on particular cell phone companies, it will tell you the towers that actually carried a particular phone call at a particular time.
And what significance would that have to an investigator?
I can speak for myself. It would tell me if a particular call was placed at a time, and I want to get a general area of where that phone was. It would tell me a general area of where the phone was when a call was made.
And it could assist you in tracking a person's movements,
I've
depending on the records?
I've used it for that, yes.
Okay. And you used that for Miss Anthony, did you not?
Yes.
In fact, you had them create an entire report on that.
What do you mean they?
The Metropolitan Bureau of Investigation had them do a month-long investigation as to the cell tower locations of Miss Anthony, where she went, and so on and so forth.
Well, we subpoenaed the records, which had that information. And at the beginning of this investigation, yes, the Metropolitan Bureau of Investigation did plug the towers in using latitudes and longitudes.
And you did not do that for George Anthony?
No.
You did not do that for Cindy Anthony?
No.
And you did not do that for Lee Anthony?
No.
The only person that you focused in on with the cell records was Casey Anthony?
At the time, yes.
At any time?
Yes.
Okay. So the entire 3 years that you've been investigating this case or had this case, you've never done that for anyone other than Casey Anthony?
That's not correct. There are other people that I've pulled cell phone records on, and I've looked at tower information to see where they were during particular times.
Who did you do that for?
Off the top of my head, I can think of one, and that was the person who actually called when they discovered the remains on December 11th.
Okay. Let's talk about that for a moment. You're talking about an individual by the name of Roy Kronk.
Yes.
Now,
Mr. Kronk.
Mr. Kronk on December 11th is the man who discovered the remains.
That's correct.
Okay. And upon him calling, call 911, correct?
Yes.
And
I don't know if he called it, but he called his communications. 911 was ultimately called.
That day, you immediately responded to Suburban Drive.
As soon as we were notified of the call, yes.
And when you got there, you interviewed Mr. Kronk.
Ultimately, yes.
Okay. And when you spoke to Mr. Kronk, you asked him what happened?
Generally speaking, yes.
And you asked him what he did?
Generally speaking, yes.
Okay. And you asked him if there was any other important information that he had for you regarding his activities?
Yes, this was all tape recorded in order to maintain the integrity of his conversation. So yes, it should all be on tape.
And he didn't tell you that he had called the police 4 months earlier, did he?
Objection, this is hearsay.
Sustained.
Question.
Judge, it's a negative. I'm not asking for a
That's
statement.
hearsay.
Were you made aware at any time, or when did you first become aware, I should ask you, of prior calls to 911 from Mr. Roy Kronk?
You may continue.
During the month of August 2008, sir, were you approached by a Detective Gerald White regarding a tip off of Suburban Drive?
Yes.
And did you inform Mr. Detective Gerald White that he did not need to follow up on that tip because that area had already been searched?
Sustained, rephrase the question.
What did you instruct Detective Gerald White in regards to that tip, sir?
Well, I recall the tip was very general, and we had already sent a cadaver dog, Deputy Forgy, in that general area. So I told him that the area had been searched.
And as a result of which, did you instruct him at that point not to follow up on that tip because that area had already been searched?
As a result of our conversation, yes, he did not follow up on the tip, and that was because he approached me and asked me about the tip. So I told him, yes, we already sent people to the area, so just mark it down and go to the next tip. We were getting hundreds of tips.
Okay. Now, the gentleman, Mr. Roy Kronk, you mentioned that you had gotten his phone records.
Yes.
What day or dates did you get his phone records for?
I can't recall off the top of my head. It would be on the subpoena when I made the request.
Okay. Do you have that with your case file?
I don't believe I have it now.
Okay. Did you ask, do you know if you asked him for, did you ask, excuse me, let me strike that question. Did you subpoena his phone records for 2 weeks, a month, 6 months?
Going on memory, I believe I subpoenaed it for June through December of 2008.
And did you turn over those cell phone records to the prosecuting attorney's office?
Yes, I would turn over all records I got on this case to the state attorney's office.
June through December. 2000.
I believe so. That was the date range.
Okay. And does these cell phone records include cell tower information?
Yes, I believe they do.
And did you have a report run for that cell tower information?
When you say report, when I make the request from the cell phone provider and they provide me the information, and when they provide it to me, I am able to actually get latitudes and longitudes based on their tower. So there's no report created aside from the one the phone company provides me.
Okay. Did you give that to the same person who prepared the report for Casey Anthony's cell tower movements?
Who prepared the report for her cell tower movements? I'm confused. Are you referring to, did I give this MBI?
Yes, I'm
No.
asking. Okay. Did you instruct someone to observe the movements of Mr. Kronk during that six-month period?
No, I used that information to answer questions I had about where the cell phone was at a particular time.
Okay. Now, subsequent to the remains being found, you were aware that there was duct tape found off of Suburban Drive.
I recall there were a lot of calls at the end of Suburban and in the dirt road towards the end.
You misunderstood my question.
I think I did, yes.
At the recovery site on December 11th, crime scene investigators recovered duct tape near the remains of Kaylee Anthony.
Yes.
And several months later, it was made public on a news report that there was video taken of duct tape at the command center where George Anthony was manning the command center.
Yes, I remember that.
Okay. So you discovered by looking at that video that it was the same brand of duct tape.
It proved to have the same markings as the duct tape we found on the scene, yes.
And these are the markings of the Henkel logo, which is the name of the brand of the duct tape.
Yes, that's correct.
This is somewhat unusual duct tape, right?
I had never seen personally duct tape with a stamp or logo on the non-adhesive side. So to me, it was unusual. I had never seen something like that.
And when did you go back and interview Mr. Anthony as to when and why he had duct tape that was found at the scene off Suburban Drive?
I did not.
So you have never gone back after finding out this evidence and interviewed Mr. Anthony as to where he got this duct tape from and what was going on with it?
Objection, asked and answered.
Sustained.
After this news report came out, you were also aware that the only piece of duct tape found at the Anthony home was found on this gas can, correct?
That had that Henkel marking, yes.
And 283, Your Honor. And as far as the evidence that you had relating to the duct tape, you knew you had duct tape near the remains of Kaylee Anthony, correct?
Yes, and on her remains as well.
Okay. And you knew that duct tape was found on this can?
Yes.
And you knew that there was no other duct tape anywhere in the house that was from the Henkel brand that matched the duct tape at the scene?
Yes, at the time of our search warrants, there was none.
And the only other piece of duct tape that you ever saw other than those two was the one on this video?
Yes, that I can recall, yes.
3 pieces, or 3 different locations, 3 different, well, I know there were multiple at the scene, but 3 different locations, 3 different sets of evidence, correct?
Yes, generally, yes.
And you were also aware that this gas can was reported on June 24th, 2008, as being stolen by George Anthony.
Sustained, Mr. Lee.
During the course of your investigation, did you investigate as to whether there were any police reports maybe reporting a gas can missing from the Anthony home?
Yes.
Did you determine that this was the gas can that was missing?
Yes.
And this was the gas can that ultimately had the duct tape on?
May I see the can?
Yes. May I proceed?
The tape has been removed. The tape is no longer on it. Or is it hidden under? It appears to be the same gas can on the photo. I don't see the tape on the can, though.
Are you looking at photo 107? States 107?
Exhibit 107, yes.
Now, during the course of your investigation, you actually interviewed Mr. Anthony on July 30th, 2008, correct?
I believe that was the date, yes.
Okay. And that was the first time that Mr. Anthony had informed you of some sort of a fight with Casey and this gas can.
Sustained.
Did Mr. Anthony at any time ever inform you that he had reported these gas cans missing? I'll withdraw the question, Judge. Was the very first time you had these gas cans collected August 1st, 2008?
I'd have to refer to the property form. I wasn't the one that went to collect them. I believe it was one of our crime scene investigators.
Would you have collected it immediately after? When? Why would you have gone and collected these gas cans?
Shortly after, Mr. Anthony would have told us that.
Sustained.
Without telling us what he told us, would you have waited a while after? How long would you have waited before collecting these gas cans after being informed of an incident?
That's a difficult question to answer of how long I would have waited. I can't recall specifically when he first told me of the cans. I can't recall, unless I see a property form, what date the cans were collected. It would have been within a reasonable time, I believe. I wouldn't have waited months, obviously.
Okay. But when you say reasonable amount of time, you mean days?
Yes, going by memory, I believe it would have been within days.
Maybe even 24 hours.
Again, without those two pieces of information, I hesitate to answer that.
Okay. Do you have that with your case file today?
I can check my report to see if it's in my actual report.
Go ahead, take a look.
Were you saying the gas cans were collected on August 1st?
Yes.
Reading the narrative of my report, I don't have anything on August 1st for the gas cans, so again, I would have to look at the property form just to confirm that that was it.
May I approach the witness judge?
You may.
Yes, ma'am. Yes, August 1st.
One final matter on, you said you got Mr. Cronk's cell phone records from June through December of 2008, correct?
Yes.
Did you also confiscate his computer?
No.
Could his computer have told you more information as to his activities within those 6 months? Do you confiscate computers during the courses of investigations?
As a general rule, yes, if I believe the computer can provide me information related to the crime committed.
Okay. And sometimes computers can tell you what emails are sent?
Yes.
Sometimes computers can tell you what internet sites someone's visiting?
Correct.
Maybe when they do Google Maps as to locations and things like that?
Yes.
Anything that actually a computer tells you quite a bit about someone's activities on the internet, do they not?
It tells you about the computer's activities, yes.
And what else did you do to investigate Mr. Roy Kronk?
What do you mean?
You said all you got was his phone records. Did you do anything else to investigate Mr. Roy Kronk or any of his actions?
We obtained statements from him. We obtained statements from his coworkers. Obviously, we've gotten his cell phone records as well for a period of time.
Okay. I have no further questions at this time.
Cross-examination.
Very briefly, Your Honor. Detective Melich, you referred to having been provided a tip by another detective by the name of Gerald White.
That's correct.
Okay. This is a coworker of yours, or at least was at the time, in the homicide unit.
Yes, correct.
You indicated that the tip itself was very general in nature. Did it mention Suburban Drive?
Yes, it did.
Did it mention the tip itself that you saw, did it mention a particular location on Suburban Drive?
Swampy area near a 6-foot fence or across from a 6-foot fence.
Now, you were familiar at that time, which was August of 2008, with the fact that Suburban Drive was near Hope Spring Drive, where the Anthonys resided, correct?
Yes.
And at that point, in August of 2008, Orange County Sheriff's Office efforts as it related to Suburban Drive dealt with the dead end where Suburban stops just short of woods, correct?
Yes, the far east side of Suburban Drive where it dead ends at the school.
This is Hidden Oaks Elementary?
Correct.
Okay. The site where Kaylee Anthony's remains were ultimately located would be between Hidden Oaks Elementary and the Anthony home, correct?
Yes, much closer to Hope Spring than it would be towards the dead end.
All right. So when you were responding initially, or at least ultimately, to the tip information that was given to you from Gerald White, you believed that the end of Suburban Drive had been searched,
Yes.
correct?
Correct.
And you had mentioned Jason Forgy and his cadaver dog. Did you have knowledge as to whether or not that was a location past the school, past the dead end, that the dog had been deployed?
Yes.
That's all the follow-up I want to do on the testimony.
Later, detective, be excused. You're excused, detective, subject to recall at a later time. Okay. Do we need a court report? Okay.
Okay, well, that's going to be it for testimony today. Let's see what we have on day 28. We can definitely get started. Get on to day 28.
Okay, let the record reflect that the defendant is present along with counsel for the defendant, assistant state attorney. Both sides ready to proceed.
Yes, sir.
Okay, on Saturday, the defense filed a motion to determine competency to proceed. Based upon that motion, the court ordered that the defendant to be examined by 3 psychologists to determine her competency to proceed. The court appointed 3 independent experts. The first expert the court appointed was Dr. Daniel Tressler. Dr. Tressler examined Ms. Anthony on late Saturday morning, Saturday afternoon. The court also appointed Dr. Harry McLaren out of Quincy, Florida. Dr. McLaren examined Ms. Anthony on Saturday evening and some on Sunday. The court also appointed Dr. Ryan Hall, who examined Ms. Anthony on Sunday. Both sides willing to stipulate that the court may utilize the reports that were submitted by the doctors in making a determination on the issue of competency to proceed. What says the state of Florida?
The state will stipulate, Your Honor.
And the defense?
No objections on that.
Now, has both sides had an opportunity to review the reports of the three experts in this area?
Yes, the defense has.
Based upon the reports that the court has reviewed, the court will find that the defendant is competent to continue to proceed. Those reports will be filed, but pursuant to law, those reports will remain under seal. The originals now will be filed with the clerk of the court. Okay, are there any other matters we need to take up prior to resuming testimony in this case? I think y'all have cleared up any matters dealing with Dr. Furden.
Yes, we have. There is, for the record, there is no issue.
Okay, Mr. Ashton?
That's correct.
Okay, the court will file into the record the motion to determine competency to proceed and the court's emergency orders appointing experts. Oh, can't be. All right, let's return to jury. Good morning, ladies and gentlemen of the jury. Did you heed all of my previous admonition during the recess? Does the state recognize the presence of the jury? And does the defense?
Yes, sir, we do.
The defense may call the next witness.
Your Honor, the defense calls Detective Yuri Melich.
My name is Yuri Melich, Y-U-R-I-M-E-L-I-C-H.
You may proceed.
Please support, Mr. Ring. Good morning, ladies and gentlemen. Good morning, Detective Melich.
Good morning, sir.
Sir, you were called on Friday afternoon to testify, and you misspoke, correct?
Yes, regarding some cell phone records.
Okay. Can you please clarify the issue that you misspoke about with the ladies and gentlemen of the jury?
In regards to cell phone records that I was questioned about on Friday, he asked me particularly about Roy Kronk. I was thinking of a different set of records when I answered that. As far as Roy Kronk is concerned, we did subpoena his records for June of 2008, June 1st to July 1st of 2008.
Now, the very first time that Mr. Kronk actually called law enforcement was until August 11th, 2008, was it?
In regards to this case, yes.
Okay. And there were several calls made in August 2008.
Sustained.
The time period in question for Mr. Kronk as to his involvement in this case begins in August and ends in December.
That's correct.
Okay. And he is the gentleman that found Kaylee Marie Anthony's body.
Yes.
And you did not seek phone records for any of those time periods from August to December 2008.
Correct.
And Mr. Kronk lives in a town called St. Cloud?
Yes.
Which is a significant distance from the area where Kaylee's remains were found.
That's correct.
And his work is off of Curry Ford?
Yes, in that area.
And that is a little bit of distance from the location where the remains are found.
A few miles, yes.
And the cell records, had you gotten them from August to December of 2008, would have been able to give you movement locations of that cell phone.
I'm not going to object and ask you to speculate as to the availability of the records and what they would show at this juncture.
Yes, they would give me movement of where the phone was.
And you would have been able to tell if August 14th, Mr. Kronk decided to go to that location, or if his cell phone was in that area.
What area are we referring to?
The area of Suburban Drive where Kaylee's remains were found.
It would tell me the area the cell phone was in, but also keeping in mind that there is a highway, a north-south highway between, or in that general area as well. So yes, it would give me a general area.
It would give you a general idea if he was in the vicinity, within a certain 3-mile radius, correct?
Give or take, yes.
And you could also find out if in September of 2008, when he did not have the route that included the area of Suburban Drive, if he happened to be there then.
I don't recall off the top of my head which times he had a route. I know August was one time. I know December was another. And I don't recall in the middle when he did or did not have that route. I don't think I can answer that.
Are you aware that if he had it in November?
I know he had it sometime between August and December, but I can't recall now when he had it. I'm not doubting he did. I just don't recall.
Understood. So you know on 1 month he had that route, but the other months he did not.
I'm going to object based on hearsay.
It's based on his investigation, Judge.
Sustained.
these cell phone records could give you information as to whether he was in the vicinity at times where his work schedule did not require him to be.
The cell tower records, again, will tell me what area a particular cell phone is at when it's transmitting or receiving a phone call. So to answer your question, yes, it would.
Okay. Now, is this the first case that you've given mistaken information to the jury?
Sustained.
Are there any other incidents where you misspoke to this jury?
Same objection.
I'm giving an opportunity to clarify any previous omissions or...
Overruled.
Not to my knowledge, no.
So as far as you know, the only time you misinformed this jury was Friday afternoon when we spoke of this topic.
You're suggesting that I intentionally misinformed the jury, and I did not. It was simply that you're asking me questions based on a 3-year investigation, a lot of cell phone records. I don't know what you're going to ask me. So in respect to Friday's testimony, yes, I did misspeak. And yes, I did give the wrong date range for the time I subpoenaed Roy Cron's cell phone.
Sir, I'm not suggesting anything. I'm just asking you simply if there's any other information that you gave this jury that was false.
Not that I can recall. Is there something that you wanted to bring up?
Well, now that you bring it up, let's talk about Mr. Anthony's cell phone records.
Yes.
You mentioned that you testified that you had George Anthony's cell phone records for June and July, did you not?
I can't recall what I testified to. I remember that there was a question of cell phone records that we had subpoenaed, and I wasn't sure if it was a home phone or cell phone. After leaving on Friday, I was able to verify, yes, we did have George Anthony's cell phone records, and we subpoenaed them back in 2008.
For what month?
I believe it was for the month of June and July of 2008.
Do you have those with you, sir?
I do not.
Okay. Do those include cell tower locations?
No, they do not. It's a PDF form, not a spreadsheet, so they do not have cell tower information.
Okay. And would that information have been useful to you as to being able to determine Mr. George Anthony's movement or his cell phone movement?
Yes, if I had a reason to even believe that that would play a part in this case, which at the time I did not.
Okay. Since then, have you decided at any time to go back and subpoena Mr. Anthony's cell phone records?
No, I don't recall issuing any more subpoenas for Mr. Anthony.
Okay. Now, you've subpoenaed quite a bit of other people's cell phone in this case, have you not?
When you say me, yes, in the course of the investigation, several were subpoenaed.
You're the guy, you're the coordinator of this investigation, kind of like a quarterback, right?
Yes, but to infer that I actually did the subpoenas, no, but during the course, several were subpoenaed, yes.
Right. And that would include Amy Heisinger?
Correct.
A friend of Casey's. Jesse Grund, an ex-boyfriend?
Yes.
Ricardo Morales, another ex-boyfriend of Casey's?
Correct.
Tony Lazaro, another ex-boyfriend of Casey's?
Yes.
Chris Stutz, a friend of Casey's?
Yes.
Diane Taylor, who is she?
It was referring to a number that was coming off of Casey's phone. At the beginning, we were trying to identify who Zanita Gonzalez was. So we subpoenaed several numbers from Casey's phone to try and identify who the people were. I believe that's one of the names that came back.
Okay, Stephanie Kostakis, that's a childhood friend of Casey's.
I don't know what the relationship is, but I do recall the name.
John Chat, roommate of Ricardo Morales.
Again, I recall the name. I can't recall the relationship.
Okay. Ronald Westenberger.
I recall the name, yes.
Troy Brown, another friend of Casey's.
Yes.
Jenna Prentice and a shot girl at Fusions.
One and the same person? Yes.
Jamie Relander, another friend of Casey's.
Again, yes.
Brittany Schreiber, another friend of Casey's.
Correct.
So you subpoenaed all of these phone records. You were able to get all this information, but you never got the information or the cell phone records of the person who found the body.
I had no reason to pull the cell phone records for that time. There was nothing to suggest I needed that.
Would the reason be that he did not tell you that he had called 4 months earlier on December 11th?
Object, he's eliciting information based on hearsay.
Sustained.
You, of course, find nothing suspicious with the circumstances surrounding the earlier calls in this case, do you?
Objection, calls for an opinion.
I'll withdraw the question, Judge. All right. You also testified that you never confiscated Mr. Cronk's computer.
Yes, I don't recall getting his computer.
Yet, do you recall doing a search warrant to get a computer belonging to a woman by the name of Joy Ray?
Yes, I do.
Overruled at this point.
You did?
Yes, I did.
And this is a woman who claimed to have taken photographs of the area off Suburban Drive?
Yes.
She also claimed to be a spy for George Bush?
That's correct.
She also had been Baker acted by your department, correct? Shortly after interviewing her, you Baker acted her?
I don't recall Baker acting her. I recall she was Baker acted a few times, but I don't believe any were from our agency, maybe an adjoining agency.
Okay. You identified her clearly as someone having mental health issues.
I hesitate to give my...
Sustained.
You got her computer, but you didn't try to get Mr. Cronk's computer.
I did, but there was a specific reason as to why I chose to get her computer.
Okay. And you also got Ricardo Morales' computer.
Yes.
And that's how you found out he was selling photographs to the Globe.
I recall that, yes.
Now, on December 13th, 2008, 2 days after Kaylee's remains were found, you received an email from a gentleman by the name of Joe Jordan, did you not?
I did receive an email from Mr. Jordan. I don't recall the date.
And this was giving you information as to the area, was he not?
Sustained.
Do you recall when you decided to turn that email over to either the prosecution or the defense?
Overruled at this point.
I don't recall.
Do you recall if it was a year and a half later?
May I see the email in question, sir?
Verdict.
Same objection, relevance as to turnover date.
Overruled at this point.
May I see the email that we're talking about?
While that's being brought up, sir, was this email only turned over after the defense had found Mr. Jordan?
I'd like to see the email first.
Okay. Do you have any knowledge of whether that email was turned over only after the defense found Mr. Jordan?
Before answering any one email, I'd like to see the email, please.
Sure. While that's being retrieved, what you got? May I approach the witness, Your Honor?
You may.
If we could have the exhibit marked for the record.
I can have one printed.
Okay.
I'm just trying to speed it up. I can show them.
Give them an identification number, just for the record, Madam Clerk, and we'll print it up. All right.
Pardon me, while I read it. Sure. Okay.
Does that refresh your recollection?
Yes, sir, I recall that.
Okay. And my question to you, sir, was, did you only turn this email over after the defense had found Mr. Jordan?
I don't recall when the email was turned over, sir.
And do you know, or can you recall as to whether it was in the normal course of discovery or a significant time period?
Objections been asked and answered by the witness.
Sustained.
I'll withdraw the question, Judge. Now, sir, you conducted in December of 2000, after December 11th of 2008, you conducted 2 search warrants on the Anthony home, correct?
One on December 11th and then a subsequent one, yes.
Okay. And in the first search, you of course had some knowledge of what was found off of Suburban Drive. What items, correct?
That's correct.
And that would include any items having to do with the Winnie the Pooh blanket?
Yes, I believe that was included in that first search warrant, yes.
Okay. And then on December 20th, you exercised, let me stop there. As part of your regulations, you have to leave a copy of not only what you confiscate, but a copy of the search warrant at the residence, right?
Yes, a copy of what we took and a copy of the search warrant, not the affidavit.
And did you do that on December 11th?
Yes.
Okay. And then on the 20th, well, let me go back for a second. On that search warrant of December 11th, 2011, it would have indicated that, of course, you were looking for any items having to do with Winnie the Pooh, correct? Any bedding material?
It should all be listed inside the body of the search warrant.
And then also, if you confiscated any from the home, it would have been there.
It should be, yes.
Okay. So on December 20th, when you went back, did you share anything having to do with your investigation with the Anthonys?
I don't recall what we spoke to the Anthonys about when we went next to the search warrant.
Is it normal for a detective to share information that's not made public yet with people that you're at home where you're exercising a search warrant?
In general, it's not abnormal to share information with victims of crimes that may not be public, especially in homicide. But I don't recall specifically sharing any information with them that I don't think I understand your question. I don't recall the conversation in detail with the Anthonys on the day of the search warrant.
I'm not saying you did. I'm asking you if you did.
I don't recall.
The investigation was confidential at that point, was it not?
It was an ongoing investigation. To say it was confidential, everything subject to the public at one point. I don't understand your question, sir.
Did you disclose any items that you found off Suburban Drive with the Anthonys? Did you tell them, we found this, we found that, we found this?
I don't recall any specific conversation. Not to say I didn't have a conversation. I don't recall the specifics of the conversation with the Anthonys regarding what we had found on scene.
Can you think of a scenario where you would have told the Anthonys things that you found at the scene?
Again, I don't recall the conversation, and I won't speculate on what I could have said if I don't remember saying anything.
Okay. And of course, you would have documented on your police report what transpired during that search warrant, correct?
It's very general what I document on the police report as far as conversations, unless it's directly pertinent to what I'm doing. Light conversation, like hi, or what time is it, and stuff like that, I wouldn't necessarily put in a report unless it was pertinent.
Now, did you deploy a cadaver dog on the other 2 cars at the Anthony home?
No, I don't believe I did.
At any time through July 15th through today, have you ever deployed a cadaver dog on George Anthony's car?
No.
What about Cindy Anthony's car?
No.
Did the issue ever come up that Casey may have driven Cindy Anthony's car at one point?
I remember during the course of the investigation that did come up, yes.
And that came up from George Anthony?
Yes, I believe so.
And did you later find out that that was not true?
We weren't able to determine it occurred based on EPAS records. So, yeah, we don't believe it happened in that time frame that he originally thought it may have.
You requested the EPAS records from Mr. George Anthony, did you not?
I remember getting them from EPAS. I don't recall if we actually made the request to him or if we just went through EPAS.
Okay. Did you not request them and him not turn them over to you? It's not. You had to actually go and subpoena them from EPAS yourself.
I recall getting the records from EPAS. It's the most reliable place to get the records anyway.
And the EPAS records indicated to you that...
Sustained.
I'll withdraw that. Now, did you ever deploy a cadaver dog in the Anthony home?
I don't recall ever doing so, no.
You had 2 cadaver dogs out there July 17, 2008, did you not?
I believe 2 were there. I don't know if they're both at the same day. I wasn't present during most of the search during that time frame at the Anthony home.
At any time, did you ever request that cadaver dogs go through the home to see if they picked up on any scent?
No.
May I have first witness?
You may.
I'd like to show you Defense Exhibit EZ.
That was easy.
Would this make it easier for you to explain to the ladies and gentlemen of the jury the location of both the Anthony home and where the remains are found?
I could use it to explain it to them, yes. I don't know what the abandoned house is on top, though.
I'm not going to ask you to talk about that.
Okay.
Okay. Now, does that appear to you to be a fair and accurate representation of both the Anthony residence and location of Suburban Drive where Katie's remains are found?
Yes, I had no objection with the generalization. Obviously, GPS coordinates and all that would be accurate, but the general area is correct, yes.
Okay. Your Honor, I'd like to conditionally admit this, excluding the portion, of course, of the abandoned house, which I've been finding here.
Any objection?
If I may look at the photo to see.
May.
Subject to our discussion, no objection.
Okay, it will be conditionally admitted as defense exhibit number. Witness may stand down.
Can everyone see that okay, or should I bring it closer? Detective Melich, can you circle the...
Just a little bit so the prosecution can see it. Yep. If you just take it back just a little bit, Mr. Baez. Thank you, sir.
Detective Melich, can you please circle the general area where Kaylee's remains were found and initial that? Okay. And can you please circle the area of where the Anthony home is? Initial? Yes, please. Okay. That's all. That's all. I can have just a moment. I'll see if I have any other questions. Go ahead. Now, Detective Melich, Casey Anthony was arrested on July 16, 2008, correct?
That's correct.
And she was out on bond for a short period during late August and all the way through October, correct?
I don't recall the dates she actually went in and out, but generally I'll accept that.
About a month, so a little over a month.
I won't dispute that at this time.
Okay. And she was subject to electronic monitoring during that time period, right?
Yes.
Okay. And basically house arrest?
Yes, that's correct.
Okay. And there were, throughout that period of time, give or take 5 or 10 media trucks outside her home throughout the time?
I can't testify to how many were outside the house. I know that there were at several times, probably throughout the time.
Okay. And the only time she was permitted to go anywhere was, of course, to check in with the jail and her attorney's office, correct?
To the best of my recollection, yes.
And wherever she went, the media followed?
I can't attest to that. I can't answer that.
Fair statement to make, though?
I wasn't there. I don't know if they followed her every time or not.
Okay. I have no further questions. Oh, if I can have one moment, please. And since the indictment of October 14, 2008, Casey's been in jail?
Yes.
No further questions.
Cross-examination.
Thank you, Your Honor. Good morning. Detective Melich.
Good morning.
The email that was referenced as your having received on December 13th of 2008, at that point in time, it was 36 to 48 hours after the remains of Kaylee Anthony were found, correct?
Yes.
The Orange County Sheriff's Office, suffice it to say, was extraordinarily busy with the recovery effort at that point in time, correct?
Yes, that is correct.
The Orange County Sheriff's Office had also been receiving hundreds, if not thousands, of emails or tips or other information, relevant or not, that you, as the lead investigator in conjunction with other people, had to wade through at that time. Correct?
Yes, that is correct.
At any point in time, did you receive a report that the car of George Anthony smelled like there had been a dead body in it?
No.
At any point in time, did you receive a report that the car belonging to Cindy Anthony had the smell of a dead body in it?
No.
The phone records that you subpoenaed or had other investigators working with you subpoena from Amy Huizenga or Jesse Grund, Ricardo Morales, Tony Lazaro, all of those individuals, did they also focus on that time frame of June and July of 2008?
Yes.
This was the critical time frame when Kaylee Anthony was last seen and then ultimately reported by her grandmother to be missing, correct?
Yes.
Miss Anthony, Casey Anthony's phone records were initially subpoenaed for that same time frame, correct? June 1st through July 15th, correct?
Yes.
In an effort to determine where she was during any specific date during the time period where Kaylee Anthony was last seen and when she was finally reported missing by her grandmother.
Yes.
And in subpoenaing those records, initially your effort was based on the information given to you by Ms. Anthony regarding this babysitter, Zenaida Gonzalez, correct?
Yes, that's correct.
Information that was subsequently determined to be false.
Regarding the babysitter, yes.
And in an effort to find this babysitter or any reference or contact or possible third-party connection, these individuals' records were subpoenaed as well as Ms. Anthony's, correct?
Yes.
And even doing all that, you were unable to locate not only Zenaida Gonzalez, but some of these other names that Ms. Anthony gave you as individuals who had some information about Kaylee's whereabouts. Juliet Lewis, another Jeffrey Hopkins besides the one that we heard from in this case.
And to include Raquel Farrell, yes.
People who, according to Ms. Anthony, had some connection to this babysitter.
Yes.
That's all I want to clarify.
Redirect as to those issues.
I know you told Ms. Drain-Burdick that you were pretty busy and, with the recovery off of Suburban Drive, but this individual claimed to have information as to that location, did he not, in that email?
Sustained.
This was asked by Ms. Drain-Burdick, Judge.
Sustained.
this person had information for you.
Same question, Mr. Banks.
This is not, Mr. Jordan was not a new person to you, correct? In fact, you had gotten information from him before?
I recall communication with Mr. Jordan. I believe most of it was through email. I don't know if there was any face-to-face at any point in time. I don't recall.
He was helping you out, giving you information, putting you in contact with people, was he not?
A lot of people were trying to help us out and trying to do things and trying to tell us how to do our job and trying to tell us where to look. So he was one of many people who was doing that.
But you actually took some of his information and used it, did you not?
I don't recall what specific information I took.
Do you recall him giving you blogs that were posted from Cindy Anthony's brother?
I recall somebody had mentioned Cindy Anthony's brother's on a blog. I don't recall who mentioned it. It may have been, it may not have been.
You don't recollect that he's the one that gave you the blogs?
No, I don't recall.
And do you recall that he's the one that helped put you in contact with Cindy Anthony's brother?
I don't recall that.
Do you recall Cindy Anthony's brother's the one that told you about all of this wedding, what happened at his wedding?
Sustain.
Now, you heard Mr. Burdick said that you hadn't gotten any information about Cindy or George's car smelling, correct?
Correct.
Did you get any information as to whether they had trash in their trunk for 3 weeks?
No.
Neither car?
I never had any reason to ask, no.
Detective Melich, you were present when Deputy Forgy, the canine handler, did the actual inspection of the car, were you not?
On July 16th or 17th? Yes, I was.
Okay. I'd like to show you Defense Exhibit EM, if I may approach the witness.
You may.
Sir, please take a look at that drawing. Are you familiar with that drawing?
Yes, I am.
Okay. And is that a drawing that you drew at a previous hearing in this case?
That's correct.
Can you put the date into the record?
The date of the drawing is March 23rd, 2011.
Okay. And does that drawing depict a fair and accurate representation of what you testified to on that day?
Yes.
Okay. And there you were drawing, what exactly? Can you tell ladies and gentlemen of the jury that you're drawing?
Well, I can't recall the instructions at the time, but generally speaking, I guess it was what I recalled of the date. The Deputy Forgy was called out, his cadaver dog, to inspect Ms. Anthony's car.
Correct. And what you drew there was the forensics bay garage?
Yes.
And also Ms. Anthony's car?
Yes.
And on that drawing, you, of course, just put one car that Deputy Forgy had inspected, correct?
Yes, after the fact, you asked me to put a second car in there, but for the purpose of Ms. Anthony's car, there was only one car drawn at the time.
Okay. And you also testified that when Deputy Forgy deployed his dog, it was only on Ms. Anthony's car.
Sustain.
Was there only one car that he deployed his dog on that you recall?
Yes, that I could recall, yes.
Okay. Judge, at this time, I would move item EM into evidence.
What says the state?
I have no objection to the drawing.
Be received evidence, the state's numbered.
I have no further questions for Detective Melich.
Any recross? Okay, detective, you may be excused, subject to recall.
Thank you, sir.
The defense may call their next witness.
Defense calls Michael Vincent.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am. Michael Vincent, V-I-N-C-E-N-T.
You may proceed.
Thank you, Your Honor. Good morning, sir.
Good morning, sir.
May I approach the witness, Your Honor?
May.
Mr. Vincent, I'd like you to look at Defense Exhibit EJ for a moment. Is that a drawing that you drew at an earlier hearing in this case?
Yes, sir.
And is that a drawing of the forensics bay garage and Miss Anthony's car?
Correct.
And did you testify that there was only one car that was deployed by Deputy Forgy?
Yes.
At this time, Judge, I would move that item into evidence. I believe it's EM.
What says the state? If you received an evidence, it's defense exhibit numbered.
I have no further questions.
Cross-examination.
Thank you, sir.
May Detective Vincent be excused, or is he subject to recall? You may be excused, subject to recall, sir. Who's the defense next witness?
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Good morning. Geraldo Bloise, B-L-O-I-S-E.
Good morning, Mr. Bloise.
Good morning, Counsel.
Your Honor, may I approach the witness?
You may.
Mr. Bloise, I'd like to show you Defense Exhibit EL. Is that a drawing that you testified to at an earlier hearing in March of this case?
Yes.
Okay. And that's of this year, March of this year.
Yes.
And does it show a drawing of the forensics bay and Miss Anthony's car?
Correct.
And did you testify that there was only one car that the canine cadaver dog handler deployed his dog on?
Correct.
I have no further questions. Oh, actually, let's take that back. Is that a fair and accurate representation of what you drew that day?
Yes.
Judge, at this time, I would move that item in evidence.
What says the state? Be received in evidence as defense exhibit number.
I have no further questions for Ms. Blake.
Cross-examination.
Investigator Bloise, is it fair to say that the focus of your investigation on that day in July was Ms. Anthony's white Pontiac Sunfire?
Correct.
And this is what you were paying attention to and documenting for the Orange County Sheriff?
Yes.
Thank you.
Mr. Bloise, as a crime scene investigator, your job is to focus on the details, are you not?
Yes.
In fact, down to the very minute details.
Yes.
No further questions.
May the witness be excused. All right. Sir, you may be excused, subject to recall.
Thank you.
Okay, ladies and gentlemen of the jury, we're going to take a 15-minute recess at this time. Please remember all of my previous admonitions. In the additional instructions on behalf of the state or the defense, we'll be in recess for 15 minutes. State recognized presence of jury. Defense?
Yes, sir, we do.
All right, the defense may call the next witness.
Deputy Jason Forgy.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Sir.
Forgy, Jasonr, Forgey.
Thank you, Your Honor. May I approach the witness?
May.
Deputy Forgy, I'd like to show you a drawing labeled Defense Exhibit EK. Take a look at this here.
Stuck. Yes, sir.
Is that a drawing that you drew?
Yes, sir.
And that was in testimony in a prior hearing in this case on March 24th, 2011?
I believe that's the date. 3/24, 2011.
And what that depicts is the forensics bay garage and Miss Anthony's vehicle and another vehicle?
Correct.
Okay.
It's a rough drawing, not to scale, like I said in the hearing.
And do you show, or did you testify that there were two cars in which you deployed your dog, Garris?
Correct.
And did you testify that the other car is someone else's car? It's unknown to you whose car that was?
Correct.
And did you testify it was a blue car?
I said I believe it was a blue car.
Did you get it? I'm sorry. Go ahead.
That was my quote. I believe it was a blue car.
Okay. Did you testify, or do you know what the license plate number is or who that car belongs to?
Absolutely not.
It was just somebody's car that was there?
Correct.
And when you began deploying your dog, you started with that unknown car?
Correct.
And you knew that the white Pontiac Sunfire was Miss Anthony's car?
I knew it was a car in question. I didn't know whose car it was.
Okay. Is there anyone that can corroborate that a second car was there?
Sustained.
Were there any witnesses that saw you deploy your dog on this car?
Yes.
Okay.
Who else saw you deploy your dog on these two cars?
My canine supervisor at the time, which was Mike Carden, was my corporal.
Who else?
I never say his name correctly. The forensic tech, Geraldo.
Bloise?
I believe so.
Okay. Who else?
I believe Mike Vinson was there also, but I'm not sure.
Who else?
That's all I recall.
And is this the first time you've ever mentioned, either in deposition, hearings, or in court, of your supervisor being present?
No, sir. I mentioned it in deposition. I mentioned it whenever you asked me.
Okay. And did he fill out a report?
No.
Okay.
It's not common practice.
So the individuals that you just mentioned are the ones who can corroborate that you actually deployed your dog on two cars as opposed to one?
The ones that I recall that were there, yes, sir.
And the reason you do two cars is so that way the dog doesn't falsely alert because it wants to please you. That's one of the reasons why.
It could be, but the reason you do it in training is for that. But this was a real search. And I did it. There was no real reason behind it.
There's no reason why you deployed your dog on this other car who you do not know who it belongs to.
I just wanted to make sure his mindset was correctly. Okay. That's it. Just start working him, running around another vehicle. Just make sure his mindset's settled in, calm, and go right to my car in question.
And it has nothing to do with your training, which tells you you should have multiple cars. That way it would prevent handler bias.
Training is different than a real world scenario, because a real world scenario, you're not going to have, generally, you're not going to have the opportunity to have a second vehicle there. In training, of course, you can do that. I believe that's why I did it this time, because it happened to be there. In that lot, there's a lot of vehicles out there, but this is the only ones that we were questioning. But in that lot, I mean, there's trailers, there's cars, there's all kinds of stuff. But in the real world, you don't have the opportunity to set it up that way. It just happened to be there.
You could have had them drive this car to where the other cars were parked, right?
I had them move it outside the bay. Could I have done it? I don't know.
Orange County was in possession of this car.
Correct.
And you could have asked, just like you asked them to take it out of the garage, you could have asked them to put it near other cars.
But it was.
My question to you is, you could have asked them to put it near where all the other cars were at.
It's next to another vehicle when it came outside the bay. Could I have moved it to the front of the lot? I don't know. It's evidence. So I don't know. I've never run into that.
Could you have asked them to move the car to where there were several cars there?
It's possible.
But you didn't?
No.
No further questions.
You may.
What's the number of the letters on the back of that one?
EK? K, kilo.
EK is evidence.
Be received in evidence as defense number cross-examination.
Deputy Forgy, regardless of whether or not there was 1, 2, or 200 cars, you still knew that the white Pontiac Sunfire was the car in question, correct?
Yes, ma'am.
That's all I wanted to ask.
Okay, may the deputy be excused, subject to recall.
Yes, subject to recall.
Thank you, Deputy Ford.
Thank you, sir.
The defense may call in next witness.
Dr. Kenneth Burke. Dr. Kenneth Burke.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you for the
My name is Dr. Kenneth G. Furton, F-U-R-T-O-N.
You may proceed.
Thank you, Your Honor. Good morning, Dr. Furton. Good morning. Can you tell the ladies and gentlemen of the jury what your profession is? Yes, I'm a professor in the Department of Chemistry and Biochemistry at Florida International University. I am also the Director Emeritus of the International Forensic Research Institute and the Dean of the College of Arts and Sciences at FIU. And how long have you been employed there? For 23 years. And can you share with us your educational background? Yes, I have a bachelor's degree in forensic science, a PhD in analytical chemistry. I then completed postdoctoral studies in the United Kingdom for 2 years in nuclear science. And for the last 23 years, I've been on faculty at FIU in Miami. And what is your area of expertise? I focus on area of chemistry dealing with separating, identifying, and quantifying complex mixtures of chemicals. And for the last 18 years, I focused on studying the chemicals that are given off by forensic specimens in order to be able to see how canines locate forensic specimens, as well as how machines can be developed to either complement or replace biological detectors. And the opportunity to study human decomposition and chemical breakdown. Oh, yes, I have. Can you share with the ladies and gentlemen of the jury what your experience is in that area? Yes, since about 2003, my research group has been looking at the volatile chemicals that are given off by live humans as well as human remains, with the idea of trying to identify individuals, live individuals, and also try to locate the human remains based on the characteristic chemicals that are given off after a person is deceased. And have you published any peer-review articles in the area of human decomposition? Yes, I have. How many? We have I have a master's student and a PhD student who published their thesis and dissertation. And then we have two peer-reviewed journal articles, one in 2003 and one in 2011. How does that work when you have students that have published work? Do you have any involvement in that? Yes, the way it works is I directly supervise the students' research, so they have to develop a certain level of independence of their own projects. But I also join them in some cases in the lab, and I actually just came back early from a week-long field trip with several graduate students out in California doing research on human scent. Now, have you also received any grants in the area to study the area of human decomposition from our government? Well, we've got several different grants that fund my research lab. Most of my research funding last 8 years related to human scent has been focused on live human scent. But we've also done human remains research as well in the laboratory. And have you lectured in this area? Yes, I give extensive lectures around the country and around the world in a variety of areas related to detection technologies, instrumental and biological, and many of those have been related to the location of human remains. Are there any instruments that are used to analyze these chemicals? There are instruments that are used to generally analyze volatile organic compounds from any kind of a forensic specimen. There's currently no instrument specifically designed for identifying human remains. Okay. And have you ever testified as an expert witness in the area of human decomposition or forensic chemistry?
Objection. Compound question.
I'll rephrase it, Judge.
Rephrase it.
Have you ever testified as an expert witness in the area of human decomposition? Not before this particular trial. Okay. And have you ever testified as an expert witness in forensic chemistry? Yes, I've testified over 24 times in a variety of different areas related to DUI, presumptive drug testing, and also identifying volatiles associated with detecting forensic specimens. Do you have any patents that you are the holder of? Yes. How many? Just one at the moment. Okay. And what is that for? It's a patent which is the identification of humans based on the volatile organic compounds that they give off. Okay. And do you belong to any professional organizations? Yes, I do. What are they? I'm a member of the American Chemical Society. I was including being a past president of the South Florida section of the American Chemical Society. I'm also a fellow of the American Academy of Forensic Sciences. Okay. And where have you testified previously in a court of law? I testified in a variety of situations, including grand jury hearings and civil court proceedings, criminal proceedings, both on behalf of the prosecution and the defense. Have you received numerous awards and honors from law enforcement due to your contribution?
Objection. Not with qualification.
Sustained, Mr. Lord.
Judge, at this time, I would move to have Dr. Furton admitted as an expert in human decomposition and that of forensic chemistry.
I have no objection to forensic chemistry. I would like to rely on the position.
You may proceed.
Doctor, your work in the study of human decomposition is from the perspective of what a human remains detection dog would alert to. In other words, your studies began in studying the training aids and the chemical composition of those. Is that correct?
That's correct.
And in fact, until very recently, let me start over. When we say your studies, we actually mean your students' studies, correct?
They're the studies that are done completed under my direction.
Right, but by your students as the primary researchers.
By my students as well as myself.
And up until just recently, that study did not deal with studying the decomposition of whole human cadavers. It was decomposition of training aids used by dogs, correct?
Yes, the one master student worked on training aids, which would be human remains components, and then the most recent PhD student worked with whole human remains.
Right. Other than that, other than studying the compounds given off by training aids and then in one study by actual human corpses, do you have any other expertise in human decomposition other than that area? In other words, human decomposition is a very broad subject matter. Do you have expertise in stages of decomposition, bloat versus fat, that area?
Well, just in as it relates to how we look at the volatiles associated with human decomposition, because different stages of decomposition can give different volatile organic compounds. And as a forensic scientist and teaching forensic chemistry, involved in the general knowledge of human decomposition as it relates to my research.
I don't have any objection to being qualified in the limited area of human decomposition related to volatile organic compounds that are given off, not the entire area of human decomposition. If that's acceptable to counsel, I have no objection.
Because we're not going to inquire as to the different stages or things like that. It will be on the chemical analysis of human decomposition.
Dr. Ferdinand will be accepted as expert witness in the area of chemistry and human decomposition in terms of the odor analysis. Is that what you're tendering to me?
Yes, sir.
Okay, you'll be accepted. You may continue.
Now, Dr. Furton, you mentioned you just got back from California.
Yes.
Okay. And we're kind of taking you out of turn because of your schedule.
Yes.
Okay. Now, can you tell us what items you received and reviewed in this case?
Yes, I received all the records related to the investigation, including the autopsy reports, the photographs of the contents of the trunk, the expert witness report from the preliminary and final reports from Oak Ridge National Laboratory, all of the depositions and other documents related to the experts, the canine experts, as well as the chemists and the other investigators related to the case.
Okay. Were you asked to specifically look at the work done by the Oak Ridge National Laboratories?
Yes, I was.
And did you review the preliminary reports as well as the final report?
Yes, I did.
Did you also review the report issued by Dr. Sigmund?
Yes, I did.
Okay. And he is from the National Center of Forensic Sciences?
That's correct.
Okay. Was Dr. Sigmund's report the first report issued in this case as it relates to a chemical analysis?
Objection to hearsay.
Overruled at this point.
I believe that was the first report, the first chemical analysis that was done of the contents of the trunk.
And then after Dr. Sigmund's report was completed, a month later, the first preliminary report came out from Dr. Voss?
Yes.
Okay. Now, did you put together a, well, let me ask you this. Have you also reviewed numerous studies or all different studies having to do with the study of human decomposition?
Yes, I have.
Okay. And do you have an opinion as to whether there is a unique signature of chemical compounds that could tell you if it is human decomposition?
Yes, I do.
And what is that opinion? Can you tell the ladies and gentlemen of the jury?
Yeah, well, it's based on the research that we've conducted over the last 8 years and all of the peer-reviewed literature that I've been able to review, as well as including our studies. It's my expert opinion that there's currently no instrumental method that's been scientifically validated to the level that it could be used to identify the presence or absence of human remains based on the chemical residues that are present.
Okay. Have you prepared a PowerPoint presentation that would assist you in explaining to the jury this incredibly complex and boring area of forensic science?
Yes, I have.
Okay. Would that assist them in as a demonstrative aid?
I hope so. Yeah.
Okay. Judge, at this time, we'd like to connect the Dr. Furton's computer to be able to show these PowerPoint presentation.
I don't have an objection. Do we have a copy to have marked to make sure we have a record of exactly what we're showing?
Absolutely.
It's been offered as a demonstrative aid. Mr. Bias, is it being offered only as a demonstrative aid?
Yes, sir.
Okay. You will be permitted to show it to the jury.
May I publish to both the witness and the jury, Your Honor?
You may.
And F8. Okay, you want to go ahead and start your slide? Okay. What are we looking at here, Doctor?
This is animation showing how the instrument works, in which the gas chromatograph actually separates all those individual chemicals in a complex mixture into the individual components. It's a little cut off on my screen, but you can see the what's called the chromatogram. Each of those peaks is a.
Let me take it one step at a time. This box here, that's the GCMS that everybody's been talking about.
Yes, that's correct.
Okay, and that stands for gas chromatograph mass spectrometer, right?
Yes.
Okay. Now, where do you insert the samples? You can touch your screen, by the way.
Oh, okay, yeah. So the samples are actually injected here with a either a syringe if you were to take just an air sample and inject it, or there may be other types of injection devices that are used, but the sample is placed in at the beginning of that instrument.
Okay, and then it goes through this machine, and it comes out with a written report called a chromatogram.
Yes. If is the bottom cut off on yours? Should I change the resolution?
I think that's what the problem is. Yeah.
Take one.
We're gonna get a kid to help you out.
Yeah, which okay. Yes.
Okay, it's published.
Okay.
Okay, so yeah, so as you were saying, those chemicals pass through the gas chromatograph, and then based on the size of the molecules, the smaller molecules move more quickly than the larger molecules. So hopefully in the end, you wind up in this chromatogram is you get a separation of all the chemicals, although many times you'll get compounds that are very close to one another, so you have to run calibration standards. And ultimately you identify the chemical by this what's called the mass spectrum. It's essentially a molecular fingerprint. So the molecule is fragmented, breaks into that mass spectrum, and use that along with retention time with known standards to get the identity of whatever chemicals in the mixture.
Let me stop you there. What do you mean by known standards? What does that mean?
It's you buy standards from a chemical company which have a confirmed identity, and you run those on your instrument, and you confirm where the peaks come out in terms of retention time and how the mass spectrum looks on your instrument, because that's the only way you can be certain of the identity of a chemical.
So you buy chemicals from a company that says this is definitely this chemical. You insert it in, and you can compare it to what your results are.
Correct.
And this chromatogram, does it tell you how much of a specific chemical is there?
No, it doesn't. It only gives you you can get an idea of relative abundances. So based on the different sizes of the peaks, that can give you an estimation of the relative amount. So a peak here, which is smaller than this one, will give you an idea of relative ratios. But ultimately, you need to run what's called a calibration curve, in which you inject those standards that you purchase. You run them on the instrument at different concentrations, and then when you inject your sample, you make sure that your sample has the same peak area response that's within your calibration curves. That's the only way you can do what's called quantification, or determine the exact amount of the chemical.
So unless you do this, you don't know how much of a specific chemical is there, right?
That's correct.
And all this will tell you is that a specific chemical is there and how much it compares from one chemical to another.
Sustain, Mr. Lee.
What will this tell you, sir?
That would just give you an indication of the approximate relative ratios of the chemicals, but not the absolute amount in terms of total number of molecules or grams or a concentration unit.
And when you say relative, you're referring to one chemical versus another?
Right, within the same run.
Okay. All right. What's the next slide you got?
Okay, so what we've done is I apologize, it's a very busy slide, but what we've done is run, if you take each of those peaks, the different chemical of each a peak has a different color, and I put it in a bar graph form. So F7 here is one person, female 7. Oops, sorry. And then we put her relative ratio of compounds in one run. And when you do that, this is 5 females and 5 males compared, looking at the relative ratios of characteristic compounds. These are 24 primary odor compounds that we have identified from living humans. When we do that, and we've developed a database and looked at background chemicals, we can discriminate the individuals with over 99% discrimination ability using a 0.9 threshold by a technique called Spearman rank correlation.
All right, let me stop you there because you're starting to lose. Okay. These are all people that are living.
Yes.
Okay, and this is kind of like you're identifying what kind of chemicals their bodies give off?
Yes, you can kind of think of it as like a human barcode in terms of the chemicals that the living person gives off.
Okay. So all of these lines here represent a different person.
That's correct.
Okay. And from what you're seeing here, there are different chemicals for different people that they give off.
Yeah, so if you just visually look at those 10 barcodes for 10 individuals, you can see that each person has a unique pattern of chemicals.
Okay. So everybody's different.
Yes.
All right. Got that. All right. Is there anything else other on this?
No, just that, and then we, by doing enough analyses, you have to assert some level of confidence to the measurement, and so we've applied a variety of different statistical methods, and I won't bore you with all the different techniques, but the one that's very simple to explain is the Spearman rank correlation. You just look at the most abundant to the least abundant. It essentially gives a number associated with each one, so it's almost like a barcode. It's very simple and easy to apply, but we've done other statistical methods in order to determine how reliable the method is in terms of being able to differentiate individuals.
So what you were able to do is, correct me if I'm wrong, if I'm understanding this right, is you're able to see which ones are common across the board with everyone and put that as the most important chemical, and then go down the line, or go from top to bottom, I should say.
Yes, it's a combination of the common chemicals and the relative abundance of those, as well as some unique chemicals that individuals give off.
Okay, let's take a look at the next slide.
So if you compare those bar graphs, on the left are 7 living individuals, and you can again see essentially those human barcodes are all very different. And then these are 6 deceased individuals. These are 3 that were taken at a Morgan, 3 at a crematorium. And you can see that deceased individuals look more similar to each other than living individuals. And so the idea is to try to look at what are the most important chemicals that are associated with human decomposition in order to be able to use those chemicals as a tool for locating human remains.
Okay, let's go to the next. What are we looking at here?
So this is a table that I put together that shows the 20 most abundant chemicals. So we saw this in 20 the majority of the samples that were taken from the morgue, 21 individuals at a morgue and 6 individuals at a crematorium, deceased individuals. And the idea is to try to look at what are the chemicals that are most common, most abundant and most common, and then compare them at different locations in order to try to get to these characteristic compounds that can be used for locating human remains.
Okay. And so this right here lets you put an X next to which ones were found common in both of these locations?
Yes.
And if there's nothing there, they were not in both?
That's right.
Okay. All right, the next slide.
We've also done this for other decomposing animals. So this is just an example showing these are actual decomposing canines. These are portions of tuna, chicken, lamb, pork, and beef. So they're not the whole animal, but portions of the animal. And then these are the actual whole human deceased individuals.
So what is this telling us here?
It's again, the idea is to try to identify what are compounds that are coming from non-human decompositional events, because those compounds would not be specific for human decomposition, and you would either have to exclude them as part of your statistical method or be cautious in terms of how you develop a method that would give you a measure of the error rate of your method.
Is there some overlap? Chemicals that are found in both?
Yes, there's quite a bit of overlap between decomposing organic matter, including decomposing animal remains.
Okay. Let's go to the next.
I also have a larger table that I put together that
assist you in explaining the
yes.
history?
Witness, please stand down.
Yeah, so this is, sorry, give me a microphone. Okay.
I have a unit, so we're going to go
What is he looking at?
He is looking at defense exhibit EW for demonstrative purposes.
Okay.
Okay, so I want to first, if you will, explain us what's going on here, because this is really looking kind of busy.
Yeah.
I'm sorry, I can't see either. I don't know if there's a different position.
Is that still visible? Is that better?
That's better. Okay. Yes, I apologize for, again, I know busy tables put people to sleep right away, but the idea is there's a lot of information, so I figured it'd be easier to point it out to you in a table format. So when you're separating all these complex chemicals, if you go to a very sensitive level, you'll find thousands of compounds. And if you refine it and look at higher concentration, you'll get hundreds of compounds. And the idea is to refine that down to hopefully a handful of compounds or dozens of compounds that could be used to be characteristic for human remains. So this just illustrates these are different functional groups, which are different kinds of chemicals. And so I've just...
Let me stop you so I can try and break this down. What you've done is you've classified certain chemicals into categories?
Yes, just as a chemist, it's easier sometimes to look at these acids and esters and alcohols and halogens. It's just different ways.
Slow down, doctor.
Yes, slow down. Yes, Your Honor. So to a chemist, the different types of chemicals can have different sources, which is also another important thing to look at. So these blue are the characteristics of acids and esters, alcohols, halogenated compounds, and so forth, as a way to start to refine and compare the list. So this is a comparison of 8 different studies that have been done related to human remains, just to give a snapshot of the kinds of similarities or differences between the studies.
Let me stop you there. When you say reference, are these the different studies that you've assigned numbers to?
Yes, that's right.
Okay, so you're saying there's 8 different studies dealing with human decomposition?
Yeah, in this particular table, we list 8. I have another paper, a paper which was published this past week from a graduate student's dissertation. But
that's not in here.
That's not in here. This table actually comes from that paper.
Okay.
Summary of that paper.
All right, and there's 8, but I see a number 10 here. What is that?
Oh, yeah, I think these were the references that came out of the publication, so it's not necessarily in 1 through 8.
All right, and do you include the papers done by Dr. Voss?
Yes, I did.
Okay, and that is what's highlighted in yellow?
Correct.
Okay, so is this a breakdown of what Dr. Voss finds versus what other people find?
Objection under case, Your Honor. Approach the management explain.
Yes. Okay, rephrase the question.
Yes, sir. Now, Dr. Furton, the methodologies from all of these different studies are different, are they not?
Yes. Some are similar, but many of the studies are very different.
And basically, they have bodies, they study decomposing bodies at different stages.
Yes.
As well as different locations. Some are buried, some are above ground.
Correct.
And this is what appears to be a table of all of those different studies and the chemicals that they found based on their methodologies.
That's right.
Okay, I just wanted to clear that up. And so what are we looking at here?
Okay, so the idea is that when you're trying to locate human remains, which could either be a whole body or a portion of an individual, we're looking at what are the chemicals that are given off by a deceased individual or portions of a deceased individual. And there are various groups around the world who are working in this area, including my research group. And the idea is in order to reach a scientific consensus, is to work towards some idea of what are the most important chemicals that could be used in order to reliably locate human remains. And so this is a summary based on just a portion of all of the compounds that have been presented to try to get to certain compounds. For example, you'll see toluene, where when you have the majority of studies have identified toluene, or the sulfides, disulfides, trisulfides, you see the majority of the studies agree. That indicates, not necessarily with certainty, but it indicates that those could be important compounds to be included in a database for identifying humans.
Now, just so we have the numbers right, Dr. Voss's studies, his 2 papers would be 6 and 7.
That's correct.
Okay. And we've heard a lot about this guy, the Greek, I don't want to butcher his name, Stratheropoulos.
Stratheropoulos, yes.
Okay. And he's from Greece.
Yes.
And he's number 4. Is that correct?
Yes, number 4 and 5.
Okay. And what, if anything, can we learn from this chart that you have here?
Objection. General question may be a case violation.
I'll rephrase that.
Rephrase.
Now, what are these percentages?
I just illustrated of the 8 studies, the percentage of agreement. So if most of the percentages were above 50%, that would indicate general agreement amongst the different research groups around the world studying the volatiles associated with human decomposition. And you'll see that generally the numbers are well below 50. In some cases are only about a quarter, about 25%, which means there's more disagreement than there is agreement at the moment between the different studies that have been completed.
And that takes into account also that there are different methodologies,
yes.
Different studies. Okay, so the only ones that are above what you consider the 50% threshold are 2, 4 chemicals?
Yeah, at least in this, for this summary chart, those 4 chemicals give you an idea of some compounds that there seems to be some general agreement amongst, which are the cyclic hydrocarbons, the toluene, paraxylene, and the sulfides, dimethyl disulfide and dimethyl. Yes, sorry, toluene and paraxylene, as well as the sulfides, dimethyl disulfide and dimethyl trisulfide.
Okay. Did you want to explain anything else here, or did you prefer to go back to your
PowerPoint? I think that is sufficient.
Okay. Yeah, I'll take that from you. Okay, let's go to the next slide. Now, what are we looking at here?
Well, this just is a photograph that was provided to me of contents from the trunk after they had been removed and I believe inventoried and laid out on a table. Just to give some examples of, there are, in addition to comparing living persons to deceased animals, the idea is also to look at what could be decompositional events from food products or volatiles that could be given off by consumer products that could be similar to things that are given off by decomposing humans. It's just,
all right, let me stop you there. And we've heard some stuff about these fatty acids, okay? And did you read that these fatty acids were found on certain items like the paper towels?
Yes, that was in the report by Dr. Voss.
Okay. And where can you find these 4 fatty acids? And what kind of items can you find them in?
They're really everywhere. They're at least related to fatty materials. I show example here. They're present in milk fat or milk lipids. So milk products would also have them, cheeses and so forth. And they're the same compounds that are found in humans. So body fat, particularly when a person begins to decompose, the body fat can hydrolyze and produce these same fatty acids. And the ratios will change over time as well. But the same chemicals are seen in human fat as well as animal fat products.
And the chemical compounds dealing with sodium, calcium, magnesium, and iron, where can you find those?
Similarly, they're found in many, in fact, most products that we consume. So example I just show here is milk. So these are the elements that are in our body because we drink milk or other other liquids or food materials that contain these elements.
Okay. So are these, do you have an opinion as to whether these fatty acids are unique to human decomposition?
They're certainly not unique to human decomposition. And that's one of the reasons that the science there's not a sufficiently reliable scientific method to be able to identify the presence or absence of human remains, because you would have to know what all of the background chemicals are and the ratios of the various different chemicals in order to determine a statistical significance to a finding when you do a measurement.
And what about these chemicals? Are they unique to human decomposition?
No, they're not.
All right, do you have another slide?
Just another one. There are other, just a couple of examples, because of the one was milk products. This would be pork and beef, common kind of food items that we would consume. There was hard salami, a wrapper for hard salami present. Just gives an example. They would also contain the same fatty acids, the same elements that were reported in the report by Dr. Voss.
Okay. Any other? The next slide, or is that your?
No, that's it.
Okay. Now, in looking at the now, actually, let me ask you about chloroform. Did you see a quantitative analysis done by Oak Ridge National Laboratories?
No, I did not.
Okay. Explain to us why it's important to do a quantitative versus a qualitative analysis. Yes, sir.
It's the original slide I showed you with the separation of the chemicals and then doing a calibration curve. That's the only way you can actually know the concentration of the chemicals that are present in a substance, and then you would compare that to the concentration that you would find in, say, consumer products or other decompositional events, human or non-human, in order to get some measure of the importance of the match. You would need to know the concentration.
Where can you find chloroform?
It's pretty much everywhere. It's a very common chemical in very low quantities. It can be very high in certain products, certain consumer products such as bleach.
I believe it counts for a moment.
You may continue.
Dr. Furton, you were saying that you can find chloroform in cleaning products. And
Yes, yes. It's one of the it's seen in many different products, and depending on the concentration level, including even drinking water. But in consumer products, one of the products where you see a very large amount of chloroform as well as carbon tetrachloride is household bleach, and there have been studies showing that it can be produced at very high levels.
Can you give the jury some examples of other products that you can find that contain chloroform?
Yes, it's a little scary when you think about it, because the World Health Organization has generated reports and done surveys of what compound, what.
The World Health Organization studies are the ones that we spoke about.
Tell us what you can find. Just answer the question.
Yeah, okay. It's found in everything from drinking water to household foods, things like cheeses and even soft drinks.
I'm going to approach. I have an objection, and I need to show you.
Okay.
Cover this area.
Approach the sidewalk. Okay, ladies and gentlemen of the jury, the time is now approximately 11:59. We're going to recess for lunch. We're going to start back at 1:45 for you. There's a matter we have to take up at 1:30. That should give you enough time to take care of your lunch, and there's an appointment I think one of you has at noon. So that should give everyone sufficient time to do what they need to do. Members of the jury, you may be excused for lunch. We'll bring you back at 1:45. The rest of you at 1:30. You have that cite with you, Mr. Ashton?
Lynn versus Counsel, found at 946, 732, have to do with the ability of an expert to testify in hearsay as the basis of his opinion. That case involved hearsay as far as statements of other consulting experts, and I believe the principle would lie. I'll have more to come back.
Okay, we'll be in recess to 1:30. Okay, let the record reflect that the defendant is present along with counsel for the defendant, assistant state attorneys. Okay, both sides ready to proceed?
Yes, sir.
Yes, with a proper matter.
The court's ruled. We're in a proper line of questioning. I'm not interested in pre-trying my case for the prosecutor to have another look. This has been going on far too often, and I think the court has ruled in our favor. And of course, if the court instructs me to do so, I will do so. But it would certainly be over our objection.
Well, I don't necessarily think we need a proffer, but if you read the case that Mr. Ashton cited, as long as the doctor has given his opinions, would be.
On direct. Anything about whether was.
I'm not going to require proffer entirely. I'm not going to require if
this interpretation, as by experts in the renders in the field.
What ran in our household is of a that's where you can talk about it. Jury, you can't. Okay, both sides are ready to proceed.
Are we proceeding with proffer or proceeding to the jury?
Do the short proffer.
Okay.
The basis of his knowledge.
You understand I'm not requiring you to proffer?
Absolutely.
Okay.
I just want to avoid any further delays.
All right.
Dr. Furton, can you explain to us the basis of your knowledge on chloroform?
Based on general knowledge of volatile toxic chemicals such as chloroform being present.
And would that be through your education and experience?
Yes.
Okay. And have you, even prior to this case, relied on scientific journals and treatises to gain knowledge on chloroform, where it's found, and as far as levels are concerned as well?
Yes, I have.
Okay. And at the Fry hearing, you testified from a report. What report, or a study, I should say? What study is that exactly?
I refer to the World Health Organization has reports on toxic chemicals in the environment and in households, and so I refer to the World Health Organization report on chloroform, which lists essentially it's a thorough review of the documents and peer-reviewed articles that refer to chloroform in various environments.
And how many times have you had chloroform show up on samples as you've been since? I'm sorry, let me strike that. How long have you been using a gas chromatograph mass spectrometer?
About 25 years.
And in those 25 years, have you frequently had chloroform come up as a chemical in some of the samples you've done, both environmental and other types of samples?
I don't recall the exact number, but we've used chloroform as a solvent, and we've also seen chloroform in mixtures.
Now, just prior to your getting ready to testify, did you do further research to identify more specific items that you could find chloroform in?
Yes, because in the that World Health Organization report, there were There were some consumer products that weren't listed in there, and that's why I did internet searches to see what other references were out there related to consumer products in chloroform.
And these internet searches, were they of legitimate scientific journals and articles?
They it varied. Some I did through Google Scholar. So there are very some came up as journal articles, some came up as websites where analyses had been reported for different consumer products.
And are these sources reasonably relied upon for forensic chemists to assist them in rendering their decision or opinions?
It would depend on the source. So in some cases, if there isn't a peer-reviewed study published, then I would use the information with caution.
Now, you've been instructed not to refer to those findings that you've had in your most recent internet research. Is that correct?
Yes.
And the opinions that you were about to render and that you will render, provided the court permits, have nothing to do with these recent internet research that you've done, correct?
Correct.
No further questions.
Mr. Ashton?
Doctor, have you ever done any research into the presence or levels of chloroform in household products?
No, I haven't.
Is everything you know about which household products contain chloroform and to what extent all based on what you've read from various sources?
Yes. Well, my knowledge and experience as a analytical chemist and the journal articles and government reports that I've read, yes.
Well, if you have never done any research in the presence of chloroform, what experience are you talking about, other than reading?
As an expert in the field of analytical chemistry, that's my life, is separating, identifying, quantifying mixtures in chloroform is like one of many chemicals.
I understand that.
Yeah.
The specific question is your testimony about its presence in common household products and the amount. That is completely based on what you've read, correct? It's not based on any tests you've done.
As are my opinions related to the studies done by Voss and others. Yes, they're based on peer-reviewed journal articles or government reports.
I just wanted to make sure we understood this. Your Honor, if you want me to argue them.
Go ahead.
The witness can give an opinion. The difficulty is that Lynn indicates that he's not permitted to announce to the jury the hearsay upon which it's based. So I have no objection to him expressing some opinion, but for him to regurgitate to the jury what he's read, either in preparation for this case or in the past, is a violation of Lynn. Lynn indicates that a witness may not be used as a conduit for hearsay information. If the defense wants the jury to believe that a particular cleaning product is a possible source of chloroform, then they need to present that to the jury in a manner that can be cross-examined, not by someone saying, I read it somewhere. The opinion still comes in. And if I choose to challenge the basis of that opinion, then it may become admissible. But at this point, the defense, according to Lynn, cannot have this witness testify in direct examination and regurgitate the inadmissible part of his opinion. And if I may quote Mr. Mason's friend, Professor Earhart, just a moment, sorry. Let me see, where was the quote? Of the points. When that
he's a chemist and then chemists get. I heard my expert's opinion and based on.
Anything else, folks?
No, I think the court understands my argument.
It's simply
examined.
Well, exactly.
We're ready, Judge.
All right, we're ready.
State recognized presence of jury.
Yes, sir.
Defense.
Yes, sir, we do.
Good afternoon, ladies and gentlemen of the jury. Did you heed all of my previous admonitions? You may continue.
Thank you, Your Honor. I'll make please the court. Mr. Ashton. Good afternoon, ladies and gentlemen. Good afternoon, Doctor.
Good afternoon.
Dr. Ferguson, where we left off, you were explaining to the jury what types of products that you can commonly find chloroform in. Can you explain to them the different array of products?
Lynn, statement of fact.
Overruled.
The most common place you find chloroform is when chlorine reacts with organic compounds. So when you household bleach contains chloroform because of the reaction of the very strong sodium hypochlorite reacting with organic compounds, usually fragrances or things that might be in the bleach.
Can you speak a little closer to the microphone?
Sorry. Yes. And so and chloroform itself is a non-polar compound, so it tends to be a higher concentration in non-polar things, which would be fatty type of materials. So you see it in things like butter, oils, cheese, things of that nature.
Okay. And you also said you can find it in water?
Yes, because chlorinated drinking water, because there are organic compounds in drinking water when it's chlorinated, chloroform is formed.
Now, the gas chromatograph mass spectrometer, would it pick up chloroform levels in water?
Oh, yes.
Okay. Would it pick up other chemicals that are commonly found in water?
Yes.
As well as cleaning products and everything else, pretty much.
Yeah, any of these we call volatile or these low molecular weight organic compounds would be detected. Volatile organic compounds.
Now, do you have an opinion after looking at the 5 chemical compounds that Dr. Voss found in this case as to whether those chemical compounds are the makeup of human decomposition?
Yes, I do.
And can you share with the ladies and gentlemen of the jury what those opinions are?
Yeah, it's my opinion that using that those 5 compounds are not unique to human decomposition, because 2 of the compounds, chloroform and carbon tetrachloride, are found in household products such as bleach, and the methyl sulfides, the 3 methyl sulfides, or the dimethyl sulfide and the other 2 methyl sulfides, have been reported in decomposing organic matter. It doesn't even have to be another animal, but they've been reported in urban waste trash bins, for example. So they're known not to be unique for human decomposition.
And are there studies that have shown that these organic compounds can be found in trash?
Sustain.
And do you have any other opinions based on those 5, or is that pretty much the sum of it?
Yeah, that's pretty much the sum of it, that we know those 5 are not unique to human decomposition, so cannot be relied upon to make that conclusion. I have no further questions.
Cross-examination.
Good
afternoon.
Have you ever examined the spare tire cover that was tested by Oak Ridge National Laboratory?
Move to strike.
That's it?
Yes, sir.
Overruled on that basis.
Let me show you why.
It's also beyond the scope, Judge.
Response as beyond the scope?
Well, I haven't asked the question yet. The question I'm going to ask has to do with bleach.
Okay. Overruled at this point.
You see State's Exhibit 139.
Yes.
David, you would accept the first of my question that this is the spare tire cover that was, portion of which was tested by the Oak Ridge National Laboratory. All right? See any bleach stains on that?
Not that are apparent to me.
It's a whole big, the portion that was,
Overruled.
Judge, basically, the question you just asked them, there's a missing part of
Overruled.
The chemical reactions that you're referring to that could coincidentally create chloroform don't happen in a vacuum. They don't create just chloroform, do they?
Organic compounds, correct.
Particularly the reaction between bleach or the active ingredient bleach and organic compounds creates more than just chloroform. It creates other compounds, correct?
Yes, in fact, carbon tetrachloride is more abundant than chloroform.
Pardon me?
Carbon tetrachloride is even more abundant than chloroform in things like bleach.
Bleach, right. But you would expect that if bleach were spilled upon a dark fabric surface, that the dark fabric surface would reflect some evidence of bleach having been spilled on it, wouldn't you?
Overruled.
If the source of the bleach was being placed directly on the carpet, then yes.
All right. Now, but even in that circumstance, there would be other chemical signatures to show that that reaction had occurred between the active ingredient bleach and organic components. Some specific bromides, I think, were discussed earlier in this trial. Is that correct? Are you familiar with that?
During my testimony?
No. Are you familiar with the other chemicals that are created by the accidental, the process that creates chloroform through the contact between chlorine and organic material creates more than just chlorine? What are the other things it creates?
I know that it can create other things. I don't know of anybody who's done a peer-reviewed study on that, and it wasn't in any of the reports I was asked to review.
So you don't have any idea whether that coincidental reaction that you suggested would have left other indicia that are not in this case, that weren't found. Did you understand my question? That may have been inartfully done.
Yes, no, I understand it. It may have, but that would need to be researched and published in order to use that as part of an analysis.
Did you research to determine whether there are articles in peer-reviewed publications that discuss that accidental creation of chloroform and what else is created?
There were no articles that I came across in my research or that I was made aware of.
Did you find an article in an Iranian journal that discussed that coincidental creation of chloroform?
And
do you recall that?
No, I never had an Iranian. I would think I would remember an Iranian.
So your research in this area only went as far as that. Yes, it can be accidentally created, but not deeper into what else might be created, so we could determine whether it actually happened or not.
No, the fact that there's so many things that can happen is exactly why I have the opinion that I have, which is that this is an ongoing research study that needs to be analyzed in order to make those determinations. One journal article in an Iranian journal wouldn't be sufficient to be relied upon to make a conclusion in a forensic case.
But how many articles are you relying upon in telling this jury that chloroform can be accidentally created through the combination of chlorine and organic compounds? How many articles are you relying on for that you tell this jury?
Well, I just gave one. I have one example article that I put in my report just to give as an example, but there are many, many other sources of chloroform.
And what did that article say about the other compounds that are created by this coincidental creation of chloroform?
I don't recall. As I said, I'm not involved in. I wasn't trying to come up with an interpretation of a particular outcome. The idea was to illustrate that chloroform and carbon tetrachloride were relied upon as 2 of the 5 compounds to determine that there's a human origin, but we know that they can come from non-human sources.
So you weren't trying to figure out where they actually came from. You were just trying to see if there was some other explanation that you could come up with.
No, I was trying to see where they came from, which is that they did not. And also the reason we compared to other studies is whether they came from a human origin or whether they could come from a consumer origin. But I'm not saying they had to come from bleach. I'm saying there are any number of potential sources that the chloroform could come from. That was one example.
Exactly. And each one of those sources, chloroform comes with something else. Correct?
With everything comes with something else. That's what.
And so in determining whether any particular appearance of chloroform is due to one of those sources, all you have to do is look to see if those other things are also there.
Yeah, that was not done in this study, in this report. That's exactly my point.
And you didn't do it either.
No, because I have the opinion that it's not possible at this moment. It's ongoing research. That would be later on once compounds are identified. If chloroform were a characteristic compound for human decomposition, then that would be very important to do to see what levels it is relative to things that could be from non-human decomposition.
But as far as whether the chloroform in this case came from someone mixing chloroform and deliberately administering it to a child versus it being created by some accidental reaction, you didn't really go too far into figuring out which one it was. Would that be fair to say?
That's correct.
The same thing with its presence in butter or cheese. There are other things that should have been found. Let me withdraw the question. Isn't chloroform a carcinogen?
Yes, it is.
And it's in butter and cheese?
Yes, like I said, if you start looking at what toxic chemicals are present in the environment, it can be a little bit scary because they are present at various levels in many common compounds.
In very, very, very small amounts, correct? In the parts per billion range.
Typically, a part per billion or low part per million in some cases.
In what substances does it appear in a low parts per million range?
It would typically be the more fatty materials like cheeses or butters, although some pasta products have also been reported to have high levels.
In low parts per million range?
Yes.
Is there an FDA limit on how much chloroform can be in a product, a food product?
Yes.
What's that limit?
I don't recall the limit off the top of my head.
Is it in the parts per billion range?
Yes, it's in the low level.
Okay. And in water, it appears in drinking water. You're talking about?
Yes, in low levels.
In the parts per billion range.
Correct. And sometimes even lower.
Now, let's talk for a moment about some of your PowerPoints. Can we pull up that PowerPoint again? And go through it. I'll have to defer to counsel on that. I don't recall what the
Madam Clerk?
I don't think so.
FB.
Okay, so let's move on to keep going. Just make sure this is okay. Keep going, please. Next, I'll go back. Okay, this slide. This is slide number 3.
It's
Is it slide 3?
Excuse me. Yes, slide 3.
If I may publish this slide to the jury.
You may.
Now, you described this slide as a. Oops, we just lost it.
Oh, sorry, I put it in the. I think it's going in the presentation mode.
There we go. You described this slide as a comparison between the variations of the odor signatures of living human beings and dead ones. That'd be correct.
That'd be correct.
So basically, what this tells us is that we all smell much more alike when we're dead than when we're alive.
That's correct.
Okay. So this would tend to indicate that, at least potentially, there is some similarity in the odor of human decomposition among all people. Wouldn't that seem to indicate that?
Yes.
Okay. But your point is we haven't yet found that unique set of compounds or percentages of compounds that are unique to human beings. That's your point, correct?
Yes, the compounds and the significance in terms of error rates.
All right. And once jurisdiction, I'll publish that. Go on to another one. Can I go to the next slide? Yes, this is the slide 4. I'll publish this if I may. Now, the interesting thing about this study is your student performed this study for a paper that was just published this year, correct?
Yes, I completed the study with my student did this under my direction.
Right. But your student's the one that actually went to the morgue and got the samples and analyzed them and all that kind of thing, correct?
That's correct.
Now, what she did was she went to the morgue for the 21 bodies and took a device called a scent transfer unit. This is a device, I think you said it's not to make light of it because it's a serious device, but it still looks like a dustbuster. Sucks air in through a certain filtering material which seeks to collect the organic compounds for later analysis or examination by dog, correct?
Correct. The instrument is used by law enforcement agencies across the country for collecting human scent. We are applying it for a comparison of live human scent to human remains scent.
Now, the particular collection medium that you use for this device is actually inferior to the triple sorbent trap. It's not as good a collection device, correct?
I guess, yeah, that would be an accurate statement.
So the triple sorbent trap is likely to collect a great deal more compounds and a variety of compounds than the filtering device that's used for this study, correct?
I'd have to speculate, but it typically, depending on the concentration, if you went to lower concentration levels, you would probably collect similar compounds, but the triple sorbent trap would tend to collect a larger amount of the chemicals.
It's more likely to get compounds that appear only in small amounts, correct?
That's accurate, yes.
Now, in this circumstance, your student that collected these items, basically, the way she did it was she basically held the device over basically the midsection of the corpse for about a minute, allowed air to come through the device, and then sampled the filtering device to see what compounds were found, correct?
Yeah, she sampled over the entire body for a period of 1 minute, which is the 1 minute is the same sampling time that is used by law enforcement agencies to sample live human odor. Now, she did not, though, take control samples of the morgue where she examined the bodies, correct? No, she did do some samplings away from the body, but there are background when you're dealing with as you can imagine, a morgue or a crematorium, there are compounds associated with human decomposition that are going to be ubiquitous.
That are just going to be there all the time?
Yes.
Okay. So this wasn't done out in a natural environment, either on the ground or anything like that, correct?
That's correct.
Right. And in fact, there was a number of compounds that were found, according to this, in every body in the morgue, but sometimes in one or no bodies in the crematorium, correct?
Yes.
Wouldn't that tend to indicate that those might more likely be background rather than something coming off the body?
That's a possibility.
But she didn't really correct for that in this chart, correct?
No, that's correct. This is ongoing research.
Okay. I think there may be one more I want to go to. Would you go to the next slide?
Next.
Okay. Yeah, we'll just speak about this one for a moment. This particular study, just so the jury's clear, the tuna, chicken, lamb, those are testing of meats processed for human consumption, correct?
Yes, they're the meats from the animal.
But I mean, it wasn't a freshly slaughtered. It was basically she went to a restaurant and got rotted food of various things or got from Publix and then tested it that way. It's processed, correct?
Well, yeah, it's unprepared. It wasn't cooked, but yes, unprepared and then allowed to decompose.
Okay. But this does actually demonstrate a great deal of consistency among human decomposition and a great difference from those animal sources. That's what this chart would seem to indicate, correct?
Yes, and that was the point of the study, is to try to look at compounds that would be not only common amongst humans, but different between humans and other species.
And it would seem to indicate that there's a great deal of difference between human and non-human decomposition odors, at least from that chart.
Yes, there does appear to do that.
Next slide, please. Let's go one more. One more.
I think that was it, maybe?
I wanted the one that's on the big chart, but I know you have it on a slide.
Oh, I have a thing at the end.
Where was that? Just there it is. Now, let me publish that if I may. Now, you testified on direct that each one of these studies was slightly different, and I'm going to talk about the differences. Which one of the studies that you cite from the literature was the most longitudinal? Longitudinal, in other words, covered a decomposition from a variety of times.
That would be the reference 6 and 7, the Voss studies, which were buried, I believe 4 buried bodies in each study.
Okay. So Dr. Voss's study is the only one that looked at a longitudinal look at decomposition. All the other studies looked at particular points in time. Is that correct?
It would, in terms of whole bodies, that would be correct. Yes.
Correct. All right, we're going to get to the partial bodies in just a minute. How many of these studies use triple sorbent traps, which we said was the more robust method of collection?
Well, I don't know if that was a more robust method. It's a common method used for environmental sampling.
Whichever, okay, whatever you want to use. Which one of these used that method?
I believe those are the Stathopoulos and the Voss articles.
So those are the two papers that use the triple sorbent trap technique.
I believe so, yes.
Is that the best technique to use in obtaining the maximum variety of compounds, even very minute amounts?
Proper bolstering?
It's one method. I don't know that it's the best method. It's a commonly used method, so that it is.
Now, of all of these studies that you cite, how many of them involved decomposition odors from whole body as opposed to parts?
From the ones that are listed here, it would be those same 4.
So Stathopoulos and Voss are the only ones on this list that actually look at entire human bodies.
Yes, I believe that's correct.
So the Hoffman, Caldwell, Lorenzo, and Tolliver studies were all studies of things typically used for canine training aids. Portions, correct.
Yeah, there'd be portions of a decomposing body at different stages of decomposition.
Like blood?
Yes.
What else?
Blood, usually adipose tissue, bone, oftentimes early stage decomposition materials, and people will use like placenta or some other human-derived material that's not of the whole body, but that is at a different stage of decomposition.
And this study bears out that those studies that look at decomposition of the entire body find more variation of compounds than those studies that only look at specific parts. Isn't that true?
No, I don't believe that's true. I think when you look at the total list, there are many compounds in most of the studies, and they don't necessarily correlate based on whether it's whole body or body parts.
So you haven't found from the study that Dr. Stathopoulos and Dr. Voss's studies generally found a wider variety of compounds than the other studies that did not look at the entire human body?
Well, I think they find a larger number of total compounds, likely because they were utilizing the triple sorbent trap, as I mentioned, which tends to collect more higher concentration of compounds.
So the fact that a large number of these compounds were only found in Dr. Voss's work may be because Dr. Voss is the only one that looked at longitudinal decomposition and used triple sorbent traps. Isn't that right?
Proper bolstering.
Doesn't that make sense?
I don't believe so, because Stathopoulos also used triple sorbent trap and didn't see the same compounds.
But did Stathopoulos look at a longitudinal decomposition process? He looked at 1 day, right?
Correct.
Stathopoulos sampled his corpses 1 day.
Correct.
Not over 4 years.
Correct. But generally speaking, when a person decomposes and you see people become more similar in terms of compounds they produce, it doesn't change from day to day. You get a consistency, which is what's happening when you move from a live human to human remains.
Don't you agree that the compounds emanated from decomposition change over time based upon the stage of decomposition?
Oh yes, you'd see the ratios of compounds can change, and some the identity of compounds can change as the decomposition process proceeds.
And of course, of all these studies, how many of these studies look at anaerobic decomposition, that is decomposition in an oxygen limited or deprived environment?
I believe only in terms of bodies, it would be the Voss studies where he had actually buried his subjects.
So the fact that Dr. Voss found a large number of compounds that other studies did not may be attributed to the fact that he was looking in a different way. Isn't that most probable?
I couldn't say that that's most probable. There's but it could be that a body buried deep could produce some compounds that aren't produced from a body that's say, at the surface. That's a possibility.
But you.
Okay, everybody. Well, it is already after 5. It's 5:10. There's another couple hours left to day 28, so we're going to have to cut it at some point, and this witness goes on for a little bit longer, much longer. So we're going to have to continue with this tomorrow. That is the plan. So we are getting through this. It's day 28. I think there's only 32 days in the trial, and then there's closing argument. So tomorrow, the way that we're going, we should get the closing by the end of this week, because we are getting through days of trial very quickly. So very interesting stuff today, and we will see you all tomorrow. Thank you all for joining us, coming to the end of this trial. Thank you very much. We will see you all next time. Before you leave, make sure to hit the subscribe button, hit the like button, and have a wonderful evening. Take care all.